Ladies and gentlemen, when the judge comes in, I'm gonna ask you guys to write yourself, all right? So stand up, and, she'll let you know. She's done it already. All right.
Thank you. You may be seated. All right, good morning. This is Commissioner Elizabeth Campbell, and I am Commissioner Campbell, and this is the 8 a.m. initial appearance calendar for April 15th, 2025. The court's orders for the taking of DNA and fingerprints that were given on the first calendar of this month shall apply to all matters on this calendar. Persons appearing today are reminded that they have the right to remain silent and that anything they say could be used against them. Most of you have qualified for a court-appointed attorney. If you have not, or even if you have, you can retain an attorney at your own expense. I will be calling you up individually on each of your matters. At the conclusion of your hearing, I will be asking that you step to the left, and the officer will have your paperwork for you, which will have all of the written information for you about my orders today. We're going to go ahead and start with Michael Squires, and then we are, is he down at the bottom? Hold on. Oh, somebody. Yes. And then we are going to move to Jonathan Valdez. Good morning, sir.
Morning.
All right, go ahead, state your name for the record, please.
Michael Ryan Squires, date of birth 8/30/98.
Thank you, and you are here today on two matters. Your first matter is following your arrest yesterday on charges of narcotic drug possession, a Class 4 felony, and possession of drug paraphernalia, a Class 6 felony. I did find probable cause for both of those violations. In this new matter, I am appointing you an attorney, and I'm setting 3 hearings in your new matter. The first one is on April 21st at 8:30 a.m. The second one is on April 22nd at 1:30 p.m. And the third one is on April 24th at 8:30 a.m. Because these new violations were committed while you were on felony release in another matter, I am holding you non-bondable in this new case. In addition to your new case, you also have a bench warrant out for your arrest for failure to appear in your case 2025-111299. You should already have had an attorney appointed for you in your existing case, and I'm setting 2 hearings in that case. The first one is April 21st at 8:30, and the second one is April 24th at 8:30, both in the downtown Maricopa County Superior Court. I am setting a secured appearance bond in the failure to appear case in the amount of $250. However, as I mentioned, I am holding you non-bondable today in your new case. So go ahead, step
So
one.
Even if I pay that bond for the failure appeal, I won't get out?
Nope, because you're non-bondable. All right, Jonathan Valdez, and then Ethel Lee Welliver.
Good morning.
Mr. Valdez, good morning. Go ahead, state your name for the record.
Jonathan Gaitan Valdez,
And Mr. Valdez, what is your date of birth?
December 19, 2006.
Thank you. And Mr. Valdez, you are here today because you were arrested yesterday on for violations of armed robbery with a deadly weapon, a Class 2 felony committed on or about March 25th of 25, aggravated assault, a Class 3 felony also committed on or about March 25th of 2025, carrying a deadly weapon under 21 years of age, a Class 3 misdemeanor committed on or about April 14th of 25, and possession of a weapon by a prohibited person, a Class 4 felony committed on or about April 14th of 2025. Did find probable cause for all of those violations, and I am appointing you an attorney. I am setting hearings in your case. on April 21st at 8:30 and April 24th at 8:30 in the downtown Maricopa County Superior Court. I am setting a secured appearance bond in your matter in the amount of $75,000. In the event that you are able to post that bond, you will be subject to certain pretrial services to include ankle monitoring. Again, in the event that you are able to post that bond, you may not return to the scene of the alleged crime or have any contact with the alleged victim. Go ahead, step to the left. Officer will have your paperwork for you.
Thank you.
Ethel Lee Welliver, please. And then we're going to have Jeremiah Reyes. Ms. Welliver, go ahead, state your name for the record.
Ethel Lee Welliver,
And Ms. Welliver, what is your date of birth?
10/29/1963.
Thank you. And you are here today following your arrest yesterday for aggravated assault, a Class 2 felony. I did find probable cause for that. I am appointing you an attorney, and I'm setting 2 hearings in your case, the first on April 21st at 8:30, and the second one on April 24th at 8:30, both in the downtown Maricopa County Superior Court. I am setting a secured appearance bond in your matter in the amount of $10,000. In the event that you are able to post that bond, you may not return to the scene of the alleged crime or have any contact with the alleged victim. I think that you two live together, but you may not go back even if it's your residence. One civil standby with law enforcement is permitted to collect your essential belongings. Okay, go ahead, step to the left.
I have a question.
Yeah.
I am supposed to be in chemo the week of the 21st.
All right, I have appointed you an attorney. So you're going to need to talk to your attorney about scheduling, okay?
Okay, and that's all in here?
The information that is available at this point, I'm not sure if they know who your attorney is going to be, but the available information at this point is in that paperwork for you.
Okay, thank you.
Thank you. Jeremiah Reyes and then Beth Roseborough. Good morning, sir. Go ahead, state your name for the record.
Jeremiah Elias Reyes,
And Mr. Reyes, what is your date of birth?
6/14/2001.
Thank you. And you are here on an arrest warrant from the Maricopa County Superior Court on a direct complaint. And that direct complaint alleges that on or about October 17, 2024, you were involved in a violation of misconduct involving weapons, a Class 4 felony. I am, for purposes of appointing you an attorney based upon the information you provided, determining that you are not indigent, but you are welcome and you have the right to retain an attorney at your own expense. I am setting hearings on April 21st at 8:30 a.m. and April 24th at 8:30 a.m., both in the downtown Maricopa County Superior Court. I am setting a secured appearance bond in your case in the amount of $10,000. You are on probation, according to my information, in a different case. So you will need to contact, if you post that bond and secure your release, you will need to contact your probation officer within 24 hours. Okay, go ahead, step to the left. Officer has your paperwork for you.
Question?
Sir?
I'm unbondable for the probation though, right?
I don't have your, so I have the direct complaint information. I'm not showing it as a violation of your probation, but that's still, hold on, let me look. Make sure I'm giving you the right information. October 24th. Look. Looks like you're in probation revocation proceedings in your 23 case. And then also on probation in your 17 case. What is your 24? The information that I have, the direct complaint is recommending a bond of $10,000 secured, and I am going to affirm that today. You may get page 2'd on the other ones while you're in custody, but I just don't have that yet. So go ahead, step to the left. I'm going to go with what I have so far. Yeah, okay. All right, Beth Rosenberg, please. And then Lynn Augustin. Oh, I'm sorry. You were probably there the entire time, and I apologize. Ma'am, go ahead and state your name for the record.
Beth Roseborough.
And Ms. Roseborough, what is your date of birth?
4/29/90.
All right, and you are here today on 4 matters, so we're going to go ahead and talk about your new matter first. You were arrested yesterday on charges of narcotic drug possession, a Class 4 felony, and possession of dangerous drugs, a Class 4 felony. I am finding probable cause on the narcotic drug possession, the Class 4 felony, but I'm not finding probable cause on the possession of dangerous drugs. That doesn't mean that those allegations are dismissed, and a formal complaint may still be filed with the dangerous drug possession violation as well as the narcotic drug possession. But for purposes of today's hearing, I am finding probable cause on just the narcotic drug possession, a Class 4 felony. I am appointing you an attorney, and I am setting 2 hearings in your case. The first one on April 21st at 8:30 and the second one on April 24th at 8:30, both in the downtown Maricopa County Superior Court. I am setting a secured appearance bond in your new case in the amount of $750. All right, so you also have 3 other cases. You have in which warrants for your arrest based upon allegations that you violated your probation has been issued. Let's talk about your CR 2019-112345 case. Actually, let me back up. On all 3 probation violation cases, I am appointing you an attorney, and I'm setting hearings on April 22nd at 8:30 in the morning. In your CR 2019-112345 case, I am setting a secured appearance bond in the amount of $250. In your CR 2019-145981 case, I am setting a secured appearance bond in the amount of $1,000. In your CR 2023-133586 case, I am setting a secured appearance bond in the amount of $900. So that is a total secured appearance bond of $2,900 in all 3 cases. If you are able to post that bond and secure your release, you will need to contact your probation officer within 72 hours. Go ahead, step to the left. All right, Lynn Augustin, please. Good morning, Mr. Augustin. Go ahead, state your name for the record.
Yeah, Lynn Brian Augustin, date of birth April 5th, 1962.
Okay, you are here on 2 matters. You are here on a new case, but you're also here because the Superior Court issued a warrant based upon a probation violation.
Yes.
All right, let's talk about the probation violation first. This is a warrant in your case, CR 2008-007339. And in that case, I am appointing you an attorney, and I'm setting hearings on April 22nd at 8:30 at the downtown Maricopa County Superior Court. Probation violation matter, I am setting a bond in the secured appearance bond in the amount of $2,000. If you're able to post that bond, you will need to contact your probation officer within 72 hours, okay? All right, now you are also here today because you were arrested yesterday on charges of possession of dangerous drugs, a Class 4 felony. For purposes of today's proceeding, based upon the limited information that I have in front of me, I am not finding probable cause for this new violation. Although I'm not finding probable cause, it does not mean that these allegations, that the new allegations are dismissed, and you must still attend your scheduled court dates, which I'll give you in a minute, because formal charges may nonetheless be filed on the April 14th drug charges, okay?
Yes.
All right. On the April 14th drug charges, I am appointing you an attorney. I am setting 2 hearings in that case. The first on April 30th at 8:30 and the second one on May 2nd at 8:30, both in the downtown Maricopa County Superior Court. In the event that you are able to secure your release, because I know there's a bond in your probation case, don't forget to contact your probation officer within 72 hours. All right, go ahead, step to the left. I'll finish your paperwork for you. Xavier Howard, please, and then Carlos Macias Armenta.
Hi,
Hi, go ahead, state your name for the record.
my name is Xavier Howard, born July 3rd of 1993.
All right, and you are here today because the Superior Court issued a warrant for your arrest in a probation violation matter in your case CR 2023-002421. I am appointing you an attorney in that case, and I am setting hearings on April 22nd at 8:30 in the downtown Maricopa County Superior Court. I am setting a secured appearance bond in that case in the amount of $1,500. In the event that you are able to post that bond, you need to go to your hearings and you need to contact your probation officer within 72 hours of your release. Okay? All right, go ahead, step to the left. Officer has your paperwork for you. Carlos Macias Armenta, please. Good morning. Go ahead, state your name for the record.
Carlos Alfredo Macias Armenta,
Thank you. And Mr. Armenta, what is your date of birth?
August 1491.
Thank you. All right. And you are here because you were, well, based upon charges yesterday of taking contraband into a correctional facility, a Class 5 felony, and possession of drug paraphernalia, a Class 1 misdemeanor. I did find probable cause for both of those. I am appointing you an attorney, and I am setting hearings in your case. The first on April 21st at 8:30 a.m. and the second one on April 24th at 8:30 a.m., both in the downtown Maricopa County Superior Court. I am setting a secured appearance bond in this matter in the amount of $1,000. Go ahead, step to the left. Officer, I have your paperwork.
I'm not going to be released?
No. $1,000 secured appearance bond. Victor Cruz, please. Mr. Cruz, go ahead, state your name for the record.
Victor Julian Cruz,
And Mr. Cruz, what is your date of birth?
October 1st, 1994.
Thank you. And you are here, sir, on 3 warrants out in Maricopa County Superior Court for failure to appear in your pending or in your pending criminal matters there. And those matters are, Let me get those. Yeah. CR 2024-007524. Let me actually back up. I'm not appointing you an attorney in any of these cases because one should already have been appointed for you. I am setting hearings in these matters on April 24th at 8:30 in the downtown Maricopa County Superior Court. I am setting cash bonds in each of these cases, and those bonds, those cash-only bonds are as follows. In CR 2024-007524, I am setting a cash bond in the amount of $250. In your case, CR 2024-007510, I am setting a cash-only bond in the amount of $100. And in your case, CR 2024-006907, I am setting a cash-only bond in the amount of $250. So that's a total of $600 cash-only bond. If you are able to post that bond, you need to go to your court hearings.
I tried to contact my PO. She wasn't answering me. And I went to detox myself and got out already. So I can prove that to you guys.
Okay.
I'll take a piss test.
Oh, okay. I appreciate
I was waving down the police.
offer.
I was waving down the police. I didn't have a phone or nothing. I charged my monitor when I got out.
Okay.
I was blowing up her phone on my dad's phone. I went to work. Scottsdale police helped me in San V, and they picked me up, and I was trying to wave them down, and that's how I got here.
Okay. So I am going to the judge in your cases has recommended that $600 cash, that combined $600 cash bond, and I'm going to go ahead and affirm that. So if, you can talk to that judge when you see him on the 24th. Go ahead, step to the left. Officer will have your paperwork for you. Michael Dizen, please. And then Carlos Flores. Morning, Mr. Dizen. Go ahead, state your name for the record, please.
Michael Santiago Dizon, May 7, 1969.
Okay. And Mr. Dizon, you are here today on 3 matters. You have a new case, and then you have 2 warrants issued by the Maricopa County Superior Court for probation violation matters. So let's talk about your new case. You were arrested yesterday on charges of possession of dangerous drugs, a Class 4 felony, and possession of drug paraphernalia, a Class 6 felony. I did find probable cause for both of those violations. I am appointing you an attorney on your new charges and setting hearings in the Maricopa County Superior Court on April 21st at 8:30 and April 24th at 8:30. Again, both in the downtown Maricopa County Superior Court. In your new case, I am setting a secured appearance bond in the amount of $250. Now, the Superior Court has also issued warrants for your arrest for probation violation matters. Wait, no, that's not true. Hold on, sorry. Wow. So, I'm sorry. The allegations in the violations in the new in your new case for which you were arrested yesterday would constitute violations of your probation in CR 2023-000008 and CR 2024-153538. I am appointing you an attorney in both of those probation violation matters, and I'm setting hearings in the probation violation cases on April 22nd at 8:30 a.m. In each of the probation violation matters, I am setting a secured appearance bond in the amount of $250. So that is a combined secured appearance bond for all 3 cases in the amount of $750. In the event that you are able to post that bond and secure your release, you will need to contact your probation officer within 72 hours. Okay, go ahead, step to left. Officer has your paperwork. Carlos Flores, please, and then Rick Nuzzo. Good morning, sir. Go ahead, state your name for the record.
On the floor.
And Mr. Flores, what's your date of birth?
83. Excuse me.
All right. All right, sir. You are here today because Maricopa County Superior Court issued a warrant for your arrest in a probation violation matter. I am appointing you an attorney, and I'm setting hearings on April 22nd at 8:30 in the downtown Maricopa County Superior Court. I am setting a secured appearance bond in this matter in the amount of $750. In the event that you are able to post that bond, you will need to contact your probation officer within 72 hours. All right, go ahead, step to the left. Rick Nuzzo, please, and then Johnny Gaitan, please. Morning. Go ahead, state your name for the record.
Rick Mario Nuzzo.
And Mr. Nuzzo, what is your date of birth?
5/30/80.
All right, and Mr. Nuzzo, you are here today on a new case and also on a warrant in your probation case. So let's talk about the new case first. You were arrested yesterday on charges of possession of dangerous drugs, a Class 4 felony, and possession of drug paraphernalia, a Class 6 felony. I did find probable cause for both of those violations. I am appointing you an attorney, and I'm setting two hearings. The first on April 21st at 8:30, and the second one on April 24th at 8:30, both in the downtown Maricopa County Superior Court. In your new case, I'm setting a secured appearance bond in the amount of $500. In your case in which you are currently on probation, which is CR 2024-119826, I am appointing you an attorney in that case as well. And I'm setting hearings on April 22nd at 8:30 in the downtown Maricopa County Superior Court. In your probation violation matter, I am setting a secured appearance bond in the amount of $500. So for both cases, it is a secured appearance bond of $1,000. In the event that you are able to post that bond and secure your release, you will need to contact your probation officer within 72 hours. All right, go ahead, step to the left. Johnny Gaitan and then Carlos Samaniego. All right, Mr. Gaitan, go ahead, state your name for the record.
Johnny Salvador Gaitan.
And Mr. Gaitan, what is your date of birth?
10/6/64.
Thank you. All right, and Mr. Gaitan, you are here because Maricopa County Superior Court issued a warrant for your arrest on allegations that you violated your probation in case CR 2024-101726. And I need to fix this one. I am appointing you an attorney in this case, and I am setting a, hold on, no, that's that one. And I'm setting hearings. I'm setting a hearing on April 22nd at 8:30 in the downtown Maricopa County Superior Court. I am setting a secured appearance bond in this case of $300. In the event that you are able to post that bond and secure your release, you will need to contact your probation officer within 72 hours of your release. All right, go ahead, step to the left. Carlos Samaniego. Good morning, sir. Go ahead, state your name for the record.
Carlos Alberto Uscanga Samaniego.
And Mr. Samaniego, what is your date of birth?
03/07/1991.
All right, and you are here because you were arrested yesterday on charges of possession of drug paraphernalia, a Class 6 felony, and DUI, a Class 1 misdemeanor. I did find probable cause for both of those violations. I am appointing you an attorney, and I'm setting two hearings in your case. The first on April 22nd at 8:30, and the second one on April 24th at 8:30, both in the downtown Maricopa County Superior Court. In this new case that we're talking about now, I'm setting a secured appearance bond in the amount of $250. Now, you are also here because the allegations in the new case would constitute a violation of your probation term 1 of your probation in your case CR 2024-123981. In the probation violation matter, I am also appointing you an attorney, and I'm setting hearings on April 22nd at 8:30 a.m. in the downtown Maricopa County Superior Court. In the probation violation matter, I am setting a secured appearance bond in the amount of $250. So that is a combined secured appearance bond of $500 for both cases. In the event that you are able to post that bond, you will need to contact your probation officer within 72 hours of your release.
If I have the money in my property, how can I do that?
I'm sorry, what?
If I have the money in my property?
So you can talk to, it is a secured appearance bond, so you can go through a bonds person, or you can otherwise post it, but you will need to talk to the detention officers about how to do that, okay?
Okay.
All right, if you post it, make sure you contact your probation officer and show up to those hearings, okay?
I will.
All right.
Thank you.
Gary James, please. And then Dora Orozco.
Hello.
Hello, sir.
My name is Gary James, 32980.
All right, and you are here because you were arrested yesterday on charges of narcotic drug possession, a Class 4 felony, and possession of drug paraphernalia, a Class 6 felony. I did find probable cause for both of those violations. I am appointing you an attorney, and I'm setting 2 hearings in your new case. On the first on April 21st at 8:30, and the second one on April 24th at 8:30, both in the downtown Maricopa County Superior Court. In this new case, I'm setting a secured appearance bond of $250. Now, you are also here because you are currently, you have an arrest warrant out for you on a direct complaint in your case, CR 2025-114319. I'm sorry, I went too far. CR 2025-114319, and that direct complaint alleges that on or about October 9, 2024, you possessed or used narcotic drugs, a Class 4 felony, and also on or about October 9, 2024, you possessed or used drug paraphernalia, also a Class 4 felony. I am, okay. I am setting you I am appointing you an attorney in the direct complaint matter as well, and I'm setting hearings in the direct complaint matter on April 21st and April 24th at 8:30 in the downtown Maricopa County Superior Court. In the direct complaint matter, I am setting a secured appearance bond in the amount of $500. So for both cases, both your April case and then the direct complaint case with allegations from October of 24, that is a combined secured appearance bond of $750. In the event that you are able to post that bond, you need to go to your court hearings.
Okay, well, if I can't make them both, I can't post that bond, what if I can't?
Then officers will make sure that you you'll be transported for those hearings.
So I have to stay in, or you have to keep me in custody?
You have to stay in unless you can post that bond. Dora Orozco, please. And then Leonardo Ibanez, please. Good morning, ma'am. Go ahead, state your name for the record.
Good morning. Dora Orozco,
And Ms. Orozco, what is your date of birth?
8/22/78.
All right, and you are here because?
They said I had an open container of alcohol in my car, and that's what they said.
Right. Oh, I'm sorry. I didn't mean for it to be a leading question. I am sorry. I was reading. You do have the right to remain silent. You are here because you were arrested yesterday on charges of possession of prescription drugs, a Class 1 misdemeanor, and consuming liquor in a vehicle, also a misdemeanor. I am, for purposes of appointing you an attorney, I am finding that you are indigent, and an attorney should be appointed for you at your next hearing, which will be on April 22nd at 1:30 p.m. in the Surprise Municipal Court. Yeah, I am setting a secured appearance bond in this matter in the amount of $750. In the event that you are able to post that bond, you do need to go to that court hearing, okay?
I'm sorry, can you repeat that?
I am setting a secured appearance bond in your case in the amount of $750. In the event that you're able to post that bond, you do need to go to your hearing, okay?
Okay.
All right, go ahead, step to the left. Leonardo Ruiz Ibanez, and then Kevin Thompson, please.
Good morning, Your Honor.
Good morning, sir. All right, Mr. Ibanez, go ahead and state your name for the record.
My name is Leonardo Ruiz Ibanez.
All right, and Mr. Ibanez, what is your date of birth?
June 28th, 2006.
Okay. And you are here today, sir, because you were arrested yesterday on charges of endangerment, a Class 6 felony committed on or about April 13th, leaving the scene of an accident, a Class 1 misdemeanor also committed on or about April 13th, and criminal reckless driving, a Class 2 misdemeanor committed on or about April 13th, and criminal damage, a Class 4 felony committed on or about April 14th. Did find probable cause for all of those, and I am, for purposes of appointing you an attorney, finding that you are indigent, and appointing an attorney to represent you in this matter. I am setting hearings on April 30th at 8:30 and May 2nd at 8:30, both in the downtown Maricopa County Superior Court. Will you go to those?
Yeah, I will.
Okay, then I'm going to release you today to pretrial services.
Thank you.
I'm going to require you get drug and alcohol tested and that you have an ankle monitor installed, okay?
That's fine.
All right. Go ahead, step to the left. All right, Kevin Thompson, please, and then Michael Downs.
I'm sorry, can I just quickly ask a question?
Sir.
If I have the ankle monitor, would I still be able to go to work?
So it's, I put it as curfew, so it will be, you're going to have to work with pretrial services on appropriate hours for that, but it's not house arrest, okay?
Okay, thank you.
Mm-hmm. Kevin Thompson, please, and then Michael Downs. Mr. Thompson, go ahead, state your name for the record.
Kevin Thompson, 11963.
Thank you, Mr. Thompson. All right, you were arrested yesterday on 2 charges. The first is possession of narcotic drugs for sale, a Class 4 felony. I didn't find probable cause for that violation. Arrested on charges of possession of drug paraphernalia, a Class 6 felony. I did find probable cause for that violation. I'm working on very limited information here, and while I may not find probable cause, it doesn't mean that those allegations are necessarily dismissed, and charges may still be brought against you on those, for those violations. However, again, for purposes of today's hearing, I'm finding probable cause only on the possession of drug paraphernalia, the Class 6 felony. I am appointing you an attorney, and I'm setting hearings in your case on April 30th at 8:30 in the morning and May 2nd at 8:30 in the morning, both in the downtown Maricopa County Superior Court. Will you go to those?
Yes.
Okay, I'm going to release you today on your own recognizance.
Thank you.
Okay. Jeffrey Kinney, please. Morning, sir. Go ahead, state your name for the record.
Michael L. Downs.
I'm sorry, what?
Michael L. Downs.
Sorry, my bad. I skipped ahead.
Okay.
This now makes sense with the picture. Okay.
Okay.
And Mr. Downs, now that
Yeah.
I know, now that you and I are on the same page, what is your date of birth?
13158.
All right, you were arrested yesterday on three violations: unlawful discharge of a firearm, a Class 6 felony; endangerment, a Class 6 felony; and criminal damage, a Class 1 misdemeanor. I did find probable cause for all of those violations. I am appointing you an attorney, and I am setting hearings in your case on April 30th at 8:30 and May 2nd at 8:30. Will you go to those hearings?
I sure will.
Okay, I'm going to release you today to pretrial services.
Okay.
You're going to need to register with them, and then you're going to need to do drug and alcohol testing, all right?
Okay.
All right, go ahead, step to the left. Officer has your paperwork for you. All right, now Jeffrey Kinney. And then Mark Salazar. All right, Mr. Kinney, go ahead and state your name for the record.
Jeffrey Kenny,
And Mr. Kinney, what is your date of birth?
6/22/83.
Thank you. And you were arrested yesterday on charges of narcotic drug possession, a Class 4 felony, possession of dangerous drugs, a Class 4 felony, and possession of drug paraphernalia, a Class 6 felony. I did find probable cause for all of those violations. I am appointing you an attorney, and I'm setting 2 hearings in your case. The first is on April 30th at 8:30, and the second one is on May 2nd at 8:30, both in the downtown Maricopa County Superior Court. Mr. Kinney, will you go to those?
Yes, ma'am.
Okay, I'm going to release you to pretrial supervision then. Go ahead, step to the left. Officer has your paperwork for you. Mark Salazar, please.
How you doing?
Good morning, sir. Go ahead, state your name for the record.
What is it? Sorry, I can't hear you.
It's okay. Go ahead, state your name for the record.
Mark Salazar,
Mr. Salazar, what is your date of birth?
1988.
All right, and you are here today because you were arrested. Wow. Hold on. Oh, that's why. Give me a second. Because the Maricopa County Superior Court issued a arrest warrant on a direct complaint for the following violations: possession or use of dangerous drugs, a Class 4 felony committed on or about August 25th of 24, driving or actual physical control of a vehicle while under the influence, a Class 1 misdemeanor also committed on or about August 25th, 2024. And driving or actual physical control while under the influence, a second count, also a Class 1 misdemeanor, also committed on or about August 25th, 2024. I am appointing you an attorney in this matter, and I'm setting 2 hearings. The first one on April 30th at 8:30 a.m. and the second one on May 2nd at 8:30 a.m., both in the Maricopa County Superior Court. Mr. Salazar, will you go to those?
I sure will,
Okay, I'm going to release you to pretrial services then.
All right, thank you. Have a good day.
All right, and with that, I think, Kayla Ruiz Harrier, did she get moved to a house call?
We still can't find her yet,
Okay,
so I think they took her to the wrong court.
okay. Do we just want to bump Miss Ruiz Harrier then to the 11 a.m. or even the 2, so that, because we still have time for her?
She should be back by 11, right?
Yes, they're trying to get her back from downtown court.
Oh, okay.
I guess she was EEC court.
Maybe?
Yes.
Okay.
So they took her there instead of bringing her here. She actually court.
I understand having conflicting obligations. Okay, so we'll do it 11 then, is that good with you? Okay. All right, so then we are going to do our house calls, and so we do need to clear for 4, but not for 28.
So a little far.
That one was vacated, it's the federal warrant.
Oh.
I don't know when they after the time I got here, so.
Yeah,
I thought
me
they-
too. They crossed it out, so
Oh, they crossed it out?
well, they did, but they didn't tell me that it was crossed out. He's out there.
Oh, okay.
I can move him out.
Yeah.
All right, we have 2 house calls today, and these individuals are not able to be with us because they are a danger to self or others, or otherwise not able to function for purposes of appearing here in court. The first one is Miguel Madrid Garcia. Mr. Madrid Garcia's date of birth is September 1999, and Mr. Madrid Garcia is here on a warrant out of the Peoria Municipal Court it's a pre-adjudication warrant. Because of the nature of the charges, Mr. Madrid Garcia is not entitled to have an attorney appointed for him today. And he has a hearing scheduled on May 1st at 9 a.m. in the Peoria Municipal Court. My inclination at this point is to release Mr. Madrid Garcia on his own recognizance. However, if anything changes after I speak with Mr. Madrid Garcia, I will update my written order. Our second matter is David Hilton, whose date of birth is December 29th, 1980. And Mr. Hilton is here today on a warrant from the grand jury for violations of sexual exploitation of a minor, dangerous crimes against children, Class 2 felonies committed in from August 2021 through May and into May of 2022. The grand jury had recommended a cash bond. I am appointing, hold on, why? Let me redo this one, I'm sorry. I am appointing Mr. Hilton an attorney, which is the part I missed, and I apologize for that. I am appointing Mr. Hilton an attorney, and I am setting a cash-only appearance bond in the amount of $150,000. And I am doing this because the grand jury issued an $100,000 recommendation for a $100,000 cash-only bond. However, in view of the information in the Form 4, the defendant barricaded himself in his apartment to avoid arrest, and also the fact that that warrant is several months old. I am going to go ahead and set the cash-only appearance bond in the amount of $150,000. In the event that Mr. Hilton were to be able to post that bond, he would also be subject to additional conditions such as ankle monitoring. So with that, I think that completes everything we can do on the 8 a.m. calendar, and court will stand adjourned until the 11 a.m. calendar. Any updates for the house calls will be done in writing.
Oh, these are Silvas,
Where are you? Oh, right there.
Begay, and McKnight.
All right. I'll just go ahead and continue. Oh, go ahead. Yes.
Your Honor, this is Court Interpreter Pedro Davis. Mr. Padilla was the one interpreter matter that we had on this morning's list. So if he's not seen by your lead, may I be excused?
Yes. Thank you.
Thank you.
McKnight. Where are you? There you All of those have been continued to this evening, except for Begay, who's just been continued for a 30-day review hearing. What?
Thank you.
That's number 4. Yeah, I think I did double check. And then number 2, number 4. All right, good morning. Please state your name.
Camila Felix Sepulveda.
Ms. Felix Sepulveda, this is the time for your initial appearance. Let's see. You are here this morning after being picked up on a warrant for a charge of driving under the influence. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney. I am appointing Janet Altschuler to represent you in this matter. And we're going to talk about your conditions of release this morning. And to prepare for that, I have reviewed, let me see, information in the file, including the fact that I've been informed that you're being held on another matter out of Pima County Justice Court, I believe.
It's Santa Cruz County.
Okay, it's Santa Cruz County. All right.
Yeah, but I have been pulled over on it multiple times, and every time they told me that it was non-extraditable, and I don't know what changed this time, but I've been trying to take care of it, but they just tell me that I have to physically be in the county of Santa Cruz to take care of it, and then I don't know what's different this time around that it became extraditable.
Okay. Well, I don't know why. Let me look at this for a second. Oh, so it looks like at this point, it looks like the out-of-county issue is a probation violation. And that may be part of what makes the difference. I don't know if that's what it was in the past or not. But then you also have this matter in Pima County?
One for Pima County. I was never given the option to take care of it because the warrant was issued while I was in federal custody.
Okay.
So I never got the opportunity to take care of it.
All right. So if I were to order that you be released on your promise to appear for your next court date, would you appear for your next court date?
Most definitely.
All right. So that court date is going to be April 25th at 8:30 in the morning. And that is before Judge Cornejo at Pima County Justice Court. If you were to fail to appear for that hearing, given that you were just arrested on this matter, it's likely that another warrant would issue for your arrest out of that hearing. The additional orders are that you do not drive unless you have a valid driver's license, do not possess or consume any alcohol or illegal drugs. And then since I am not going to hold you on the matter, then I am not going to appoint an attorney to represent you. So you do have the right to hire an attorney of your choice, and in certain circumstances, an attorney may be appointed on your behalf. All right?
Alrighty.
You understand the consequences of failing to appear?
Yes.
All right. Thank you. You're excused.
It's going to take into
Doesn't work great when I don't have paper under it.
See, that's my right. Yeah, because the Sunny Attorney Office got they thing over to slip. But the other ones, right, I asked about that and tried to get it way position on it, told no. He said, no, but we notified that he's still not here, so she's getting calling and stop.
State your name.
Brian Cesar Reyes.
Mr. Reyes, this is the time for your initial appearance. You are here this morning on misdemeanor charges of assault. You have the right to remain silent. Anything you say can and will be used against you. Under certain circumstances, an attorney may be appointed to represent you, and you always have the right to hire counsel of your choice. It looks like you were also being held on other felony matters before me today. Is that correct?
Yeah.
All right, thank you. We're going to talk about your petition for release in this matter. I am going to order that you're held on a bond of $500. That will be cash or secured. I'm going to order that if you are released, you may not possess or consume any alcohol or illegal drugs. And your next court date is going to be tomorrow at 1 p.m. before Judge Cornejo for an arraignment. If you remain in custody, the jail will make you available for that hearing. And if you were to be released, then it would be your responsibility to appear. And if you failed to appear, a warrant could be issued for your arrest. Do you understand?
Yes.
Yes, I am appointing Janet Altschuler to represent you in the misdemeanor case. Thank you. You're excused.
Thank you.
Good morning. Please state your name.
Christopher Allen Chapman.
Mr. Chapman, this is the time for your initial appearance on charges of shoplifting. These are felony charges from March of this year. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney, and it is ordered appointing the public defender's office to represent you. And you have counsel seated next to you for the purposes of today's hearing. It looks like you are being held on charges out of Pima County Justice Court that are not in front of me today. So regardless of what I ordered in today's hearing, you would not be actually released until those matters were resolved. We're going to talk about your conditions of release on these new charges, and I have reviewed information provided by pretrial services about you, which lets me know about your ties to the community and whether you have any felony criminal history, and what their assessments and recommendations are. And then I don't see, let me just double check in here. Oh, here it is. Okay. It looks like the state is recommending that you be held on a bond of $30,000. And if you are able to post that bond, that you be released to the custody of pretrial services. Would the state like to be heard further? Mr. Poston, did you want to be heard any further?
No, Your Honor.
Thank you. And the defense.
I would, Your Honor. I'd like to note that I did not receive a complaint from the state in Mr. Chapman's case, so I can't meaningfully address the underlying allegations that the state has alleged in this case. I will note that what the state is recommending, $30,000, is quite a high bond for somebody that is charged with shoplifting. I understand that there's some priors and some history in Mr. Chapman's past, but the fact of the matter is this is not a crime of violence. This is not a crime of domestic violence. This is not something that has endangered the community. What the state has alleged is that he had essentially removed goods from a store. And so while these are serious allegations, we're talking about a class 4 felony. We're not talking about actual physical harm or danger to the community. And so in terms of what the court needs to address here, it's his ability to show up to court and the threat and the danger that he presents to both the community at large and the listed victim in this case. Now, again, I don't know who the listed victim is because I don't have a complaint. But the fact of the matter is we're not talking about physical harm or danger to the community here. And I don't think that $30,000 gives Mr. Chapman the opportunity to potentially post a bond and secure his release, which is the purpose of bond. It's not to hold people. It's to give them the opportunity to bond out and have some skin in the game and secure their release. And Mr. Chapman's not in a financial position with $30,000 as a posted bond to be able to do that.
Thank you.
Your Honor,
I think if I could just have a moment, Mr. Poston, I did just want to let you know, I think the reason you don't have an interim is that Mr. Chapman was supposed to be seen at a previous IA session, but was not able to be seen at a previous IA session. And so his interim would have been provided at that time, I think, to whoever was sitting in your seat at that session. The charges allege that he took $546.79 worth of merchandise from Walmart and has been charged with shoplifting more than 2 times in the past year. Mr. Poston, is there something else you need to say?
The state would note the fact that he's in custody on other charges and he's not, and it's not just the 500 and such that he stole this time around. He's got quite a few open charges. He has an extensive history of theft, drugs, trespass, and this is just
the tip of the iceberg, and I'm ratifying a judgment call made by a colleague previously.
Thank you. I'm going to order a bond of $1,500. That's cash or secured. If you are released, you'll be released to pretrial services. You'll be ordered to submit to monitoring or treatment as directed by pretrial services. No alcohol or illegal drugs, no firearms or weapons, no contact with the alleged victim. Do not return to the incident location.
Thank you, Your Honor. Your Honor, when were those next court dates?
Yeah, his next court date is April 25th at 1:30. And if you can still hear me, Mr. Chapman, if you are able to post bond and be released and then fail to appear for court, a warrant can issue for your arrest. You're excused.
Yes, Your Honor.
Thank you.
Here you go, Mr. Chapman.
Thank you, sir.
Thanks, appreciate it.
It's 10:30, right?
Good morning. Please state your name.
Christian Garcia.
Mr. Garcia, you are here this morning on your initial appearance. Let's see. It looks like you were arrested on a warrant out of Maricopa County, but there are some Pima County charges keeping you here in Pima County as well. Those are not before me today. We're just doing a review hearing of your Maricopa County warrant status. And so what I'm going to do is just set another review hearing in 30 days to determine if you are still being held here in Pima County or to Maricopa County on that warrant. Okay?
Okay.
All right. Thank you. You're excused.
30 days? Yeah. So they're going to see you. They're going to take you back. That's an accident. I'm looking to another. And I'm speaking the doctor. Good. Thank you. I can't see you here, but well, this is pretty bad.
Good morning. Please state your name.
Laura Arizmendi.
Ms. Arismendi, this is the time for your initial appearance on charges of possession of drug paraphernalia out of Tucson City Court. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire an attorney of your choice. In certain circumstances, an attorney may be appointed on your behalf. You are presumed to be innocent, and I will enter a plea of not guilty for you today.
Okay.
We're going to talk about your conditions of release, and if I were to order that you were released on your promise to appear for your next court date, would you appear for your next court date?
Yes, by my word.
Thank you. So I am going to order that you're released on your promise to appear. The additional orders are that you possess or consume no alcohol or illegal drugs, and then I am going to consolidate this case with your other cases out of Tucson City Court. Your next court date will be June 6th.
Okay. So instead of April 30th?
Will she have anything set on April 30th currently? I have to look. Let me look.
Okay.
Hold on. Let me look and see if you. Yeah, we can do April 30th since you already have that set. I'll change it.
Okay. No. Because I have a court on April 30th already. I thought that you were consolidating that court date with this one.
Yeah, I'm going to do that.
Okay, let's do it how you said.
So it'll be April 30th at 2 p.m.
Okay.
This is how it's money probation warrant.
She fell.
Your Honor, she's being held on a Maricopa County warrant.
Okay. Let me see.
Can I go to rehab for that?
That you have to talk to Maricopa County like that. It's you're being tempted to do that on the Maricopa County warrant, and then it's Maricopa. You're still on the one chance.
So then in that case, ma'am, let me just explain to you the options. So if I order that you're released on this case, then you would be released to Maricopa County. And then hopefully you would be able to be released there by your April 30th court date. And I'm not sure what your Maricopa County charges are, so I don't know if you are likely to be released there in the near future. Do you have a feeling about that?
The probation violation?
Okay. All right.
So, I don't know. I'm not sure what to expect of that.
So maybe, counsel, are you willing to have a quick chat with her to see if she would like to be released to Maricopa County or if she would like to be held here to deal with this first?
Sure.
Thank you. You're welcome.
Your Honor, she'd like to remain here to deal with the Pima County case.
Okay. And the earliest date I can give you to be seen on this case is 10 days from now, April 25th. Is that okay?
That's fine.
She hasn't put one yet.
Oh, dang. There's so much whiteout on this piece of paper. Okay. 425. All right. So I am going to appoint the City of Tucson Public Defender to represent you in this case. I'll order that you're held on a bond of $50, passive secured. If you remain in custody, your next court date will be April 25th at 1:45 for a video review. And if you were to post bond and be released in this matter, then your next court date would be that April 30th date at 2 o'clock. If you fail to appear for future court hearings, a warrant can issue for your arrest. The hearings can go forward in your absence, including trial. And if you're convicted and then fail to appear for sentencing for at least 90 days, you can lose your right to a direct appeal. You understand?
Yeah.
All right. Thank you. You're excused.
Because she said like I don't think I fail. No. And then we changed to my
Talk to the city public defender about what that's going to look like. Okay, because I with the Maricopa County. So
this, I don't know if this is your question, but if you post bail now, then you would be released to Maricopa County's custody. But I don't know if you have an attorney in that case that you can talk to and see if you can, arrange something else. All right, you're excused.
Thank you.
Back. Mom, you're gonna go this way. All the way down the steps.
Good morning. Please state your name.
Becker.
Mr. Becker, this is the time for your initial appearance on failure to comply with a court order. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire an attorney of your choice. In certain circumstances, an attorney may be appointed on your behalf. And you are presumed to be innocent. I will enter a plea of not guilty on your behalf today. We're going to talk about your conditions of release, and if I were to release you on your promise to appear for your future court date, would you appear on that court date?
Yes.
All right. Then I am going to order that you're released on your promise to appear. The additional orders are that you commit no acts of domestic violence, have no contact of any kind with Ashley Fletcher, do not go to her residence or workplace. And your next court date is going to be May 13th at 1:30. That is for a domestic violence arraignment with Judge Million at Tucson City Court. If you were to fail to appear for that court date, a warrant could issue for your arrest. The hearing can go forward in your absence. That includes trial. And if you're convicted and then fail to appear for sentencing for at least 90 days, you can lose your right to a direct appeal. Do you understand?
Yes.
All right. Thank you. You're excused.
Don't. Oh, yeah. Well, that's it.
Hello.
Good morning. Please state your name.
Rochelle Stone.
Ms. Stone, this is the time for your initial appearance on charges of assault and criminal damage. Those are domestic violence offenses. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire an attorney of your choice. In certain circumstances, an attorney may be appointed on your behalf. You are presumed to be innocent, and I will enter a plea of not guilty on your behalf today. We're going to talk about your conditions of release. If I were to order that you're released on your promise to appear for your future court dates, would you appear for your future court dates?
Yes.
All right.
Definitely.
Thank you. So I am going to order that you are released on your promise to appear. The additional orders are that you commit no acts of domestic violence and have no contact with the alleged victim, Paul Stone. Do not go to his residence or incident location. I'm assuming you may have been living at the same place as Mr. Stone?
Let me put it this way, he left.
Okay.
The resident.
All right. So if, and is that where the incident occurred?
Yes, but he had honestly left.
All right. Are there other people living?
No.
All right. So what I'm going to order then is wherever he's living is where you cannot go. Okay. If he's not living there, you can go there.
Yes.
But if it turns out that he is living there,
I have to go.
yeah. But you can return one time with a police escort to pick up your belongings. You would just take my order to the closest police station. Okay.
Okay.
All right.
No problem.
So your next court date is going to be May 13th at 1:30. That's in front of Judge Million for domestic violence arraignment at Tucson City Court. If you fail to appear for that court date, a warrant can issue for your arrest. The hearing can go forward in your absence. That includes trial. And then if you are convicted and fail to appear for at least 90 days, you can lose your right to a direct appeal. Do you understand?
Yes.
All right. Thank you. You're excused.
Valencia.
Good morning. Please state your name.
Uchil Valencia.
Ms. Valencia, this is the time for your initial appearance on charges of driving under the influence. It looks like a warrant was issued in a petition to revoke probation as well. Let's see. I think that is the, well, hold on. Those are the charges that you were on probation for, and a petition to revoke was filed. All right. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by counsel. I am appointing the City of Tucson Public Defender to represent you. And we're going to turn to your conditions of release now. I am going to order that you are held on a bond of $500 cash or secured. If you are able to post bond and be released, the additional orders are that you do not drive if you don't have a valid driver's license, possess or consume no alcohol or illegal drugs. Let's see. Your next court date, if you remain in custody, will be April 25th at 1:45 for a video review. And if you are able to post bond and be released, then your next court date will be May 19th at 9:30. If you were to fail to appear for court after being released, a warrant could issue for your arrest. Do you understand?
Yes.
Thank you. You're excused.
Espinosa. Oh, yeah, down the steps, right hand side, please.
Good morning. Please state your name.
Eddie Espinosa.
Espinosa, you are here this morning on an initial appearance for charges of criminal trespass out of Tucson City Court. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire an attorney of your choice. In certain circumstances, an attorney may be appointed on your behalf. You are presumed to be innocent, and I will enter a plea of not guilty on your behalf today. Sir, if I were to order that you were released on your promise to appear for your future court dates, would you appear for your future court dates?
Yes, ma'am.
I'm going to order that you be released on your promise to appear. The additional orders are that you commit no acts of domestic violence, have no contact of any kind with the alleged victim of the trespass, do not go to the incident location. Your next court date is going to be May 12th at 9 a.m. That's before Judge Verena at Tucson City Court. If you were to fail to appear for that court date, a warrant could issue for your arrest. The hearings could go forward in your absence. That includes trial. And if you were convicted and then failed to appear for sentencing for at least 90 days, you could lose your right to a direct appeal. Do you understand?
Yes.
Used.
Fontes. Victor.
Good morning. Please state your name.
Victor S. Fontes.
Mr. Fontes, this is the time for your initial appearance on charges of driving under the influence, disorderly conduct, and assault. The disorderly conduct and assault are domestic violence charges. You have the right to remain silent. Anything you say can and will be used against you. You have the right to hire an attorney of your choice, and in certain circumstances, an attorney may be appointed on your behalf. And it looks like it's been requested that I do appoint the Tucson City Public Defender to represent you, so I will do that. We're going to talk about your conditions of release today. And before we do that, I will enter pleas of not guilty on your behalf and let you know that you are presumed to be innocent. And then, sir, if I were to order that you be released on your promise to appear for future court dates, would you appear?
Yes.
Quick look at this. Nope, can't do it. All right, so I am going to order that you're released on your promise to appear for your future court date. The additional orders are that you do not drive without a valid license, possess or consume no alcohol or illegal drugs, commit no acts of domestic violence, have no contact of any kind with the alleged victim in the domestic violence cases, and that is Armando Fontes, and do not go to his residence or workplace. Your next court date will be May 12th at 9 a.m. before Judge Verena at Tucson City Court. If you were to fail to appear for court, a warrant could issue for your arrest. The hearings can go forward in your absence, including trial. And if you are convicted and then fail to appear for sentencing for at least 90 days, you can lose your right to a direct appeal. You understand?
Yes.
Thank you. You're excused.
Yes, please.
policy. I'll do that.
Thank you.
Yeah.
Well, Byron. Oh, $100. Oh, Byron.
You see something.
Sit right here, moment.
Good morning. Please state your name.
Byron Echo?
Mr. Antone, this is the time for your initial appearance. On charges of failure to register and failure to have a current Arizona identification. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney. I am appointing the Pima County Public Defender's Office to represent you. We are going to talk about your conditions of release today, and I have reviewed the interim complaint. I have reviewed information provided by pretrial services, which would include any felony criminal history, information that you've provided to them, and their assessments and recommendations. I have also reviewed the state's request, and the state is requesting that you be held on a bond of $5,000 and if posted, be released to pretrial services. Would the state like to be heard further?
Yes, Your Honor. This person has absolutely no justification for not registering. Every person in this individual situation is given abundant warning in writing, verbally, and it is made absolutely crystal clear that given their past, they are required to register. The reason that is because the state has determined that this sort of individual is an ongoing risk to society. He is a danger to the community. And what we have is he has failed to do so, therefore increasing the risk that he's not going to register and the state is going to be deprived of the right to know where this person is at all times. Therefore, he is a flight risk and a danger to the community. 5,000.
Thank you. Defense?
Yes, Your Honor, we're going to be asking to release this individual to pretrial services. I think it's important that we give him the opportunity to, present a defense with the assistance of his attorney from the outside rather than here in jail. Obviously, with his living situation, I think the court can certainly understand sometimes the difficulties of, dealing with life on the street on a day-to-day basis, as well as, complying with some of these additional restrictions that, he has to, that are above and beyond what somebody who is housed would have to comply with in terms of the registration requirements, how often he has to do it. The fact is it's a difficult thing to comply with. Obviously, he has an obligation to comply with it, and whether the state can prove whether he did or did not comply with it is something that happens at a later date. What I'd be asking for, Your Honor, is release to pretrial services so that he doesn't have to sit in jail while waiting for this case to resolve. I can understand where the state is coming from. I will note that there are no other allegations other than the failure to have the ID and failure to register. And so for these reasons, Your Honor, I think that pretrial services is more than sufficient to ensure that Mr. Antone, participates in his case, attends his court hearings, and, continues to comply. Having that level of supervision, I think, would be important to ensure compliance moving forward. And so for these reasons, Your Honor, I think pretrial services release is more than sufficient in this case.
Thank you. I am going to order a bond. I do see a failure to appear history even on pretrial services. I'm going to order a bond of $500 cash or secured. pretrial services if that bond is posted, monitoring or treatment as directed by pretrial services, no alcohol or illegal drugs, no firearms or weapons. And sir, if you are released, you must report to the Pima County Sheriff's Department Identification Unit at 1650 East Benson Highway within 2 working days following your release from custody. Your next court date will be April 25th at 1:30 for a preliminary hearing. If you are in custody, the jail will make you available for that hearing, and if you have been released, then it will be your responsibility to appear, and if you fail to appear, a warrant will issue for your arrest, okay? Yeah. Thank you. You're excused. His name was Ian Chow.
Come on, mommy.
Yours is this coming up next, I think. Good morning. Please state your name.
Robert Rivera.
Mr. Rivera, this is the time for your initial appearance on a couple of different matters. There's a charge out of Tucson City Court of driving under the influence. And then we have, that's a misdemeanor charge. Then we have new felony charges of possession of a narcotic drug for sale, possession of a dangerous drug for sale, possession of weapons as a prohibited possessor, possession of firearms during narcotic offenses, disorderly conduct, which is a domestic violence offense, and discharging a firearm within city limits. You have the right to remain silent on all of these matters. Anything you say can and will be used against you. You have the right to be represented by an attorney on the felony matters, and I am appointing the Pima County Public Defender's Office to represent you. We're going to talk about your conditions of release today. We're going to start with the felony charges. And in preparation for that, I did review the interim complaint. I have reviewed information from pretrial services, which includes whether you have any felony criminal history, their assessments and recommendations, and then any information you provided. And then I have reviewed the state's recommendation, which is that you be held on a bond of $15,000. If you were able to post that bond, that you be released to the custody pretrial services. Would the state like to be heard any further?
Yes, Your Honor. We're looking at dealer weights of multiple drugs. We're looking at other indicia of sales. We're looking at multiple weapons and the fact that he's a prohibited possessor. And then we have the fact that he discharged the weapons up to allegedly a half dozen times. This person is a risk to the community. He's peddling these drugs in huge amounts. These are not personal use. He's got a weapon, he's a convicted felon, and he's using said weapon. He is a danger to the community. He has a history of FTA, he has priors, and he's likely looking at mandatory prison time. He's a flight risk, $15,000.
Thank you. Defense?
Yes, Your Honor. I understand the court is likely inclined to impose a bond here. The thing that I would like to ask the court to really take into consideration here is Mr. Rivera's financial circumstances. That's something that the court is obligated under Rule 7 to take into consideration, and I would really strongly urge that you do so here. This is a young man who, would not be in a position by any means to afford a $15,000 bond, and that might be, the outcome that the state is looking for here. But the whole purpose of bond is to give a person the opportunity to secure their release. And so I asked the court to take into consideration, his age, the fact that, he's working, as I understand it, part-time. And so he's kind of in limited financial circumstances such that he wouldn't be able to afford $15,000. I would really strongly urge the court to consider a bond in the neighborhood of $2,500 to $5,000. That might be something that family members or friends could pull together and put funds together to go through bail bond company and get Mr. Rivera out so that he can continue to live and work and defend his case with the assistance of counsel from his home, where he's certainly safer and certainly better able to present a defense than he would be if he is to remain here in jail. So for these reasons, Your Honor, I'd ask that you please consider a significantly reduced bond than what the state is asking for here. Give him the opportunity to post that bond and show up to court and participate and have it exonerated at the end of his case, one way or another.
Judge, if the state can have a brief moment to respond to that.
I'm going to order a $15,000 bond. Do you still need to respond? Thank you.
No.
Yeah, I see the ability to obtain a lot of drugs and firearms, so I am ordering the $15,000 bond. That'll be cash or secured. If you are able to post that bond, sir, the additional orders are that you may not drive without a valid driver's license, you may not possess or consume any alcohol or illegal drugs, you may not possess any firearms or weapons. If there are any firearms in your possession when you are released from custody, you must surrender those to local law enforcement. You must submit to any monitoring or treatment as directed by pretrial services. No contact with the alleged victims. Do not go to the incident location.
Yep.
On the felony charges, your next court date will be April 25th at 1:30. That's for a preliminary hearing. If you remain in custody, the jail will make you available for that hearing. If you are released, then it will be your responsibility to appear, and if you fail to appear, a warrant can issue for your arrest. Charges, we're also going to do your arraignment today, so you are presumed to be innocent. I will enter a plea of not guilty on your behalf for that driving under the influence charge today. Your next court date for that case, if you remain in custody, will be April 25th at 1:45. It's very close in time to your other case, but if you're in custody, the jail will be able to arrange that you appear by video for both. If you are released on the Tucson City Court matter, then your next court date will be May 22nd at 9:30, and the bond I'm ordering in that case is $50, also cash or secured. If you fail to appear for your Tucson City Court case after being released from custody, then a warrant can issue for your arrest. The hearing can go forward in your absence, including trial. And if you are convicted and then failed to appear for sentencing for at least 90 days, you can lose your right to a direct appeal. You understand, sir?
Yes, Your Honor.
All right, thank you. You're excused for today. I did mark the City of Tucson Public Defender on that one, didn't I? Okay.
Good morning, Your Honor. Good morning. Good morning, Judge.
Who wants them to? Do they want me to release him from custody? Yeah. Well, I'll either hold him or release him. Sure. Okay. All right. Good morning, sir. Please state your name.
Good morning, Judge. My name is Taiwan Scott.
Mr. Scott, this is the time for your initial appearance. You're here this morning on charges of robbery, armed robbery, and possession of a weapon by a prohibited possessor. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney. Hold on. I don't know if I accidentally unclicked it, but office he's supposed to have it. It's Scott is the last name.
That's what I'm saying.
I'm just finding out which defense office is supposed to be appointed to you, sir. I'm going to appoint the public defender to represent you. We're going to talk about your conditions of release today, and to prepare for that, I have reviewed the interim complaint, which describes the circumstances surrounding your arrest. I have also reviewed the information provided by pretrial services, which would let me know if you have any felony criminal history. That lets me know anything you were able to provide or references about your connections to the community. It includes their assessments and recommendations as well. And then I have reviewed the state's recommendation. The state is recommending that you be held on a bond of $50,000. And if you are able to post that bond, that you be released to pretrial services. Would the state like to be heard further?
Yes, Your Honor. This person is a prohibited possessor, not only out of a 2009 case out of Cook County, Illinois, for which he violated probation. Looks like he may still have a probation warrant out there. Next, we have a terminated probation for misconduct involving weapons and a prohibited possessor by a prohibited possessor case out of 2019 here in Pima County. Next, we have, he is a 4 out of 3. He's a 4 and a 3, and he is alleged to have taken a gun, pointed at the victim, and then had an accomplice take the victim's car. And then the individual drove off with that car. He has no problem acquiring weapons despite being a prohibited possessor. He has no qualms about pointing a gun and stealing a vehicle. He is a danger to the community, Your Honor, and therefore he's looking at probably mandatory prison time with prior felonies, assaultive behavior, $50,000. This man is a risk to the community and is a flight risk.
Thank you. Defense?
Your Honor, I'm asking that you release Mr. Scott to pretrial services. I understand the state's coming in with a $50,000 bond and, gave us a nice recitation of Mr. Scott's criminal history, which, of course, we all have access to and have read. The issue is here, I think there is a there's potential and certainly a quite valid defense of a third party that at this time, just from reading the complaint and, having some information from Mr. Scott, it seems as though, there's going to be more to this story. And so I can certainly understand where the court is coming from, on paper, looking at, some of the things that the state has outlined. I would like to note, though, that, we're looking at two priors, one that is evidently at least 13 years old, if not older. And the last one looks like was misconduct involving weapons and possession. So there's some mental health stuff that was at play at the last case. At the end of the day, Your Honor, Mr. Scott here is a father. He is responsible for the financial well-being of his children. He's working full time. He's got a home to go to. It seems as though the alleged victim in this case is not somebody for whom Mr. Scott is very well acquainted with. It seems as though there is a person involved that Mr. Scott knew and that this alleged victim had apparently been having an argument with. But at the end of the day, it doesn't seem as though Mr. Scott's in a position where he lives around or lives with or knows closely the alleged victim here. And so I don't think that he is a danger to this alleged victim. And I don't think he's a danger to the community at large either. He's somebody who, by his own admission, can be relied upon to show up for court and to participate in his case, and he's asking for the opportunity to do that, Your Honor, under the supervision of pretrial services.
Your Honor, the state is at a loss to figure out how defense of a third party justifies the theft at gunpoint of a vehicle.
Great. I'm going to order that you're held on a bond of $10,000. That'll be cash or secured. You'll be released to pretrial services if released. No alcohol or illegal drugs, no firearms or weapons. Sir, if there are any firearms in your possession when you are released, you must surrender them to local law enforcement. No contact with the alleged victim. Do not go to the incident location. Your next court date is going to be April 25th at 1:30. That's for a preliminary hearing. If you were to fail to appear for any future court dates after being released, a warrant can issue for your arrest. Do you understand?
Yes, ma'am.
Thank you. You're excused.
Thank you, Judge. Thank you, Judge.
So I have like my car, yeah, my BMW, Mustang, it was a 98 that worked. I mean,
All right. Thank you.
Yeah.
All right. While we're waiting for the next person to come up, I am going to call the case of someone who is not able to appear for medical reasons. That is Jorge Antonio Padilla Montano. He has a Nogales Justice Court matter and in another matter as well. Let's see. In each case, I am going to order that he is released on his promise to appear, and his presence this morning is waived. Next court date is April 29th at 9 a.m. In his Pima County Justice Court case, his next court date is May 12th at 9 a.m. And I'm not going to make any further orders or conditions at this time. Good? All right. I did them both. All right. Good morning, sir. Please state your name.
Richard Bucker.
Thank you. Mr. Bacher, you're here this morning on your initial appearance on a few different matters. There are new felony charges of possession of a narcotic drug, possession of drug paraphernalia, shoplifting. There are new misdemeanor charges of shoplifting and criminal trespass. And then there is an older case out of Marana City Court from October of 2023 that was in warrant status for shoplifting as well. You have the right to remain silent on all of these matters. Anything you say can and will be used against you. You have the right to be represented by an attorney in the new felony matters, and I will appoint the public defender's office to represent you. You always have the right to hire counsel of your choice in the misdemeanor matters, and in some circumstances, an attorney may be appointed on your behalf. We're going to talk about your conditions of release today on all of these matters, and it looks like the state is recommending on the new felony charge that you be released to pretrial services, and it looks like you may be eligible for STEPS pre-indictment diversion screening on those new felony charges. The STEPS pre-indictment diversion program does require substance abuse treatment. If you were to be accepted into and then successfully complete that program, it's possible that the state would not go forward with these felony charges. Are you interested in that program?
Yes.
All right, so I will set your case for a steps hearing to determine your eligibility. I believe you only get one shot at that, so you want to appear for that hearing. It's on April 22nd at 9 a.m. I am going to release you to pretrial services on your new felony charges. The additional orders are that you submit to any monitoring or treatment as directed by pretrial services, do not possess or consume alcohol or illegal drugs, and do not possess firearms or weapons. Your next court, usually we have to set the preliminary hearing within 20 days. However, to give time for you to be assessed and hopefully accepted into the STEPS program, would you be willing to waive that to 45 days? All right. So then thank you. Your preliminary hearing date will be May 30th at 1:30 p.m. If you are accepted into the STEPS program, there's a strong likelihood that that hearing will not go forward, so make sure you stay in touch with your attorney from the public defender's office. However, if that hearing does go forward and you fail to appear, a warrant can issue for your arrest. So now we'll move on to the misdemeanors. And let's see. On the new misdemeanors out of Pima County Justice Court, I am going to order that you are released on your promise to appear for your future court dates. And you cannot have any contact with the alleged victim. Do not return to the incident location. Your next court date in that case is going to be before Judge Cornejo at Pima County Justice Court. And if you were to fail to appear for that hearing, a warrant could issue for your arrest. And then finally, we have the failure to appear out of Marana City Court. And because you are getting the chance to do the STEPS program, I don't want the Marana City Court case to interfere with that, so I am going to release you on your promise to appear. But because you have already, a warrant had already been issued for you in that case, I want to make it clear that I fully expect that if you don't appear for that hearing, the court will issue another warrant. So you'd be right back in jail if you don't appear. That case is going to be May 14th at 10 a.m. in Marana City Court. You may not have any contact with the alleged victim. Do not return to the incident location. No alcohol or illegal drugs. Do you understand your conditions of release, sir?
Yes.
Thank you. You're excused. Oh, let me look at them again.
Bill?
You're welcome. I probably hit the wrong button. Thanks. All right. Okay. Please state your name.
Trey Bill.
Mr. Beal, this is the time for your initial appearance on charges of aggravated driving under the influence. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney in this case, and I am appointing the Pima County Public Defender to represent you. We're going to talk about your conditions of release today. And I have reviewed the interim complaint describing the circumstances surrounding your arrest. I have reviewed information provided by pretrial services, which is information that you provided about your ties to the community, anything that could have been verified by a reference. It includes whether you have any previous driving under the influence convictions or felony convictions, and it lets me know what the recommendations and assessments of pretrial services are. I have also reviewed the state's recommendation, and the state is recommending that you be held on a bond of $10,000, and if you are able to post that bond, that you be released to pretrial services. Would the state like to be heard any further?
Yes, Your Honor. I'd like the state court to pay the state would like the court to pay special attention to the interim complaint that details how incredibly incapacitatedly drunk this person was, or for the sake of propriety impaired, such that the circumstances to speak to somebody who is so incredibly drunk, but still in a vehicle that was running, that was in drive, and this person, the state's at a loss to know what it's going to take to make this person stop driving from driving drunk short of killing somebody. And the state doesn't want to have to be here when this person eventually does kill somebody, because this sort of constant drunk driving, that's the only end game. $10,000.
Thank you. Defense?
Yes, Your Honor. We're going to be asking for release to pretrial services here. The reason for that is Mr. Beal has a home to go to. He lives with his father. He's a full-time employed worker. He has worked today. And so obviously I think we're kind of, the ship has sailed on him missing work today, but he would very much like to return to work, return to home, where his father has already indicated his willingness and ability to ensure that Mr. Beal attends all of his court hearings and provides transportation to and from court to ensure that that happens. So, to address the state's concerns here, again, these are allegations that the state is obligated to prove if it can, and it certainly hasn't yet. And so where we stand today, Your Honor, is we're asking for pretrial services with whatever drug and alcohol monitoring pretrial services thinks is necessary to ensure that Mr. Beal is not drinking and that he's not driving. And, with those, with those issues under control, with that sort of monitoring in place, then the community is kept safe here. There's no listed victims, so there's no one in particular that the state need to be worried about or the court needs to be worried about. Here it's a question of the safety of the community and his ability to attend hearings and not be a flight risk. He's got a home, he's got a job, he's got family here in town. He's not going anywhere else, Your Honor, and he's more than willing and able to participate with the drug and alcohol monitoring required of him by pretrial services if the court would be so inclined.
Is there an amount of bond he feels he can post?
If I may have one moment, Your Honor.
And while he speaks to his client, the state would just like to report that while there was no specific victim on this crime, the fact is this person was so impaired, they had to basically pour him out of the vehicle. He was having issues with coordinating balance. He was so drunk that he was not able to stand up straight, couldn't perform any SFSTs or the PBT because he was so incredibly drunk. It's only the defendant's fortunate luck that we're not dealing with somebody who's dead today, because this is not his first arrest for DUI. In fact, it's his fourth.
Thank you. Oh, you're muted.
Sorry, Your Honor. To answer the court's question, the amount that he might be able to pay at this point would be anywhere from $1,000 to $1,500 because of his limited financial circumstances at this time.
Okay, thank you. I'm going to order a bond of $5,000 cash or secured. If you are able to post that bond, sir, you will be released to the custody of pretrial services. You must submit to any monitoring or treatment as directed by pretrial services. No alcohol or illegal drugs. No firearms or weapons. Sir, I'm ordering that you cannot drive. If you are released, you cannot drive at all. Okay? No driving. All right?
How can I get to work?
Oh, it's not leaving. Yeah, I'll get it. That's perfect. Give me 3 minutes.
Your next court date will be April 25th at 1:30 for a preliminary hearing. If you are in custody, the jail will make you available for that hearing. If you have posted bond and are released, then you will be required to appear, that'll be your responsibility, and if you fail to appear, a warrant can issue for your arrest. Do you understand?
Yes, ma'am.
Thank you. You're excused.
Dolly, back. You're next.
So go.
Good morning. Please state your name.
Kelsey Domino.
Mr. Benelli, this is the time for your initial appearance. You're here on new felony charges of possession of drug paraphernalia. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney. I am appointing the public defender's office to represent you in this case. I have reviewed information from pretrial services as well as the interim complaint and the state's recommendation that you be released to pretrial services. I am inclined to release you to pretrial services. Does anyone need to be heard further?
No.
No, Your Honor.
So I will order and
Oh.
is let me just double check here.
Yeah. Your Honor, it seems to be a federal probation hold.
Oh, that's great. This is that one.
So if the court is inclined to, given that he can't be released because of that hold, I would ask for a $50 bond just so that he gets the back time.
Yep, I will order a bond of $50, cash or secured. Pretrial services, if posted, monitoring or treatment as directed by pretrial services, no alcohol or illegal drugs, no firearms or weapons. Your next court date will be April 25th at 1:30. And I can't see right now if this if I should set a step scaring.
I can make this bond right now.
Let me just.
All right, so I'm going over. That bond is there.
Yeah, fixed.
Yeah, I'm trying to speed the shit up. I'm not trying to answer all these fucking questions. Yeah, it's just stupid.
Great. It looks like there's a possibility of steps eligibility. Would you like me to set a steps hearing?
I just told you I'm trying to answer the question. No.
Okay. All right. Then your next court date is April 25th at 1:30 for a preliminary hearing. Thank you. You're excused.
Colin.
Good morning. Please state your name.
Good morning. My name is Colin Bodley.
Mr. Bodley, this is the time for your initial appearance. You were here this morning on charges of disorderly conduct and recklessly displaying a weapon. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney, and I am appointing the public defender to represent you in this case. We're going to talk about your conditions of release this morning, and I have reviewed the interim complaint describing the circumstances surrounding your arrest. I have also reviewed information provided by pretrial services, which lets me know whether you have any previous criminal history.
Which I don't. Right, Your Honor.
It would also let me know if you have any delinquency history. It lets me know if you were able to provide any information about your ties to the community and whether your references were able to verify that information. It also contains their assessments and recommendations. Let's see. And I have also reviewed the state's recommendation. The state is recommending that you be held on a bond of $3,500, and if posted, that you be released to pretrial services. Would the state like to be heard any further?
Your Honor, this person was not just engaged in disorderly conduct, he was doing it with a weapon. And the fact is, Your Honor, the court did mention whether or not he had a juvie record, and the answer to that is yes. So it would appear he's also it may be the case that he's also a prohibited possessor. It's not entirely clear, but that's also a possibility. There's no charge at present, but it is a distinct possibility. And essentially, Your Honor, with his record and that being a violent record, the fact is he's upgrading to being disorderly and violent using a weapon, and therefore the state makes the $3,500 bond recommendation.
Thank you. Defense?
Your Honor, we're asking for release to pretrial services here. Mr. Bodley's a young man. While he has evidently a juvenile record, that's something that is in his past because he's an adult now. He's completed probation. This would be his first felony level offense as an adult. And so I don't believe, absent dangerous nature allegations here, that he would actually be prison only at trial. In fact, I think it'd be the opposite. I think he'd be eligible for probation at trial. And so, here we don't have a listed victim. We've got some conduct that the state has alleged but hasn't proven. And we've got someone who is not a prohibited possessor, not charged as a prohibited possessor, and certainly isn't. Somebody's juvenile record doesn't automatically make them a prohibited possessor, and the state should know that, seeing as they're the ones in charge of charging these cases. And I think that is, in fact, what's been made clear, because there isn't a prohibited possessor charge. And so I would really strongly urge the court to evaluate Mr. Bodley's case and with any initial clearance, with what the charges actually are, not what they may be or possibly could be, or perhaps could have been charged as but weren't. And so, under the allegations the state has made, we've got, somebody who has not, victimized a person that the state has identified. They're not a danger to any individual alleged victim there. This is somebody who is a young man who is to stay. His mother has indicated that she would be more than willing to make sure that he comes to and from his court dates, provide that transportation so he can, remain out checking in with pretrial, participating in his case. This is somebody that doesn't need to be in jail, Your Honor. I think that the supervision of pretrial services is going to be more than sufficient here.
Thank you.
Judge, I would note, while defense was speaking, I did log back into pretrial, and one of his juvie charges was indeed ag assault on a peace officer. And since I don't have ready electronic access to his juvie record, there very well may be a prohibited possessor charge coming. I don't know. But at present, he's also got another for theft. So, Your Honor, he's getting quite a start after getting the proverbial clean slate when he hit 18. He's getting quite a start in demonstrating that he is a danger to the community. Thank you.
Okay. I'm going to ask both counsel to make sure that they just refer to what's necessary for the case, not refer to each other's arguments, and unless absolutely necessary. And remember that I am able to read all of this information. Okay? So I have a couple of questions for defense. Number one, does the defendant live alone or with other relatives or roommates? And number two, is there a bond he feels he would be able to post?
And she can give me rides to the court. And he is living with his girlfriend currently. A month, 5 minutes up the road. And he's just down the street from his family, from his mother, who is, as the court knows, has indicated she's willing to help with transport. As for a bond, we'd be asking for a $500 bond, cash or secured, if the court is going to place a bond. But I would note, Your Honor, we are reiterating our request for pretrial release.
Thank you. So I am going to order a bond of $500 cash or secured. If you are able to post that bond, you'll be released to pretrial services. You must submit to any monitoring or treatment as directed by pretrial services. No alcohol or illegal drugs, no firearms or weapons. Sir, if there are any firearms in your home or in your possession when you are released from jail, you must surrender them. You may not possess any firearms, okay?
Yes, ma'am.
Your next court date is going to be April 25th. That is at 1:30 in the afternoon for a preliminary hearing. If you fail to appear, a warrant can issue for your arrest, okay?
Okay, how does the bond work? Like, they bring $500? Like,
Yeah, there's a couple of things about the defender's office. Richard's attorney. He can explain it to you.
thank you.
You bet.
Thank you, Your Honor.
Cruz, Leonardo?
Please state your name.
Leonardo Cruz.
Mr. Cruz, this is the time for your initial appearance. You are here on felony charges of unlawful use of a means of transportation, tampering with evidence, and aggravated robbery. You have the right to remain silent on those charges. You also, anything you say can and will be used against you. And you have the right to be represented by an attorney. I am appointing the Legal Defender's Office to represent you. We're going to talk about your conditions of release. And then let me look, you've got another. You also have charges regarding watercraft speed restrictions out of another county. And it looks like those were in warrant status. So I'm going to come back to those after we deal with the new felony charges. So in preparing to discuss your conditions of release, I have reviewed the interim complaint, which describes the circumstances surrounding the charges. I have also reviewed information provided about you by pretrial services, which lets me know whether you have any criminal history of any kind, whether you have any, whether you were able to provide any information regarding your ties to the community, and what their assessments and recommendations were. I've also reviewed the state's recommendation, which is that you be held on a bond of $1,500 and if posted, released to pretrial services. Would the state like to be heard further?
No, Judge.
Thank you very much. And defense.
Yes, Your Honor, we're asking for pretrial services release. Mr. Cruz has no felony criminal history, scores very low on the NCA and FDA scales. He's got a job, he's working, he's actually recently moved back to Arizona. And so, there's nothing in his background or nothing in his history that indicate he'd be anything but, a compliant supervisee of pretrial services. It sounds like, he's busy, he's working. Do you have family?
Yeah. Oh, not in Tucson, they're in Phoenix.
Gotcha. So he's got family in Arizona, they're up in Phoenix, but I think pretrial services is more than sufficient here, Your Honor, given his, as what the state has alleged to be significantly lesser involvement in this incident. And, given his history, I think pretrial services is a good fit.
Thank you. And you said he moved back to Arizona. Was he in Arizona before Florida?
Yeah.
Yes, Your Honor.
And did his family remain in Arizona while he was in Florida?
That's correct.
I am, Mr. Cruz, going to give you one opportunity on pretrial services. You'll be ordered to submit to any monitoring or treatment as directed by pretrial services. No alcohol or illegal drugs, no firearms or weapons. I know it's the other person who is alleged to have had a firearm. However, I am ordering that you may not possess any firearms. If when you are released, there are any firearms available to you, you must surrender them to local law enforcement. You may not possess any firearms, okay?
Yes, ma'am.
Your next court date is going to be April 25th. That's at 1:30 for a preliminary hearing at Pima County Justice Court. You are required to appear at that hearing and all future hearings in your case. If you fail to appear, a warrant can issue for your arrest. Do you understand?
Yes, ma'am.
Okay, thank you. You're excused.
How about the other thing? It's not always.
It's a misdemeanor.
Other Yes. So that's actually, so there's a warrant out of that other county. And I believe when you're released here, you would probably be released to that other county, not just out into the community. Let me double check something real quick. Based on what the charge was. Okay. Does the jail have any information about this out-of-county charge? It looks like it came through to the clerk's office as a felony, but
No, it's a misdemeanor, Your Honor. It's a class 2 misdemeanor.
that's what we thought. All right. And I'm just waiting to see if I can get a court date for that case for you. All right. And then do I need to put anything, or you'll make it? So I am going to order that you're released on that warrant. In Wickenburg is going to be April 28th at 9 a.m. 9 a.m. Yeah. Okay. If you fail to appear for that court date, they will likely issue another warrant. Okay.
Yes, ma'am.
All right. You're excused. Thank you.
Thank you, sir. Yeah.
Oh, sorry. Oh, okay. Good morning. Please state your name.
Roy Kale.
Mr. Kale, this is the time for your initial appearance on a couple of different matters. We have charges out of Tucson City Court that were in warrant status for obstruction or refusal. And then we have new felony charges of possession of a narcotic drug and possession of drug paraphernalia. Actually, those are from January. And then new charges, charges from 2023 out of Pima County Superior Court for unlawful flight from law enforcement. I think that's everything. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney on the felony charges, and I am appointing the legal defender's office to represent you. You also have counsel seated next to you for today's hearing. I have reviewed information from pretrial services. I have also reviewed the interim complaint on the possession of a narcotic drug and possession of drug paraphernalia charges. It looks like you may be eligible for STEPS diversion screening. That is a pre-indictment diversion program that involves substance abuse treatment. If you were to be accepted into that program and then successfully completed, it's possible the state would not go forward with these new felony drug charges. Would you like me to set a STEPS hearing?
Yes, please.
So that'll be on April 22nd at 9 a.m. That will be to determine if you are eligible for the program. You'll also have the chance to speak with an attorney about the program and speak with service providers and pretrial services at that hearing. And it looks like the state is requesting that you be held on a bond of $2,500 on the older charge of unlawful flight from law enforcement, for which a warrant was issued for your arrest after you failed to appear. But they would be okay with you being released to pretrial services on the new drug charges. Would the state like to be heard further?
No, Judge.
Thank you. And defense.
Yes, Your Honor, I'd ask just that he be released to pretrial services in the older matter. The reason being, it just makes sense to have him start the steps process as he's held on one case and not the other one. He won't begin the steps proceedings until after he's released in the other case, whenever that may be. So I think the thing to do here, since the state has been willing to offer steps in the new case, would be to release him on both so that he can get that ball rolling, get access to treatment, and deal with his cases while he's going through that process. I will be there. And so for these reasons, Your Honor, I would just ask that you release him to pretrial as well as on the new case as the old.
Let me. So I do have some concerns about your ability to appear for court, sir, and also the danger you yourself were in at the time that you were arrested. Do you have anywhere to go?
I could just stay with a friend. I mean, I'll be in court. I promise. I will.
All right.
I'm gonna, I'm gonna lose everything if I'm out.
So I am going to give you one chance to be released on these charges to pretrial services. If you fail to appear, I'm certain a warrant will issue for your arrest, sir, and that the next time the judge will hold you, given the failure to appear. Your court date for steps is going to be April 22nd at 9 a.m. And then for your arraignment in your older case, your court date will be April 22nd at 1:30 p.m. So that's the same day. At 9 a.m., you'll be screened to see if you are eligible for the pre-indictment diversion program, and at 1:30 is your arraignment for the unlawful flight case. You must submit to any monitoring or treatment as directed by pretrial services. You may not possess or consume alcohol or illegal drugs, no firearms or weapons. And then on the drug charges, same conditions. Your court date for those is going to be 3 days later on April 25th at 1:30 for your preliminary hearing.
Thank you, Your Honor.
And let's see. And that's where the steps hearing is as well, not on the other case. And then on your Tucson City Court charge, your next court date is going to be May 15th at 2 o'clock before Judge Hale for a pretrial conference. I'm ordering that you abide by any previously ordered conditions of release. No alcohol or illegal drugs. And if you fail to appear for that court date, a warrant can issue for your arrest. And sir, when you are released, there is a trailer outside the jail. It's called the Transition Center. You may want to go in there to see if they can help you with any resources for places to stay and situations that may make it more likely that you are able to appear for your court dates. So you now have 4 different dates in 3 different cases. I don't want to see you back here next week, okay?
Yes, ma'am. Thank you.
All right, thanks.
Thank you.
Stay on. Don't see your shirt. Yep. Down the steps, far left side.
Good morning. Please state your name.
Nathaniel Leon, ma'am.
Mr. Leon, you're here this morning on charges of theft of means of transportation. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney. I am appointing the Legal Defender's Office to represent you. We're going to talk about your conditions of release, and I have reviewed the interim complaint. I have also reviewed information provided by pretrial services about you, which includes their assessments and recommendations. It includes any information you may have provided them, and it lets me know whether you have any felony criminal history. I've also reviewed the state's recommendation that you be held on a bond of $10,000, and if you were able to post that bond, that you be released to pretrial services. Would the state like to be heard further?
One moment, Your Honor.
Thank you.
Yes, based on this person, we're looking at, there's a warrant, they're on felony probation, and he has priors. I don't see a known residence. Prison time seems likely, if not mandatory. And also looking at the interim in this matter, what I am seeing is, while there was just theft of means charge, it also looks to be this person was also quite indifferent to public safety by tearing through town, and it was just the state's luck that he happened to almost clip a couple of undercovers. 10,000.
Thank you. Defense?
Your Honor, given that we're looking at a probation hold, I would ask for a nominal bond in this case, if the court be inclined to impose a, say, $5,000 bond. Something that if he does get the probation case resolved, he might have the opportunity of posting the bond and securing his release in this case. Just realistically, he needs to get the back time on this case if there's a probation hold, and it seems likely that there is. So for these reasons, Your Honor, I would encourage the court to impose a nominal bond if the court is so inclined.
All right, I am going to order a bond of $5,000, cash or secured. If you're able to post that bond and nothing else is holding you, you'll be released to pretrial services. No alcohol or illegal drugs. Don't drive without a valid license. No firearms or weapons. Do not have any contact with the alleged victim. Do not return to the incident location. so wherever the car is alleged to have been taken from, and if you do not have a probation hold before you are released, then contact your assigned probation officer on the first working day following release from custody. Your next court date will be April 25th at 1:30. That is for a preliminary hearing, and if you fail to appear, a warrant can issue for your arrest. You understand?
Yeah.
All right, thank you. You're excused.
All right.
Sean? Yes, I meant to tell you that. And then I think I gave Cruz the out date instead of his co-defendant. Right. Counsel, for Mr. Cruz, I think I was supposed to give him the same court date as his co-defendant, and so they're going to change his court date.
Okay.
Take some steps to make sure he understands that.
Well, they've already pulled him out of the room, so that's
Okay, thank you.
so long as the jail tells him and he gets his paperwork, then we should be fine.
All right, thank you. Please state your name.
Rashawn, ma'am.
Thank you, Mr. Rashawn. This is the time for your initial appearance. You are here today on charges of aggravated assault, causing temporary disfigurement, aggravated assault with a deadly weapon or dangerous instrument, possession of a dangerous drug, possession of a narcotic drug, possession of drug paraphernalia, and disorderly conduct with a weapon. These are all felony offenses. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney in these matters, and it is ordered appointing the public defender to represent you. We're going to talk about your conditions of release, and I have reviewed the interim complaint. I have also reviewed information from pretrial services that lets me know if you have any criminal history, what the felony criminal history looks like. If so, it lets me know what information you've provided to pretrial services about your connections to the community, and it also includes their assessments and recommendations. I have also reviewed the state's recommendation, and the state is recommending that you be held on a bond of $50,000 and released to pretrial services if you are able to post that bond. Would the state like to be heard further?
Your Honor, other than it looks like he absolutely sliced open somebody's face. Now, the numbers say a laceration on the left side of cheek of approximately 7 inches, and the wound required 8 exterior stitches and an unknown number of internals. I really hope that that is 7 centimeters, because 8 stitches, this person is going to have permanent disfigurement, not to mention the fact that he re-engaged the victim after the victim tried to get away. She tried to defend herself, the victim, and he also had looks to be upwards of 6 and change grams of meth, as well as some M30s. It's all on surveillance, Your Honor. This person is lucky to be alive, and they're going to go through the rest of their life not only with the psychological damage that this person's attack caused them, but also the fact that, I mean, a 7-inch laceration. This person was essentially, he slashed a new mouth into the side of her face. This is absolutely terrifying that he was, 1, carrying a knife on the bus, 2, was willing to use it, and 3, opened up her face like this. This is amazing. This is terrifying. 50,000.
Thank you. Defense.
One last thing. He is clearly a danger to society. He is clearly a danger to the victim, and he's also has a documented history of failing to appear. This man is a disaster waiting to happen.
Defense.
Yes, Your Honor. I understand the court is likely looking at imposing a bond here. The issue is Mr. Rochon lives on a, did I say it's a Rochon?
Yeah.
Rochon. Okay. Mr. Rochon lives on a fixed income. He receives Social Security checks. He's not in a position where he could afford anywhere close to what the state is asking for in terms of a bond. I understand the allegations are serious. It's certainly a difficult position for Mr. Rochon to be in, as well as the alleged victim, obviously. But the fact of the matter is that that 50,000 is far and above his ability to afford. Like I said, this is an elderly man. He's retired. He's living on Social Security. I ask that the court takes that into consideration here and coming to whatever bond number the court arrives at. This is somebody who is of very significantly limited financial means, and I think needs some support out in the community. And so the only way he's going to get that is if he has the opportunity to be released at some later date, either through a bond or revisiting the release conditions. And so, be that as it may, Your Honor, I'd ask for a significantly reduced bond such that he might be able to afford.
That's, yeah, 20.
I'm going to order that Mr. Rochon is held on a bond of $25,000 cash and secured. If he's able to post, he'll be released to pretrial services. He'll have to submit to monitoring or treatment as directed by pretrial services. You may not possess or consume any alcohol or illegal drugs. You may not possess any firearms or weapons. If there are any firearms in your possession, you must surrender them to local law enforcement. Your next court date is going to be April 25th at 1:30. This for a preliminary hearing. If you fail to appear, a warrant can issue for your arrest. Do you understand?
Yep. 63 years.
Sure, the record shows March 20th, 2024 for an arraignment and a warrant issued, and you were arrested and released to pretrial services on a different matter, and then that you failed to appear on May 6th, 2024 and a warrant issued and then was later quashed. All right. You're excused for today. Thank you.
Yeah.
Good morning. Please state your name.
Rhodes.
Ms. Rhodes, this is the time set for your initial appearance on a couple of different matters. You have new felony charges of arson and endangerment. And then you also have a charge of assault, which was in warrant status out of Tucson City Court. That's a misdemeanor charge.
I'm sorry, I have a charge of assault.
Yes.
Since when?
That's
I see. I show that this charge is from 2023 and that you did appear in custody on May 13th of 2023. You were released on your promise to appear, and then you did not appear for your next.
That can't be right, considering I was in.
I'll stop you there and say that you have the right to remain silent on all of these charges. Anything you say can and will be used against you. You have the right to be represented by an attorney in the felony matters, and I am appointing the legal defender's office to represent you in those matters. Today, we're going to talk about your conditions of release.
Okay.
I have reviewed the interim complaint, which describes the circumstances of the arrest for the new felony charges.
Okay.
And then I am also reviewing, if it will let me, the information provided by pretrial services.
Okay.
Let me try to start that over again.
Yes.
All right, so that did come up, and so that lets me know whether you have any felony criminal history. It lets me know whether you were able to provide information about your ties to the community and such things as that, or any references that you were able to provide, and it lets me know their assessments and recommendations.
Okay.
And then I was also able to review the recommendation from the state. The state is recommending that you be held on a bond of $25,000, and if you are able to post that bond, that you be released to pretrial services.
Thank you for that. This many times.
And would the state like to be heard further?
Your Honor, this individual, let me pull up this person set fire to her own property, causing $100,000 damage, allegedly, in the apartment building and put 20 families out of their homes due to damage to the overall building. That's a risk to the community any day of the week, bar none. We have a history here. There is misdemeanor records. We're looking at, given all of the charges, we're looking at an F2, and I wouldn't be a bit surprised if there are additional ones, but either way, she doesn't have a residence because it went up in smoke. We're worried about both risk to the community and a flight risk, Your Honor.
Thank you.
Thank you. No, I was good. No, I was just good.
Thank you. Defense, do you need a moment? Just
If I could, Your Honor.
You can take a moment. Make sure to mute.
I can afford that. There's nothing that I have no kind of income.
Okay, Your Honor, I think we're ready. Thank you for giving us that opportunity, by the way.
Sure.
So we're asking for pretrial services release here. I think it's very clear that this was a difficult situation for everybody involved. And I think that what's clear here is that Ms. Rhodes, could probably benefit from, the supervision of pretrial services to make sure that she continues to participate in her case. And one thing that we spoke about is getting access to behavioral health or substance abuse help while she's out on pretrial release. And I think that that's going to be, obviously to her benefit, but it is to the community's benefit as well, because she's going to be someone who is going to have that supervision, have that additional access to resources and services that it sounds like are necessary here, so that she can continue to participate in her case. I will say she's not a flight risk here. She is somebody of limited financial means. She's currently not working and is dealing with health issues. And so for these reasons, Your Honor, I think that pretrial services is going to be more than sufficient to ensure her cooperation and participation in her case, and keep the community safe as well.
It seems to me that probably some fairly intensive treatment is required for Miss Rhodes, but it also seems to me like there's a very significant danger to both the community and probably to herself if I simply order her released here today.
Can I just say something briefly?
Rise against.
Do you think you know what your client wants to say, counsel, or do you want another moment to speak with her?
If we could have just a second.
Behavioral health.
All right. So what Ms. Rhodes and I were just discussing is she's been to Palo Verde before. She's had a really great track record at some of these behavioral health homes that she's been at. She wanted to go to Palo Verde. That's what she wants to do. She wants to get out of Tucson. And so those are, some additional reasons, Your Honor. I think Palo Verde would be a good fit. She knows exactly what she needs to do to seek treatment and seek help, and she wants to take those steps and to do that. The problem is she can't do that if she's held in the Pima County Jail. She can't begin that process truly unless and until she's released. And so we're asking that you do that now rather than keep her in and her have to start that process at some later date.
And Your Honor, the state would like to be heard on that point.
Well, I'm not going to order release to pretrial today. I do think that I need something to be in place a little firmer than this. So I'm going to order a bond of $10,000 cash or secured, released to pretrial services if posted, monitoring or treatment as directed by pretrial services, no alcohol or illegal drugs, no firearms or weapons. I don't know if there's anything left of the apartment building and if anyone's able to go there. I'm going to order that you're not allowed to have any contact with any of the alleged victims and you're not allowed to return to the incident location. If there is an opportunity for you to pick up any belongings that may still be at that location, then you may return one time with a law enforcement escort to retrieve those belongings. You'll take my court order to the nearest police station to do that, if that's a possibility. And your next court date is going to be April 25th at 1:30 in the afternoon. For the for these charges. And you'll have an opportunity to work with counsel to make other arrangements, if appropriate, and see if the court will approve those at a future date. On your Tucson City Court case, I am going to order a bond of $25 cash or secured, possess or consume no alcohol, commit no acts of domestic violence, no contact with the alleged victim in that case, and that person is Eugene Kennedy. So no.
I don't even remember that.
Right. No contact with Eugene Kennedy. Do not go to his residence or workplace. And I am appointing the City of Tucson Public Defender to represent you in that case. And if you remain in custody, your court date will be April 25th at 1:45. If you are released prior to that, then your next court date for Tucson City Court will be May 12th at 2 p.m. Either way, that's with Judge Maldonado. Okay? If you fail to appear for any court dates after being released, a warrant can issue for your arrest.
What does this mean?
Thank you, Judge.
Thank you. Yes, please. Good morning, sir. I think the jail is still muted, but once unmuted, would you please state your name?
Joseph Sepulveda.
Thank you. You're here this morning for your initial appearance on charges of possession of a narcotic drug for sale, possession of a dangerous drug for sale, possession of a weapon by a prohibited person, possession or use of a weapon in a drug offense, and possession of drug paraphernalia. These are all felony charges. You have the right to remain silent on all of these charges. Anything you say can and will be used against you. You have the right to be represented by an attorney, and I am appointing the Public Defender's Office to represent you in this matter. We're going to talk about your conditions of release today, and I have reviewed the interim complaint describing the circumstances surrounding your arrest. I have also reviewed information provided by pretrial services. That lets me know whether you have any felony criminal history, and if so, what that looks like. It also lets me know any information you were able to provide about your connection to the community, and it also contains their assessments and recommendations. The state is requesting that you be held on a bond of $50,000, and if released to pretrial services. Would the state like to be heard further?
Yes, Your Honor. Search incident to arrest. This defendant was allegedly found with just shy of 400 grams of methamphetamines, a stolen handgun, a little over 5 grams of heroin, 11 grams plus of M30s, $400, almost $500 in small bills. He is a convicted felon out of New Mexico. We have every reason to believe that he was dealing, that he was armed, and Your Honor, we consider he has ties to New Mexico. Clearly, he is a flight risk and is likely, given the quantity we're looking at here, looking at mandatory prison time, and based on that, state made its recommendation.
Thank you. Defense?
Your Honor, I'm asking for a a bond of 25,000. I know that the court is likely to impose a bond in this case. The thing I'd like to point out is Mr. Sepulveda lives in New Mexico. He's a New Mexico resident, and so he doesn't have any ties here. And so, you know, in some sense, he's disadvantaged on that point, that he doesn't have someone here that he could be released to, or that he could talk to about negotiating his release and securing his bond. It's going to be people from New Mexico who are going to have to find a way to, post his bond and try to get him out. I understand the allegations that the state has brought are quite serious. I will say, though, that, his financial circumstances are what the court needs to also take into account and weigh versus the allegations here. And Mr. Sepulveda is in no position, or is anyone in his family in any position, to post a $50,000 bond. And so for these reasons, Your Honor, I'm asking you to consider a $25,000 bond, which will allow him to, actually pay an amount that is a significant amount for him in his circumstances to secure his release, participate in his case, whether that's here in Tucson or in New Mexico, travel with whatever the trial court may or may not allow, but allow him that opportunity to potentially secure his release, return home to his family, and participate in his case in a manner that the court sees fit. So for these reasons, I think that 25,000 is a number that Mr. Sepulveda might be able to afford and secure his release.
Thank you. So I am going to order a bond of $35,000 cash or secured. Pretrial services, if that is posted, no alcohol or illegal drugs, no firearms or weapons. You must surrender any firearms that are in your possession if you're released. Your next court date is going to be April 25th at 1:30. That's for a preliminary hearing. If you fail to appear, a warrant can issue for your arrest. You understand? Thank you. You're excused.
Smith.
Good morning. Please state your name.
Anthony Smith.
Mr. Smith, this is the time for your initial appearance on charges of unlawful possession of a narcotic drug and unlawful possession of drug paraphernalia. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney, and I am appointing the public defender's office to represent you. We're going to talk about your conditions of release, and it looks like you may be eligible for the STEPS pre-indictment diversion program. That is a program that involves substance abuse treatment. If you are accepted into the program and successfully completed, it is possible the state will not go forward with these charges. Are you interested in that program?
Yes, ma'am.
All right. And the state is recommending that you be released to pretrial services, so I am inclined to release you to pretrial services. Does anyone need to be heard further?
No, Your Honor.
Thank you. So you will be released to the custody of pretrial services, required to submit to any monitoring or treatment as directed by pretrial services. No alcohol or illegal drugs, no firearms or weapons. Your next court date will be that steps hearing to determine your eligibility. That's on April 22nd at 9 a.m. Pretty sure you only get one shot at that, so make sure you appear for that hearing. And then we need to set a preliminary hearing as well. Usually that needs to be set within 20 days. However, to give time for your eligibility for the STEPS program to be assessed, and if appropriate for you to begin that program, would you waive the 20 days to 45?
Yes, ma'am.
All right, so we will set your preliminary hearing for May 30th at 1:30. If you are accepted into the diversion program, it's likely that hearing will not go forward. However, if it does go forward and you fail to appear, a warrant can issue for your arrest. You understand?
Yes, ma'am.
All right, thank you. You're excused.
Brian Velasquez.
Good morning. Please state your name.
Brian Velasquez.
Mr. Velasquez, this is the time for your initial appearance. You are here this morning for failing to return rented property. That is a felony offense. You have the right to remain silent. Anything you say can and will be used against you. You have the right to be represented by an attorney. I am appointing the Public Defender's Office to represent you. We're going to talk about your conditions of release today, and I have reviewed the interim complaint describing the circumstances surrounding these charges. And I have reviewed information provided about you by pretrial services. That includes whether you have any felony criminal history, and if so, what that looks like, whether you were able to provide information about your ties to the community or any references to verify your information, and the assessments and recommendations by pretrial services. The state is requesting that you be held on a bond of $2,500 and if released to pretrial services. Would the state like to be heard further?
No, Judge.
And defense?
Yes, Your Honor, we're just asking for release to pretrial services. Mr. Velasquez has no failures to appear. This is not a violent crime. This is not a DV crime or any sort of physical altercation. This was, as the state alleges, failing to return a U-Haul that had been rented. And so, clearly, Mr. Velasquez is not a flight risk. He lives here in town. He's not a danger to the community. I think if the court were to order him not to engage in renting property, don't have any contact with U-Haul, I'm sure that would be sufficient to ensure U-Haul safety, from any sort of other alleged crimes related to this sort of incident. And so for these reasons, Your Honor, I think pretrial services is enough, given the lack of failure to appear history and the non-dangerous nature of this offense. The lack of real criminal activity on the part of Mr. Velasquez, I think is, pretrial services is a good fit in this case.
Thank you. Mr. Velasquez, I am going to give you a chance to be released to pretrial services. You'll be required to submit to any monitoring or treatment as directed by pretrial services. You may not possess any alcohol or illegal drugs. You may not possess any firearms or weapons while you're on release for this offense. You may not have any contact with the alleged victim. Do not return to the incident location, and that would be the U-Haul location. Your next court date is going to be on May 5th. That is at 1:30 in the afternoon. That is for a preliminary hearing. It's possible that court date will change, so stay in touch with your attorney. If you fail to appear for a future court date, a warrant can issue for your arrest. Do you understand? All right, thank you. You're excused. Thanks, you too. That's all I have. Does anyone have anything else?
No, Judge. Good day.
Thank you, Judge.
Back, Mr. Poston.
Thank you. Spain was beautiful.
Sure it was. Have a good one, everyone.
coger el papeleo.
Interpreter, would you mind asking if anybody else needs your services, and if they do so, ask them to raise their hand.
Yes, Your Honor. ¿Alguien más aquí ocupará interpretación en español? ¿Alguien aquí no habla inglés? Levante su mano o diga su nombre.
No. Thank you so much, interpreter.
Thank you, Your Honor. Have a good day.
You too.
Thanks.
And did our FOJ get the paperwork to read?
Yes, Your Honor.
Okay, thanks. All right, for the rest of you, I'm going to call you in individually. You'll state your name and date of birth. I will tell you what you've been booked on and whether an attorney has been appointed to represent you. I'm also going to give you the date of your next court appearance. I will let you know whether you're eligible for a bond or not. If it's a secured bond, that means you can go through a bonding company. Phone numbers for the various bonding companies are located in that jail area. You can call any one of them. They will accept collect calls. If it's a cash bond, then you have to pay the entire amount of the bond. I'm also going to tell you if I've set any release conditions, like no contact with the alleged victim or no going back to the alleged scene of the crime. You need to follow each and every condition if you want to remain released. Let me remind you, if you've been ordered by a court not to have contact with a victim, and then you do so, you may be charged with an additional felony. Now, when you come into the courtroom, please be aware this is all being video recorded. So do not talk about the facts of your case, as you have the right to remain silent. As you leave the courtroom, you're going to get your paperwork from the court staff. That's going to show you what your charges are, whether you were appointed an attorney or not, where, when, what time your next court date is going to be, whether you're eligible for a bond or not, and then it'll have a list of all your release conditions. The purpose of this hearing is to determine whether you're eligible for a bond or not. That is determined by your any failures to appear, your past criminal history, your current charges, and Arizona law. It's not based on personal information, so don't go into that. All right, can we have Antonio Lopez come on in the courtroom?
Come on down, Antonio Lopez.
Counsel, you can come up to the podium.
James, but I can't see. It's like far away. James, what's going on?
And counsel, it's my understanding this is just a limited appearance.
And the screen's backwards, James. The screen's backwards.
Okay. Sir, state your name and date of birth.
Come closer. Before here.
My name is Antonio Lopez, Jr., and my date of birth is February 15th of 1977.
Okay, and counsel?
Good morning, Your Honor. Belén Olmedo Guerra on behalf of my client who is in custody standing at the podium. And this is a limited appearance for this hearing.
What did you say?
It's a limited appearance for this hearing.
Yeah, okay.
Brooke Vaughn on behalf of the state, Your Honor.
Okay. Sir, you're here on a Superior Court new case alleging one count of murder in the second degree, class 1 felony, one count of possession of dangerous drugs.
Can you guys help out
They
Robin?
have it as a class 2.
Can you guys
It
sub
should be a class
Robin?
4. Counsel, do you have any objection of me dropping that to a class 4?
No, Your Honor.
And that is to benefit you, sir. It is a benefit to have a lower class felony.
Thank you.
Okay. Now, I am going to appoint you an attorney. But if you work something out with your counsel here to represent you, that's fine.
Unlimited?
You have the right to do that.
So she's only
You just
representing
wanna
him right
make
now,
sure
not
that
for
you have
future.
an attorney at your next court appearance. Counsel for the state, did you want to be heard?
Yes, Your Honor, the state's asking for $1 million cash-only bond.
Damn!
And if Mr. Lopez is able to post that, we'd ask for electronic monitoring. That request is based on the serious nature of the charges. Our understanding is that Mr. Lopez is transient. We have some concerns that he may have some mental health issues. A firearm was involved. Mr. Lopez allegedly shot and killed the victim.
Whoa.
There is a strong weight of evidence. There were multiple witnesses, and Mr. Lopez has made admissions to law enforcement. Our understanding is that he has a listed residence in the state of Michigan, so he may have ties to that state. We believe that he's an extreme danger to the community. Additionally, that he presents a flight risk. Thank you.
That escalated quickly.
Counsel for Mr. Lopez.
Mr.
Yes,
Lopez.
Your Honor. So Antonio actually has all community ties here in Arizona. As a matter of fact, his brother is here in the building watching this hearing from another room. Antonio lived just a few blocks from the alleged place of the incident. He had 13 years of sobriety, and unfortunately, there was an event in his life where he lost that sobriety. And so now he has been,
I think he has bigger problems than that now.
under the influence of various drugs in the last 4 months. So this relapse has turned his life upside down, having been stable and so good for so long. As the court can see, there is the recommendations from the state, and they graciously gave me a copy. Their own analysis indicate that while he does have misdemeanor convictions, he does not have any felony priors. He is not a flight risk. He definitely has to work on his sobriety again. And unfortunately, some of the statements that he may have said were under the influence. He will still continue to detox and come down from what is affecting him. I do understand the state's fear that something else would happen in the community, but I think here the clear issue is that he needs to get a handle on his addiction. And so putting $1 million cash, that is going to make it even more difficult for him to be able to get to a facility. So given the fact that not only his brother but his mother are also helping, Antonio has 5 children who are waiting for him, also being cared by family, and he has 2 other sisters. Everyone is here in the Phoenix area, in the community. So they're worried sick about him. Obviously, they're mortified about all these allegations. They want to help. They want to help him get on his feet. They want him to be able to get treatment. So for all those reasons, Your Honor, I ask the court that consider not putting $1 million cash. Typically, $1 million cash is asked for first-degree murders. This is charged as a second degree. There's no premeditation here.
Okay.
We don't know. The other
We'll make it
individual
99
also
then.
seemed that he was transient as well. And so we asked the court to lower that to $500,000 secure place. Thank you, Judge.
And if you guys are on TT, if you guys could do me a favor and if you guys could give Robin a follow, she's trying to get to 50 subs. Would highly appreciate that. I'm gonna try to find her name and pin it so you guys could.
Counsel, I don't know
help her
where
out.
this information came from, but in the Form 4, it indicates that his residence is homeless.
Oh, that sounds pretty bad. You need some
And then it
promethazine.
says Berrien Springs, Michigan.
Judge, while he may have a driver's license with an old address that he may have gone out of town
Thank you for that.
and come back, he was living a few blocks away from the alleged place of incident. And since starting going to use drugs again, he has been transient, like I already mentioned. But he does have a home with his family, his brother, his mother, his children, and his sisters. So he
I misread
is
your
not
comment,
from
Robin.
Michigan. Everybody's here. So I do understand that he does have a driver's license with a Michigan address, but that's not where he intends to go. He needs to go to rehab, and his resources are here. His community ties are here. The $1 million bond is usually something that is put for first degree premeditated, which I've handled many of those hearings here. And I do understand the state's concern, but even the scoring, the criminal activity score from pretrial services, that indicate that his scores are pretty low. The failure to appear score is a 2. The new criminal activity score is also in the lower range. He's a 3.
Okay.
Thank you for that.
Well, I will tell you the final recommendation is max from pretrial services. Also, I've seen a lot higher than $1 million on first degree. Usually it's 2.5 to 3. I am going to follow the state's recommendation. I'm concerned that, even if he was to get in treatment, most places don't have locked facilities. He is a danger to the community. I don't know why he wasn't with family prior to this incident, but I am going to
Judge, would the court consider doing it secure?
No, I'm going to impose a cash bond of $1 million. His next hearing will be a status conference, April 21st at 8:30. Anything else from either counsel?
No, Your Honor, thank you.
Nothing further from defense.
Counsel, did you want an opportunity to talk with your client?
Yes, thank you.
You can go with that.
So limited appearance means that I think this is what they mean. I think it means that they only hired the lawyer for this appearance. They're not hiring her for future appearances or the trial. He unalived somebody.
Tyler Richardson to the chair outside the courtroom.
So this is off to a bumpy start, if you will.
All right, sir, state your name and date of birth.
Rudy John Anthony Reyes, 11/9/1994.
Okay, you have 4 matters. We'll take them one at a time. The first one is a Tolleson Municipal Court warrant for one count of disorderly conduct, Class 1 misdemeanor.
I'm not sure about take K.
Lawyer to represent you. Your next hearing will be arraignment.
Excuse me, ma'am. I didn't
It just started a few minutes ago.
You what?
I finished the Tolleson case. I signed for it while I was.
It's a failure to pay.
Failure to pay. I don't have a job to pay.
It's probably on some fines or
I just
fees.
barely got a job this week recently.
Okay. Your
Thank you
next
for that.
hearing will be on April 21st at 8:30 for an arraignment. And I'm going to impose a $100 cash bond. Okay?
My local time is located right
I'll tell
above
you why
in green.
I'm imposing these
That's what that
very
clock is
low
for.
bonds on this. Okay? When we're all said and done on this. Now, the next one is another Justice Court warrant, and this is going to be from Arcadia Biltmore Justice Court. This is for one count of DUI with a blood alcohol content of 0.08 or more. Class 1 misdemeanor. This is another failure to pay. I'm appointing a lawyer to represent you. Your next hearing is going to be an arraignment, April 18th at 8:30. They had asked for a $493 bond, reducing it to $100.
Thank you.
Then you have a municipal court, another one from Tolleson, for one count of disorderly conduct, Class 1 misdemeanor.
It's
I'm appointing a lawyer to represent you. Your next hearing is going to be an arraignment, April 21st at 8:30. And again, I just dropped it to $100.
Thank you, ma'am.
Now, you have a Superior Court new case. This alleges one count of child or vulnerable adult abuse, Class 4 felony. One count of unlawful imprisonment. One count of resisting arrest, Class 6 felony. One count of an assault. 2 counts of threat. Those are Class 1 misdemeanors. One count of an assault, Class 2 misdemeanor. I'm appointing a lawyer to represent you. Your next hearing is going to be a status conference, April 21st at 8:30. Now, you are out on release on some other felony charges.
Yes, I just finished a trial recently.
Yeah. So because of that, you're out on release on a felony pursuant to Arizona Criminal Rule of Procedure 4.2A7A. You must be held no bond. That's a rule of procedure that Arizona has. I cannot release you. But you do get a chance to fight that with your attorney. And that's going to be at an evidentiary hearing on April 22nd at 1:30. Now, the reason I just put $100 bonds on those others is sometimes some of the courts will give you credit for time that you are incarcerated against those fines. If I just OR'd you on them, you still would have to stay and you wouldn't get any credit on those. Does that make sense?
Yes, ma'am.
Okay. So that's why I dropped all those bonds, just so you would have an opportunity to get credit against those bonds.
Okay. And,
Okay.
So maybe the earliest that I would be able to get out is the 22nd.
The earliest you could get out would be the 22nd.
I missed my son's birthday. Okay.
All right, get your paperwork.
I hate when that happens.
Tyler Richardson, come on in. Benji Temple to the chair outside the courtroom. Sir, state your name and date of birth.
Tyler Edward Richardson, and it's 7/12/1994.
Okay, you have two matters. The first one is a Superior Court new case alleging one count of possession for sale of dangerous drugs, one count of possession for sale of narcotic drug, both class 2 felonies, one count of possession of dangerous drug, one count of possession of narcotic drug, one count of theft of means of transportation, all class 4 felonies, one count of possession of drug paraphernalia, class 6 felony. I've appointed a lawyer to represent you. Your next hearing will be a status conference, April 21st at 8:30. Set a $10,000 bond on that.
Oh my God.
Now, the next one is you've got a probation violation. 4-year probation that you're on for a class 6 felony. Probation is now
that guy just moan?
You violated your probation by getting new charges.
He's a
Called
moaner.
Term 1 violation. I've appointed a lawyer to represent you. Your next hearing will be an arraignment, possible disposition.
What the what?
April 22nd
Put your hand there,
at
buddy.
8:30.
What are you holding on to?
Arizona
You're holding on to
Criminal
dear
Rule of
life?
Procedure 7.2C, going to be held non-bailable.
What the what?
Get your paperwork from the court staff.
Can I say something?
Uh-huh.
I had nothing to do with that vehicle being stolen.
What?
I had nothing to do with the vehicle that got stolen.
Okay, talk to your attorney about that. Benji Temple, come on in. Andrew Fortune to the chair outside the courtroom.
Pobrecito.
Sir, state your name and date of birth.
Benji Temple, 1270.
You have a Superior Court probation violation warrant for your probation that you're on for class 3 felony. Probation is alleging you violated term 2, 3, 4, 5, and 15. I've appointed a lawyer to represent you. Your next hearing will be an arraignment, possible disposition, April 22nd at 8:30. Pursuant to Arizona Criminal Rule of Procedure 7.2C, you'll be held non-bailable. Get your paperwork from the court staff. Andrew Fortune, come on in. Michael Giannis to the chair outside the courtroom.
Damn it.
Sir, state your name and date of birth.
Andrew Fortune, 01/31/1990.
Okay, you've got a Superior Court probation violation warrant for your probation that you're on for class 6 felony. Probation is alleging you violated term 3, 7, 14, and 15.
Oh, not 15.
I've appointed a lawyer to represent you. Your next hearing will be an arraignment.
It's on. I got it running on YT.
April 22nd at 8:30. Pursuant to Arizona Criminal Rule of Procedure 7.2C, you'll be held non-bailable.
Fill up
Get
the
your
Franco.
paperwork from the court staff. Michael, come on in.
Come on down to the Price is Wrong. If
And
you will.
Mario Alvarado Herrera.
15, dang. I don't know what 15 is. I'm just messing around,
Here
Chad.
outside the courtroom. Sir, state your name and date of birth.
Michael Thomas Janice, January 13, 1990.
You have a Superior Court probation violation warrant for your probation that you're on for a Class 3 felony. Probation is alleging you violated Term 15. I've appointed a lawyer to represent you. Your next hearing will be an arraignment, possible disposition, April 22nd at 8:30. Pursuant to Arizona Criminal Rule of Procedure 7.2C, you'll be held non-bailable. Get your paperwork from the court staff.
Damn, what's up with that was tank top?
Alvarado Herrera,
Jeez.
come on in. Talbot
He's
Bennett,
dressed up like
to the
he's ready for
chair
4th of July,
outside the
and
courtroom.
we're only in April.
Sir, state your name and date of birth.
Mario Alvarado Herrera, 12/21/1990.
All right, on this case, I did receive, review, and consider a victim statement.
Damn, James, you're
You're
cold.
here on a Superior Court new case alleging one kind of aggravated taking ID to gain employment, Class 3 felony, and one kind of forgery, Class 4 felony. I could not find you indigent based on your financial affidavit. So you can do one of two things.
Does that guy have a Spider-Man
Hire your
shirt
own
on?
attorney, or
Or is
give
he
the
Spider-Man?
next judge more information about your finances. Anything
Are you on Twitch?
that you owe, or
Yes, I
credit
no,
card
I
bills,
was.
or
My
things
phone
like
died.
that.
Fox Racing.
Your next hearing will be a status conference, April 21st at 8:30. I've set a $10,000 bond. Absolutely no contact with the alleged victim. No using anyone else's social security or information. Got it?
Okay.
I'll
Get your
try to
paperwork
minimize
from the
on
court
that.
staff. Talbot Bennett, come on in. Vanessa Reyes,
I knew it was a Fox shirt.
to the chair outside the courtroom. Sir, state your name and date of birth.
Talbot Bennett,
Love your streams, thank you.
05/07/1978.
You have a Superior Court new case alleging one kind of possession for sale of narcotic drug, one kind of possession for sale of dangerous drugs. Those are both Class 2 felonies. One kind of money laundering, Class 3 felony. I've appointed a lawyer to represent
Baby
you. Your
Huey.
next hearing will be a status conference, April 21st at 8:30. I've set a $7,500 bond, cash. If you post that bond, you've got a list of conditions you're going to have to follow. Get your paperwork from the court staff. Vanessa, come on in.
Thank you, Your Honor.
Tyrell Teller, to the chair outside the courtroom. State your name and date of birth.
Vanessa Beth Reyes, 10/16/85.
All right, you have 4 matters. The first one is a Tolleson Municipal Court warrant for one kind of shoplifting, Class 1 misdemeanor. And when you didn't go to court, you get a new charge of failure to appear.
Damn it.
That's a Class 2 misdemeanor. You'll have a lawyer appointed for you at your next hearing, which will be an arraignment, April 21st at 8:30, set a $100 bond. Then the next one is a Superior Court new case alleging one kind of possession of narcotic drug, Class 4 felony, one kind of possession of drug paraphernalia, Class 6 felony. I've appointed a lawyer to represent you. Your next hearing will be a status conference, April 21st at 8:30. I've set a $900 bond. Then the next 2 are both probation violations. You're on probation for 2 Class 1. No, one is a Class 6, one is a Class 1 misdemeanor. Probation is alleging you violated terms 1, 3, and 5. Nope, but they're both Class 1 misdemeanors. Sorry, I got ahead of myself there. Yeah, they're both Class 1 misdemeanors. Probation is alleging you violated only term 1 because you got those new charges we just talked about. I've appointed a lawyer to represent you on both of those. Your next hearing will be an arraignment, possible disposition, April 22nd at 8:30. set a $900 bond on each of these. If you post these 4 bonds, you must contact your probation officer within 72 hours. Okay? Get your paperwork from the court staff. Terrell Teller, come on in. Jennifer Behrens to the chair outside the courtroom.
All right, all right. Hey, I'm pretty sure she got the scare of her life when she told her that she had a felony. Hey, James, can you please remove F2P from the TK? I'm on it. Hold up. What site is this? I can't tell you, Cody D. Lang.
Sir, state your name and date of birth.
Terrell Teller, 4/11/2000.
You have a probation violation warrant for your probation that you're on for a Class 6 felony. Probation is alleging you violated term 1, 3, and 5.
1, 3, and
5.
5.
I've appointed a lawyer to represent you. Your next hearing will be an arraignment, possible disposition.
Thank you,
April
Chad.
22nd at 8:30. Set a $900 bond. If you post that bond, you must contact your probation officer within 72 hours. Get your paperwork from the court staff. Jennifer, come on in. Jerry Beach to the chair outside the courtroom. Ma'am, state your name and date of birth.
Jennifer Louise Behrens, 10/11/79.
All right, you've got 3 matters. The first one is an El Centro Justice Court warrant for driving while license suspended, canceled, or revoked. That's a misdemeanor. Then when you didn't go to court, you get another charge, failure to appear. That's also a misdemeanor. I've appointed a lawyer to represent you. Your next hearing will be an arraignment, April 18th at 8:30. They had asked for a $500 bond. I reduced it to $100. The next one is another Justice Court warrant from West Mesa Justice Court for exceeding the speed limit by 20 to 45 miles per hour. That's a misdemeanor. One kind of driving while license suspended, revoked, or canceled. Also a misdemeanor. And when you didn't go to court on these charges, you got another charge of failure to appear. That's also a misdemeanor. You'll have a lawyer appointed for you at your next hearing, which will be an arraignment, April 18th at 8:30. They had asked for a $650 bond. I've reduced it to $100. Then lastly, you've got a Justice Court warrant from San Marcos Justice Court for, again, driving while license suspended, canceled, or revoked. Misdemeanor. When you didn't go to court, you get a new charge of failure to
Mario
appear.
Kart.
That's also a misdemeanor. I've appointed a lawyer to represent you. Your next hearing will be an arraignment, April 18th at 10 a.m. They had asked for a bond of $250. I reduced it to $100. Get your paperwork from the court staff.
Thank you.
I'll guarantee you, if you don't go to court next time, your bonds are going to be pretty high.
So are you saying I have to pay $300 and I can get out of jail today?
And then you better go to court.
Thank you for that.
Oh, I have every intention to. Me not going to court this time was, I didn't have the information to go to court. My cell phone was broken. And all of the information for the court was gone. I had no way. I've been trying to find the information to get it cleared up because I already got one of the warrants cleared up.
Where were you looking for
that on the 24th. I just couldn't find the information to go to court or the information for the court. I've asked the police officers for the information the couple of times I've talked to them, but nobody would give me the information. It wasn't that I didn't want to go, and it's that I...
They didn't want to give her the information.
Always call the courts.
I didn't know which court it was.
My phone was broken.
I
just told you.
Even if you look online, it doesn't even show I have a warrant.
Can we watch?
You got 3 of them. All right, good luck to you.
Thank you.
Jerry Deach, come on in. Joshua York to the chair outside the courtroom.
Hey, TK, I got TK running on YT.
September 19th, 1977.
You have a Superior Court new case alleging one kind of possession of narcotic drug, Class 4 felony. One kind of possession of drug paraphernalia, Class 6 felony. I've appointed a lawyer to represent you. Your next hearing will be a status conference, April 21st at 8:30. Set a $500 bond.
She was playing Where's Waldo with her court date.
If you post that, you've got a list of conditions you're going to have to follow. Get your paperwork from the court staff. Joshua York, come on in.
Thank you.
Sir, state your name and date
Guilty.
of birth.
Joshua York, October 22nd, 79.
You're here on a Superior Court new case alleging one kind of aggravated harassment, Class 6 felony. I've appointed a lawyer to represent you. Your next hearing is going to be a status conference, April 30th at 8:30. Let me tell you, I really agonized on this. County
She
attorney
sounds real torn up.
requested a $10,000 bond. And I almost went with that.
But you doubled it.
I didn't. But
you tripled
this
it.
is allegedly a long history going on here. I don't want you to say anything.
Okay.
Say it.
But when I look at your criminal history, you have nothing.
Well, if that's the case, Your Honor,
just wake-up call.
Let him out at
We're going
OR.
to release you on an ankle monitor.
Sheesh.
Absolutely no contact with the alleged victim.
Yes, ma'am.
No email, no texting,
Okay.
no social media, no having somebody else call.
Scout's Honor, Your Honor.
Anything like that.
Okay.
You think about their request for $10,000. What are they going to do? How much are they going to request?
Okay.
If you violate my order, and you'll get another charge.
Okay.
Another new felony.
No, it won't happen again.
All right, get your paperwork.
Thank you.
Hold it. I'm appointing a lawyer to represent you. And then your next hearing. Do not miss it.
Okay.
April 30th at 8:30.
Oh, yes, ma'am.
All right, get your paperwork.
Thanks.
Matthew Delfino.
He'll be back. He'll be back by the end of the week. I know the type. I know the look.
Joshua York to the chair outside the courtroom. Sir, state your name and date of birth.
Matthew Delfino Tinkle, November 14th, 2006.
Did he say Tinkle?
You have a Superior Court new case alleging 2 counts of false report for an emergency, Class 6 felony. I've appointed a lawyer to represent you.
Oh, yeah, I would have changed my name.
Again,
My name would have been changed.
really thought about a high bond on this. You've got nothing. No prior history of anything.
Sure, let this guy out too. Don't tell me they were stalking that lady
Your next
together.
court hearing is going to be a status conference, April 30th at 8:30. I'm going to release you to the supervision of pretrial services. Have you been suspended from the school?
No.
It varies. It varies. It could be anywhere from days to weeks, months, or years. If this guy just got arrested, so he's probably been in custody maybe like, I would say maybe like 6-7 hours, but that's just a guess on my part. Hey Jessica, thank you for the follow. Highly appreciate that. He looks scared. Yeah, but scared enough not to want to come back and reoffend. That's the real question. He hasn't even made it into. He hasn't even taken a shower going into county jail. Me. Thank you for the follow. Twinkle,
All right,
twinkle,
so what
little
I'm going
star.
to write here is, as long as you're not suspended, you can return to school. No contact with the alleged victim. Do you understand that?
Yes, ma'am.
He looks like an internet
All right,
creeper.
they're going to bring you your paperwork. Don't miss court either.
She's
They'll bring you
emailing
paperwork, okay?
you. Fuera.
Corey Roche, come on in. Alexis Elliott to the chair outside the courtroom.
I see that guy walking the
State
same
your
aisle as
name
me.
and date of birth.
I'm
Corey
switching
Roche,
aisles.
April 25th, 1995.
You have a Superior Court new case alleging one kind of aggravated domestic violence. That's a felony. one kind of criminal damage, one kind of disorderly conduct, both misdemeanors. I've appointed a lawyer to represent you. Your next hearing will be a status conference, April 30th at 8:30. I'm going to release you on your promise to go to court.
Yes, ma'am.
Absolutely no contact with the alleged victim.
Yes, ma'am. And I have a question. Sometimes they say I can't return to the scene of the crime. What is the scene of the crime? So I know not to return there.
Okay, I didn't put that in.
Okay.
But what I said is you can't have any contact with the alleged victim.
Got it.
But if you were living together and the victim is there, you can't go there because you can't have any contact.
I understand.
But you do have the ability to have a civil standby. That's at the
like a sheriff
bottom where law enforcement will meet you there and you can get your belongings.
Okay.
Okay, get your paperwork.
Thank you very much, Your Honor.
Miss Elliott, come on in. Kayla Ruiz Harrier to the chair outside the courtroom.
Alexis Elliott, 62298.
Hang on. Go back. I want to do another one first, if that's okay. Do we have Kayla here?
Yes.
She is? Let me do Kayla.
Okay.
We need to clear her too.
James looks relaxed. I'm about to fall asleep.
State your name and date of birth.
My name is Kayla Elizabeth Ruiz Harrier, and my date of birth is January 14, 2000.
You have a Superior Court arrest warrant alleging one count of using an artifice to facilitate shoplifting, Class 4 felony. I've appointed a lawyer to represent you. Your next hearing will be a status conference, April 21st at 8:30. I'm also setting an evidentiary hearing on April 22nd at 1:30. Pursuant to Arizona Criminal Rule of Procedure 4.2A7A, you must be held no bond because you were on release at the time that this occurred. But you have an opportunity to challenge that no bond. That's going to be at the evidentiary hearing, April 22nd at 1:30. Okay?
Can I say something?
Yeah.
It's a little personal, but my grandfather, he's dying from cirrhosis.
Say it louder.
It's a little personal. My grandfather, he's dying from cirrhosis of the liver. He raised me. He's my father, and I want to spend time with him before he goes. There's no way I could do probation or something like.
There is nothing I can do about it. It's shall. But, I mean, you can...
You cannot shoplift.
22nd, so in a week, you'll have another hearing on it.
All right.
All right.
It's like, I don't, like, hold on. Did your grandfather, did that just happen to him right now while you were in court? Or was that when you were out there on the streets, doing your thing, if you will?
Can I have Lester Yazzie come on in?
Judge, when you're ready, the juveniles online as well.
Like, hey, I'm not trying to be insensitive, but come on, like, let's keep it real here.
Are they in a hurry there, or can I do this one? Okay. Sir, state your name and date of birth.
Lester James Yazzie Jr.
Not the cookies.
5/19/1986.
Okay, so you've got a warrant here from the state of New Mexico.
I was here yesterday for it.
Do we know that?
I don't remember him. Does anybody remember him from yesterday?
Did you waive?
I remember what I did 15 minutes ago.
I didn't sign the waiver.
You did not?
No. Was it in my best interest to sign?
Is there more than one?
No, it's just one.
He was here yesterday?
It's for probation violation out of San Juan.
Okay, so why don't you go back in there? We're going to check. Can you check, Katrina?
I don't remember what I did 30 minutes ago.
Go ahead and hold it up so they can see you.
All right, now how am I going to see you? I know. Have a seat.
Next. Kelly, thank you for the follow. SJ, thank you for that daily heart. Highly appreciate that.
Okay, is there something I need to click to be able to see them?
Hey, Nick, thank you for the follow. Be like Nick. Follow, hit that follow button. It's free 99. Doesn't cost you anything. Don't trip. I'm not going to be asking for gifts. I'm not going to ask you for the last 4 digits of your social security number. I'm not going to even ask you for a Cash App donation, but I will ask you for that follow. It's free 99. Don't be a Mr. Krabby Patty. Don't be a Scrooge Mick. Oh, that sounds pretty bad. Yuck. Hold it. Your Honor, you better go get that checked out real quick. I'm no doctor, no specialist. I do watch. I used to watch Doogie Howser, so I might know a thing or two about a bad cough, if you will. Get some get some Ricolas. Let me see. 4323 is the last 4 of my social security. Says you didn't ask. Oh man, thank you.
Okay.
Well, alrighty then. Not Doogie Howser. Hey, James, do you have any parole boards? Hey, not today. I'm not sure. You might not know, but they're really putting their foot on my neck with these board of parole hearings. They kicked me out of Iowa today, and then we have the whole situation with Connecticut. So it's all bad. Who stole their lungs? I gotta figure something up. So what do you do? I don't know. That's the question. But tomorrow we should be having Kentucky. So be on the lookout for Kentucky. What's the deal with TK? He got found guilty of, and right now they're in the sentencing phase, if you will. Thank you for that daily heart. You see why in Iowa? I don't even know. I just went and as soon as they were going to start, they removed me from the meeting. They didn't say nothing. They just booted me. I sent them a message to find out what's going on. James needs a disguise. Shave that stash. I'm gonna get the glasses. I'm gonna get the glasses with the nose and the mustache. On YouTube, right? Yeah.
Is there a reason why I can't move this?
Are you paying bails? Hell nah. We just moved to the next one, James. Follower por vida. Gracias. Hey, Jaime, gracias for the follow. Dwayne, thank you for the follow. Is AZ ever does that to you? I'm protesting at the courthouse. Let me see. We get you a curly and wig. Fam.
I'd be lost without it.
What's CT trying to cause? Technically, all right. It's FOI. Yep.
Are you D'Angelo?
Are you going to cover the Karen Reed trial?
All right. Can you tell me your name and date of birth, your full name?
D'Angelo, signed Zachary 11/21/2007.
Where the hell's the individual at? I don't see nobody.
All right. So you are an adult court here.
Oh, there he is.
Do you have an attorney with you?
Oh, shit, hold up.
No, I don't think so.
Okay. You have a Superior Court probation violation warrant.
Who is this vato?
Probation. You're on probation for a Class 6 felony.
Oh, I never seen this judge before.
Probation is alleging you violated terms 3, 5, 7, and 15. I'm going to appoint a lawyer to represent you. Your next hearing is going to be an arraignment, possible disposition, April 21st at 8:30. And pursuant to Arizona Criminal Rule of Procedure 7.2C, you're going to be held no bond. You can't bond out. All right? And you're going to be held in our adult facility, in the adult jail. I think you're probably going to have a hearing at 1 o'clock. Is that your understanding?
What does food do?
So his juvenile charges that he was brought in were FI'd, and so he's eligible to be picked up at this point in time. We just had to have the hearing first.
Okay. He should be brought over here then.
He's getting tried as an adult.
Getting transport scheduled for him.
Okay, thank you.
FI'd, I don't know. That's a new one for me.
All right, are we finding anything out on our FOJ? We're done here.
Okay, thank you.
Thanks.
What the what? What just
The
happened?
one he was seen on yesterday. 744, and then here it says he has a second warrant. That's the one that he's seen.
That's the one here, okay. All right, come on in,
Come on down to The Price is Wrong.
Lester.
I don't know about the name Lester.
Okay.
All right, so there was 2 warrants. Yesterday you were seen on contempt of court.
They didn't.
Contempt.
This one is another one, second warrant, and this is...
Contempt for what?
I don't know, I didn't see you. I don't know. But this is for your probation violation. So, let me go through this with you.
Indeed.
You have a choice to make at this time. You've got 2 choices. One, you can waive your right to an extradition hearing and be sent back to New Mexico within 30 days. Option number 2, you can demand an extradition hearing and that a governor's warrant be signed by the governors of both states, Arizona and New Mexico, before they can send you back to New Mexico. Now, if you choose to waive your right to an extradition hearing, you will be held non-bondable in the Maricopa County Jail for a period of up to 30 days to allow time for New Mexico to come get you. That 30 days would start tomorrow as long as you do not have any criminal charges pending against you anywhere in Arizona. If you do have criminal charges pending against you in Arizona, the 30-day period would not start until those charges are resolved. Now, if you say, no, I want to fight this, and you want an extradition hearing, I'm going to set that, and your next hearing would be on April 28th at 1:30.
I went through this process.
In our court hearing, let me finish all this. In our court building, Superior Court, I cannot appoint an attorney to represent you because extradition matters are civil in nature, but you would have the right to hire a lawyer at your own expense.
This is like 51st dates.
You are not entitled to bail. It's no bond because this is a probation violation. A governor's warrant signed by the governors of both states requiring to extradite you can take up to 90 days. Do you know what you'd like to do?
I told you guys yesterday.
I went through this yesterday. The same thing you're saying. I wasn't here for contempt of court.
Well, that's not what the paperwork that we have.
It must have been a wrong paperwork because yesterday I came in here, the judge said the same thing you said, gave me the same white big paper that they gave me, and told me the same thing you're telling me. I don't know what the contempt of court was. Maybe that was...
Okay. Well, you can ask the next judge, but at least right now, there's another warrant. This paperwork says you have 2 warrants from the state of New Mexico.
He's going to have another contempt of court.
So you know what you'd like to do.
I'll just wait for New Mexico to come and get me within 30 days.
So you want to waive your right?
Sure.
Okay, before I can accept that waiver, I need to ask you some questions to make a record of this. Did you read the waiver of extradition paperwork?
Yeah, I read it yesterday.
Yes?
I said yes.
Okay. Do you understand that you don't have to sign the paperwork? You can fight it.
I know I don't have to sign it. I just want to be out of here in 30 days.
Okay. Do you understand that you have the right to have an extradition hearing?
That's going to be on the 21st.
No, you won't have a hearing on this one if you waive your right.
They'll come get him from New Mexico. Hell yeah.
I ain't signing nothing. I'm just here to wait the 30 days for them 30 days to come get me.
He didn't sign it?
Yesterday, no.
He didn't sign any paperwork?
No, he got a court date.
So he'll still have that, but on this one, if he waives, you won't have a hearing on this one. You'll still have your hearing on the other one.
I think he's Native American, so
Okay.
he was here
You
before everybody
understand that
else.
You have the right to hire
ICE
a
ain't
lawyer
coming for
at your
him.
own expense.
Yes.
Do you understand that you have the right to demand that a governor's warrant be signed by the governors of both states before they can return you?
News update, they were here before everybody.
Do you want to give up these
Natives.
rights and sign the paperwork?
For what?
To waive your right to an extradition
I'm
hearing.
not going to sign anything.
Well, then I can't accept your waiver. Then you're going to stay here longer.
Like 90 days?
Could be up to 90 days, yeah.
Fuck. Excuse my language.
Oh,
You
I like
either
this. Where
have
this is
to
going?
sign it
I like
and
where this
agree
is
to
going.
waive your rights, or we're going to go through the process of having both governors review all the paperwork.
Right, Taurus?
I'd rather just sign it and get out of here. This county sucks.
Okay. So, do you understand? Do you want to give up the rights and you have to sign the paperwork?
I just told you I was going to sign it.
Okay. Have you had any drugs, alcohol, or medication within the last 24 hours?
I was getting irritated.
No.
I find that you're knowingly, intelligently, and voluntarily signing
that
the
one.
waiver. I'm also going to sign it. I'm going to direct the sheriff's office
contempt.
to notify New Mexico that you're ready to return. Requesting state, New Mexico will have 30 days from tomorrow to pick you up unless you have local charges pending.
See, I have court in Mesa. They had OR'd me.
If you have local charges pending, the 30 days will not start until the conclusion of that case.
Yeah, but they don't know I'm in jail. That's the thing.
Who doesn't know you're in jail?
Mesa, they had OR'd me on them cases. I got out. I was waiting to go to court there. I got stopped by the cops. They told me I had a warrant. They brought me here. So Mesa don't know I have these, that I'm here. So now they're going to put out them warrants, and now it's
all messed
a
up.
big hectic situation, and it's getting frustrated.
All right, I can
commit
see
crimes.
You're frustrated on that. Are they misdemeanors in Mesa?
Yes.
Okay. And do you know when your court date was on that?
Yesterday, but I was here. Today, but I was here. Tomorrow, and of course I'm going to be here.
You had court 3 days in a row?
Yes, I was arrested. I just recently lost my sister about 3 weeks ago.
Okay, sorry to hear
And
that.
so I went and I just got in a lot of trouble.
Okay.
Better call Sal Bateman.
If those get dropped, or if you do a plea,
This is a
they'll
job
know you're
interview.
Here, you can tell court staff to notify Mesa that you're here. And
he's
then
gonna throw
what
something.
you can do
He wants to
is
break
see
something.
if you work something out with them and tell them you're going back to New Mexico.
I don't really know
All
what
right.
again. This jail sucks. You know that, right?
Job interview.
All right, I need you to come
What up,
over
my
here.
homeboy?
Because you're going to have to
Thank
sign
you
it.
for that daily heart.
If you don't sign it, then you're going to be here longer.
Ay, ay, ay. He's big mad. Hey, don't ever get locked up. It's not fun. It's not as fun as it seems on TV. Trust me, it's really boring, real frustrating. Did he just walk away? Hey, does anybody know what time he came on yesterday so I could look up his clip from yesterday? I don't remember. I don't remember seeing him yesterday. That's how bad Maricopa County Jail is. How many times did he have to say, please let me leave? I want out. Towards the end, I want to say, but on the 11 o'clock or the 8 o'clock?
Yes.
Or 5 o'clock? He wants to. He looks like he wants. I wouldn't want to be around him. Just by the way he's breathing, I could tell something's about to go down. It seems like he wants to do a Hulk smash. They're making him sign 3 times because he signed too fast. What did he do? I don't know what he did.
Right on this calendar, we also have some house calls. Tracy Furco, date of birth is 4/12 of 91. She's a house call because of bizarre behavior. She's got a Superior Court new case alleging 2 counts of aggravated assault, class 4 felony. Can I see those? 3 counts of resisting arrest, class 6 felony, 1 count of criminal damage, class 2 misdemeanor. I've appointed a lawyer to represent her. Her next hearing will be a status conference, April 21st at 8:30, set a $3,600 bond. Then we also have Frank Ellis.
The judge, she is sick.
Thank you.
She sounds sick.
Date of birth 1/7 of 82. He has 2 matters. He's combative. His date of birth is 1/7 of 82. Can you take him back so we can clear?
Where's Melissa?
He has a Superior Court new case alleging 1 kind of aggravated assault, class 4 felony, 1 kind of interfering with judicial proceedings, 1 kind of criminal damage, class 1 misdemeanors.
Maricopa
I've
County.
appointed a lawyer to represent him. His next hearing will be a status conference, April 21st at 8:30. Set a $5,000 bond. Then he also has a probation violation warrant for his probation that he's on for a class 4 felony. Probation is alleging he violated terms 6, 7, and 16. I've appointed a lawyer to represent him. Next hearing will be an arraignment, possible disposition, April 22nd at 8:30. Pursuant to Arizona Criminal Rule of Procedure 7.2C, he'll be held non-bailable. Alexis, come on in.
Alexis, oh, this is going to be bad. J.A., if you have ever been abused, you probably want to leave now.
Name and date of birth.
I don't know what it's going to be, but this is going to be bad.
6/22/98.
Okay, you have a Superior Court new case alleging 1 kind of child abuse, class 4 felony. I've appointed a lawyer to represent you. Your next hearing will be a status conference, April 30th at 8:30. I'm going to release you to pretrial services. Now, other than the alleged victim in this case, do you have any other children? How many?
1.
1?
1 under a year.
Thank you for that, Daily Heart.
And is that child with their father at this point?
Yes, but he's incapable of taking care of him. He is trying to ask my parents for help.
Well, I'm ordering you can't have any contact with any children. At least till this gets resolved. Was the child placed with the father?
I don't know anything at this.
Is it the same father as the alleged victim?
Yes.
Okay. So at this point, I'm going to order no contact with any children. Now, I did put in the order that if DCS, Department of Child Safety, if they figure out that you can have supervised contact, then you can do that.
Okay.
All right? Don't miss your court date, April 30th, and get in contact with your lawyer. I've appointed a lawyer to represent you.
Sorry, I have 2 lawyers. I have one for DCS and now this, so that's why I wasn't sure.
I have appointed a lawyer on this criminal matter.
Okay, thank you.
All right. Do you have our paperwork? Okay. And then lastly, we have Robert Jones.
Oh,
He's
no.
a house call because of a suicide watch.
What?
His date of birth is 5/19 of 77. He has 2 matters. A justice court warrant for failure to appear in the 2nd degree. That's a misdemeanor. He didn't appear for his violating a watercraft numbering requirement. That's
Watercraft.
also a misdemeanor. I've appointed a lawyer to represent him. His next hearing will be an arraignment, April 18th at 8:30. I've set a $50 bond. And secondly, he's got a municipal court new case alleging failure to obey a police officer, class 1 misdemeanor. He'll have a lawyer appointed for his next hearing, which will be an arraignment, April 17th at 9 a.m., and I set a $100 bond.
Hey, that's crazy.
Okay, I think we're done here.
Did you guys catch
We
that?
go off the record.
So for a boat, he's in jail, and some people can't handle jail. Did you guys hear what he wanted to do to himself? Everyone, tap on the screen. We have almost 600 in here. Hey, don't go anywhere. We're gonna go ahead into Florida right now, if you will. Damn, James, we're going to Florida now. Yeah, we're gonna go to Florida. Hold on to your. Hold up. Damn, James, you got all these courts on speed dial. You're sick, James. You are sick, my friend, James. Let's see, we're in Florida now. Can't hear nothing, James.
13152. Formal charges have been filed. Pretrial is set for May 15th. With regard to 24 CF 10443, formal charges have been filed. Pretrial is set for April 22nd.
Are you asking that I revoke his conditions of release?
James, where do you find all these courts at?
Yes, Your Honor.
There we go. There we go. Sir, you have to back up off me. You're way too close for comfort, if you will. Here we go. Here we go.
Those are pretty serious charges. I'm going to revoke his conditions of release.
James whispering to himself.
2023 CF 13152AO and on 2024 CF
if you will
10443AO. Those are in divisions 12 and 17 respectively. Mr. Pierre can address those conditions released with those judges. And he has counsel on those cases already.
Let me raise it up a little bit so you guys could hear.
All right, next I have Keono Polchis.
Keono Pochis? James streams in a nutshell. What did I just read right there? Florida, Mike. I never heard that one before.
Mr. Polchis has a new law violation.
Can you file my taxes?
In 2025 CF 4567, which is driving while license suspended or revoked as an habitual traffic offender.
Oh, traffic offender.
It came in with a bond of $2,500. Based upon the charging affidavit, I'm going to find probable cause. I'm going to stay the bond at $2,500.
Oh boy, interesting.
No alcohol, no drugs without prescription, no driving without a valid driver's license. Now he was out on condition of release.
Yeah, we are.
On a DUI from 2021.
2021. This is Orange County, Florida.
DUI never resolved. Do you know, state?
Because it's a VOP, Your Honor.
Violation of parole or violation of probation, if you will.
Oh.
James is magical.
So he was
like
so
Abe
this
Lincoln.
New law violation didn't violate him.
No, it was already a VOP.
Okay.
Huh, interesting. Like my wife would say.
All right.
Interesting.
It says, bond amount not applicable. So was he out on bond on that, or? I'm a little lost as to. He apparently was sentenced on the DUI sometime after November 4th of 2021. And he violated, and that's been pending this whole time? Sure.
It's just the speakers for this court, they suck. So I've kind of raised it as much as I can without blowing up my system over here. Hey, what up?
Looks like he's got a return date on the VOP in April.
Yeah, it's a status hearing, Your Honor.
Huh.
Huh. Interesting.
Well, I've got DUIs that are older than 2021 in my division. You know what I'm going to do is I'm going to take no action on the VOP. It's an old case, and I think that the judge in Division 80 is going to sort that out. Mr. Polchis, did you want me to appoint the Office of the Public Defender to represent you?
Yes, sir.
Yes, sir.
Looks like it's $2,200 a month. He qualifies for the PD. Yeah, with one. All right, I'm going to appoint the Public Defender's Office to represent you. I'm going to take no action on the 4-year-old, 3.5-year-old DUI, and I've set conditions of release on the new charge.
Next. Don't ever go to jail in Florida.
Okay, next is Amanda Ramos.
That doesn't look like Amanda.
That doesn't look
or
like
is
Amanda
it?
Ramos. Is that Marcus Wiley?
Yes, sir.
Mr. Wiley. All right, Mr. Wiley.
What happened with Ms. Ramos?
All right, Mr. Wiley is charged with aggravated battery on a pregnant person.
Ooh. Awa.
Pursuant to a warrant signed by Judge Schaefer.
Hey, is that a Florida thing? Because yesterday we heard a bunch of them in Polk County. There was a bunch of these over there.
All right, well, I'm on to Mr. Wiley, and I'll come back to Ms. Ramos. Judge Schaefer's warrant has no bond. State, what's your position on bond on the charge of aggravated battery on a pregnant person?
The flushing is hilarious.
Is he entitled to a bond, and do you have a recommendation as to same?
This is
He is entitled to a
Orange
bond,
County.
Your Honor, as it is a violent offense, at least an F3. State would ask for $5,000.
All righty. I'm going to, having found probable cause, I'm going to stay the bond at I'm going to set the bond in the amount of $5,000. I'm going to require that the defendant have no contact directly or indirectly with the victim of this alleged offense, nor any witnesses, not consume any alcohol, no drugs without prescription, no alcohol or weapons.
He laid his hands on on somebody
no
pregnant.
Contact directly or indirectly. I don't know whether these folks are residing together. If they are, they shall maintain separate residences. Now I'll appoint the Office of the Public Defender to represent Mr. Wiley.
Thank you for that, Daily Heart. Highly appreciate that.
Also has the violent felony offender special concerns detainer.
I advised him that he has the hold for probation.
Thank you for that, Daily Heart. Highly appreciate that. And don't forget to hit that follow button. It's free 99. Doesn't cost you anything. Don't be a Scrooge
and you said
McDuck.
Ms. Ramos has decided she don't want to see us today?
Don't be a Mr. Krabby Patty. Hit that follow.
Defense will waive, Your Honor.
It's free
She's
99.
charged with possession of more than 20 grams of cannabis.
Taco night in LA County. Hell yeah.
She
Shoot
qualifies
it.
for pre-trial release.
She does qualify for pre-TR?
Yes, Your Honor, and she's the co-defendant, so I asked for a pretrial release in that.
Thank you for that, Daily Heart.
Okay,
Highly
this
appreciate
is the one
that.
that the state warned me
A
about.
Krabby Patty.
It's a co-defendant. I think I released the co-defendant.
Yeah, pretrial releases.
Pretrial release.
Pretrial release.
I'm going to require, so I'm going to release her on pretrial release. She's not to consume alcohol or drugs without a prescription, no weapons or firearms. I'm not going to restrict her. to
Thank you
not
for
having
that,
contact
Crab.
with the co-defendant,
Robin.
although, I will caution her through her lawyer that she's going to want to be very careful.
I think
Not to get in future trouble.
he's a male.
With that person, and I'm going to.
Or maybe a female. I can't even tell anymore. Confused.
Co-defendants, my understanding is that there'll be a motion filed in the division where this exists, which is Division 14, and RCC may be appointed. Is that what happens? I don't do it here. It's handled elsewhere?
Yes, Your Honor. Correct.
All right, that makes
Sounds
perfect
kind of
sense to me.
feminine.
All right, I am out of piles of paper with paper clips on them. Madam Clerk, is that all there is for me to say grace over, as Judge Arnold used to say? All right, state anything else between now and tomorrow that we need to address?
Nothing from the state.
From the defense?
Nothing from defense, Your Honor.
From pretrial release?
No, Your Honor.
All right, we will be in recess until tomorrow.
Hey, what up, Gino? All right, hold up. I'm going to find another court. Does anybody know of any courts going on right now that we could possibly check out, if you will? Let me see here. Let me fix the audio before I go somewhere else, because not people are gonna complain. James, my eardrums blew out. I can't hear nothing. Well, you remember you were telling me you couldn't hear nothing, so I adjust the volume, and that's why you don't got no eardrums anymore. So I gotta readjust it. Hold up. So hold your horses before I start busting out eardrums, if you will. Let me bring down the volumes a little bit, just a tad bit. Springfield, Missouri. Let me see. Springfield, Missouri. Let's see what it is. Hold up. Let me see here. Okay. Let me minimize this here. Okay. Let me get this over here. And I'll bring it up on the screen right now. Let me see. About LA, Louisiana, or Los Angeles? Los Angeles doesn't do. They don't do virtual court hearings. I wish they did. Court. Let me see. Try Kansas City. They have court. They do? Kansas City, you say? Hold up. Kansas City. Kansas City, Missouri. All right, so I'll check those two places for Missouri. Let's see. All right. Wizard of Oz. Let me see here. Remote virtual court hearings. Let's see. Table of contents. You see, I'm looking here. It looks like they do. They might have some in, but I'm trying to find some places don't make it easy to connect. Let's see, Kansas City. See 10. Find your courtroom virtual hearing. Blah blah blah. Video custody docket. Let's see here. Do we got something here? Join from the browser. Don't have me sign in. Oh yes. Let me see. Why allow while visiting my camera? Never allow. When I show my face. Let's see here. I don't think Kansas is gonna work. Maricopa County, please. Maricopa just ended. You missed out on it. Saline County. Let's do custody hearings. Where are they at? Let me see. Don't do the crime. You can't do the time. Vegas? Nah, Vegas. I've looked them up. They don't. Tennessee. Let me see. Atlantic County, New Jersey. Oh, Jersey Shore. I'm missing the parole board hearings. Man, tell me about it. Check Portland. Memphis, Tennessee. What about King County, Washington? New Jersey? Harris County, Texas. Oh, okay, hold up. Let's see here. Gotta go get my eyes checked. Texas live streams. They might be on lunch right now, though. Fort Wayne, Indiana. Portland would be good. That would be Ocean County, New Jersey. Follow the you snooze, you lose. Keep them notifications on. Let me see here. Boyd. Oh no, they got the TK trial going on right now, still on Texas and Bexar County, Michigan. Iona. Oh, Iona. I've heard of Iona County, but I don't remember from where. Let me see. Man, you guys. Dallas, Redding, California, Dallas, Texas, Orlando, Florida. Damn, you guys got a lot of requests. Let's see. They are breaking the TK. Okay. Remote. State of videos, quick cards. Join with access code. I got no access code. Charlotte, North Carolina. Perump? I don't think they got anything out there. Hey, you want to get some fireworks for sure. Let me see here. Calendar for the home page. Instructions. Let's see here. I'm still looking over here. I'm looking. Let me see. What's this here? Man, I wish Colorado, we could do Colorado, they have a bunch of, they have their system set up pretty good, but they don't allow it. I think Indiana doesn't allow it either. Let me see here.
Also have applied for her at least 4 or 5 colleges.
They don't allow recording in Indiana, so I'm staying out of Indiana. Indiana's going to be a no-go, if you will. Damn, it's already 12:33. Shit, what am I doing with my life? It's all bad. Criminal docket 133. Nope. Then if you get a residential proxy, is that state, they can deny you, I believe. I'll be right back. All right, all right. Let's see what else. What time is it in Tulsa right now? Tulsa, Oklahoma? Supposedly there's supposed to be one starting at 1:30, but are they Central Time? Is it 2:30 or 1:30 over there right now? Okay, they're we missed that one already. All right, thank you for that. 2:30. All right. Where is this at? Where the hell is this taking us? What time is it right now? It's 12:34. So, well, my time, it's 12:34. Your time, your mileage might vary on your side. I clicked on a Zoom meeting. Oh no, that's the wrong one. $234. Oh, so right now it's he has done CT before. Well, just the board of parole hearings, but they've been tripping. I'm telling you, like that not being able to go to the parole board hearings is it's really messing us up. It's really messing everything up. I really don't appreciate it, to be quite honest with you guys. Strictly prohibited. Kiss my ass. Strictly prohibited. Oh, that's annoying. Ay, ay, ay. Let me see here. It's like I got so many links. Remote. Work calls messing with my James time. I'm ready to quit. Don't do that. Don't do it. Don't do it. So I know somebody had asked me for Cook County. I looked them up, but Cook County does not. You cannot stream in Cook County. CI live stream, Texas virtual. Open in a new tab. And the next Arizona one doesn't start until 2 o'clock. Let's see what's going on in this one right here. We got our Zoom. South Carolina, Tri Johnson County. Hey, thank you for the follow. You know what? San Diego, they do offer virtual, but you can't stream them. So that's the only thing that messes me up with a lot of places. Some places don't allow it. Thank you for the Adams County, Colorado. Colorado, they do, but like I said, they're also blocked. Utah, Hale County. Where the hell is Hale County at? Never heard of that one. '17th Circuit. Put Judge Call out. James, remember. New York, I think is another one that they're on Nashville Superior Court. See, even Sacramento, they have them. They offer them in Sacramento too, but Michigan, pick one, James. I'm trying. It's just some of these they're out east, or they're closed for the day, or I can't stream them because they are not streaming friendly. Oakland County, Ohio. Let me see. I'm gonna try Ohio. Oh, no, I found one for juvenile court. Yeah, we won't be doing juvenile court. New Jersey shows that 4 counties. New Jersey? Which counties are those? Let me see. So I'm on the New Jersey courts. Let me see. Sussex and Union. Let me see. Morris detention. Let me see. The unauthorized use. Yeah, it's not gonna happen here in this one in New Jersey. She's live now. Judge Boyd. Oh, she's back? Okay, let me go back. Let me go jump on Judge Boyd. Just looked in El Paso County in Texas.
So hey everyone, in this video we are taking a look.
Oh, wrong one. Let me see here. Stephanie Boyd. All right. Yeah, I think they're still on break. They still haven't started up yet for Judge Boyd. Hey, what's up? How's it going? Let's see. Oh, you're talking about El Paso. El Paso. Let me see. What was it? Where's that message for El Paso? It's gone. I don't see it anymore. Oh, here it is. El Paso, Texas. Wanted to make sure I didn't get it was in El Paso, Colorado. I'm gonna know somebody there for sure. We're all waiting patiently. You don't have any from MC for NC? Nah, I don't. Be quiet and vámonos ese.
All right.
Oh, hold on. I hear something. I think Judge, she's back already.
Yeah, I'm ready.
All right.
John.
All right, Dr. Fabian,
Yes.
We're going to start in just probably about 5 minutes whenever you all are ready. All right, if you'll bring him out and we will get started.
All right, so we're gonna go with Judge
All
Boyd.
right, can you let,
We just stepped out as you were walking in. I assume he'll be right back.
all right, thank you.
We're back from our break.
Okay. No problem.
All right, so just to give you guys a heads up, so I'm probably gonna be on for maybe like about 30 more minutes or so, and then I got some other prior commitments I gotta attend to. But before that, I want to go ahead and thank you guys for tuning in. What are we watching now, James, if you will? So right now we switched on over to Judge Boyd. She should be back. She said 5 minutes, but sometimes when they 5 minutes, it might turn into a little bit longer. Were y'all watching it earlier? Nah, we weren't. We just got on right now, if you will. What do you mean? You got other things to do? I got a life. You know what I'm saying? I wish I could be right here all day. If I was making the money to cover my mortgage and all that good stuff, then I would be here. But it's not a reality for me, if you will. But you guys go help out with that if you guys want to help. Watching my videos, reposting them, dropping comments. It definitely helps me get into the algorithm. I'm not asking for any money. I'm just asking for a Are you coming back later? Yeah, for sure. I'll probably be back at
And Sean, I'm signing the documents you sent.
for sure I'll be back for Pima County and for Maricopa, so that's 7:00 p.m. my time. Being, let me see, TikTok shop. I love the TikTok shop. But yeah, no, I do appreciate you guys. Drop the merch. I'm working on that right now. As a matter of fact, that's something I gotta do. I gotta work on also. What time zone? I'm LA time zone. So my local time is right here in the back. It's 12:46. I subscribe to the. Hey, thank you, Nana. Highly appreciate that. Let me see. Hey, thank you for the follow. Is that Jose? Jose Ruiz. Gracias. Let me see. We want merch if you will. Hey, I got all the tools right here so I can start working on some merch. So I'll let you guys know as soon as I get the first demo up.
And Dr. Fabian, you're still under oath. Defense, you may proceed.
Thank you. Appreciate that heart.
Doctor, I think when we
hope Ashley's on tonight.
On the break, we were just discussing to the jury about adolescent brain development and the order in which the brain sorts of develops. But I guess, do I understand the gist of what you're saying to be that a 16-year-old's brain has not fully developed?
That is true. Yes. So the adolescent brain is more geared towards the limbic area, the emotional area of the brain.
This is interesting.
The prefrontal cortex is still developing here. We just call that more of the brakes on the brain related to executive functioning, problem solving, planning, decision making. So then,
hey Lynn, thank you for subscribing. Highly appreciate that. I just saw that. Thank you.
Breaks in the brain.
Yeah, this is TK.
And a lack of self-control, lack of full brain development is going to be pertinent to delinquency.
And that would be the case generally, whether someone has had a traumatic childhood or not.
Yeah, that is correct. Yes.
So what happens when we combine the multi-factor traumatic experiences you've discussed here today with finding someone at that moment in time of having an adolescent brain?
So when we're looking at human behavior and delinquency, violence, it's multifaceted. So it has to do with, developing brain, impulse control issues, frontal lobe is not fully developed. However, there are other factors involved in a case like this, and that's just really, that gets back to some of the early childhood risk factors we looked at. There's also like criminality in the home, substance abuse, just a lack of stability. And eventually around this time, it's my understanding he was running away from home because his father, there was abuse in the home. And so then that's when he was developing, more of these connections with other similar age peers. And that was when he was becoming more delinquent and then getting into serious trouble regarding these cases at age 16.
Yeah, a lot of what you've talked about seems to be about early childhood and
it is.
When a child's, say, maybe 10 years old. What happens when there's abuse and trauma in someone who's 15 or 16 years old?
Well, it's more of the same. And, at different times of his life, it's hard for me to always know exactly where he was living with who. And that really goes to this instability in his life. And so there was just different caregivers, different cities, and you get a little dizzy trying to know exactly where he was living and with who he's living with. So there was physical and emotional abuse going on around that age 15 by father. And unfortunately, he was not living at that time with his grandfather, which again, that home provided more stability and structure. And so the process of trauma, abuse, neglect certainly can be developmental even through adolescence.
Now, Doctor, I want to shift gears for a moment. I want to ask you, are you familiar with the the psychological and pharmacological effects of the drug LSD?
Somewhat. I know, yeah, I know what type of drug it is, and I think I'll stop sharing here. Okay.
Can you tell the jury a little bit about that drug and what it does to the human brain, to the human body?
Well, okay. Basically, you know, the drug is a hallucinogen, and it can make the individual psychotic, and it, you know, to lead to hallucinations, and
I've never tried that.
It can lead to delusions as well, paranoia, and it also can affect the area of the brain where you know, more of the striatal area of the brain, where there's just different emotional processing, I'd say.
Can it have lingering effects after the acute intoxication has subsided?
It can. That depends a bit more on how frequent the drug was used. That would be my first answer. You know, when did this individual start using the drug, and how frequently, how much in quantity, and did they experience, you know, what did they experience as far as side effects of that drug in the past?
Okay.
Yeah, he's in the white
I also want to
turtleneck.
talk to you a little bit about a different subject. You also mentioned that you have some training as an attorney. Is that right?
I don't practice as a lawyer. I have fellowship training in forensic psychiatry in the law and went to law school. So I know.
Damn, you really do stream different things.
Doing your job.
I want to talk a little bit about, you know, the concept of the emotion of anger generally. With respect to anger, I mean, is it fair to say anger is a normal human emotion?
I wonder if we went to Yale too.
And when we talk about things that provoke anger, are there aspects of life that you would expect anger to be the natural, ordinary response?
Yeah, I would agree.
Well, I could tell you where you can
different,
find them under a rock.
But yes, I mean there would, and we all perceive our emotions and handle anger and react differently.
So, I mean, is that something that you look for in people who are having difficulty with their mental health and with processing human emotion in terms of how they respond to something that might be an angering or exciting event?
Kate. What up, Zip?
Yes. And whether it's related to maybe their offense conduct, yes.
Oh, okay. On YouTube, you can find it on YouTube.
When we're looking at that, are there? Well, let me ask you this: if we're talking about issues related to a sense of love or betrayal of love or resentment about a romantic engagement, things like that, is anger an emotional response that's common to see with people psychologically?
Your Honor, I'm just going to object to one, leading and also to relevance.
Sustained to leading.
When you have you dealt with people in your practice who have struggled with issues related to, you know, failed romance or infidelity or jealousy about someone?
Objection, leading.
I'll allow him to answer that question. You can answer the question.
Yes.
What are some common emotional responses you see in those types of people?
I'm just going to object to relevance of this question, Your Honor.
Relevance.
Well, Your Honor, it goes to questions related to the testimony in the guilt-innocence phase of the trial. It goes to questions related to whether there was adequate
testimony related approach.
Were they having a meeting again? It's like nonstop meetings. What do you guys think? What do you guys feel will be correct for his sentence? Yeah, they muted it. They're talking right now. My last day of watching James full time. What the what? Say it ain't so. Say it ain't so. Life without parole, writes Joey.
Doctor, are you familiar with the concept of adequate cause as it exists in the law regarding the question of sudden passion?
Yeah, I'm familiar with the term. I mean, I'm familiar with sudden passion as well, and I've testified to it on at least one or two occasions.
And when assessing that, what are things that you are asked to examine and consider?
Well, what the, let's say the alleged or victim was doing prior to or during this offense, for example.
So are you looking at things related to the normal emotional responses of people who do not have some kind of a mental health problem? And how a normal person would react under similar circumstances?
Well, that would be, you mean with the defendant?
Right.
Yes. Yeah, typically, I think under the Texas statute is more of, yeah, the typical or normal person, how they may react.
Okay. And do you think that your training and experience in these fields of forensic psychology would be of benefit in understanding how people react emotionally to situations that may give rise to a discussion about sudden passion?
Yeah, I've done that before. Certainly, you know, it's more of a legal question. You know, if the judge decides I can testify to it.
So,
Your Honor, I was object to a legal conclusion. That's
Sustained.
Your Honor, we would just submit that we've laid the foundation, requested we'd ask a ruling on.
He's not, the objection is sustained. He's not allowed to make legal conclusions.
Without going into a legal conclusion yourself, Doctor,
I'll be right back.
What I'm asking is, are you familiar with the types of emotional responses that we would be looking to see in a normal person when questions related to sudden passion come up?
Yes.
Would that be one way of considering that question? Not the only way, but is that one way of considering it?
I would agree with that.
So with respect to that, if we have evidence suggesting that there was some sort of a conflict about romance or jealousy about a significant other, you know, what are the types of things that you as a forensic psychiatrist would want to know about that event or that incident to assess how a normal person would react?
Well, certainly what the disagreement was, the history of relationships between the parties, any prior, you know, aggressive conduct or problematic situations between the parties, for example.
Okay. And if you had evidence, hypothetically, that an individual was trying to have sex with another person's girlfriend, would that be the sort of thing that you'd want to look into more to determine how a normal person would react to that information?
Sure. And yeah, definitely. I mean, I guess relationship, jealousy, that type of thing. Yeah.
Okay. Is that something that has come up in instances where you've been asked to assess whether a normal person reacting in anger was acting appropriately?
Yes.
Your Honor, I think with that predicate, we would reoffer and ask for his opinion about the hypothetical in more detail. I just don't want to run afoul of this issue.
All right, if everybody can approach, please. All right, Finch, you may proceed.
Thank you, Your Honor. When we talk about emotions like anger, rage, resentment, or terror, can you describe sort of what's going on in the human brain when someone is under the experience of one of those emotions in a heightened form?
Sure. I mean, basically, you know, it would be more related to a different brain regions, more in the area of I'd say the amygdala, which is again more that fear factor center of the brain, and even, you know, prefrontal cortex, and some of that anger can be related to.
Oh no.
We're frozen.
Kind of fight, flight, that type of
sorry.
fear. So
You
there can
froze a little bit. So if you could start over with your answer, please.
Sure. Sorry about that. Anger involves just a number of areas of the brain. So it's multifaceted, and it would be in much part related to the amygdala, the emotional area of the brain. And that's, again, your kind of fear center of the brain. More of the watchdog, your alarm switch. So that is one area of the brain. And that also processes, you know, threat, frustration, and is connected also with processing within the prefrontal cortex, which is, again, more of that brakes on the brain. So there's critical circuits between those two areas of the brain that are responsible for feeling the threat, perceiving it, and then reacting to it.
When we talk about brain development, going through childhood, adolescence, into adulthood, when you talk about the breaks that you mentioned earlier that are achieved later in your 20s, does that have any role to play in how an adolescent might modulate their anger?
Go up.
Yes, it does. Can I share my screen, Your Honor, real quick again?
Yes.
Thank you. So basically, if you can see this right here, this slide has to do kind of with adolescent brain development. And right here, this is part of the frontal lobe, and they call it pruning. Basically, it's kind of like a shrub, and you got to reshape it, and some of the gray matter is pruned. And this happens in adolescence and in early adulthood. And basically, while your brain's developing, it's, you know, this frontal lobe area is pruning, and it is critical for more of the brakes on the brain. So the controls, the judgment, the decision making, and so that's how I would answer that question.
So in a 40-year-old man, they get angry about something. They may decide to bite their tongue, not say anything, internalize it, try to get over it without any behavioral component that the rest of the world can see. Do adolescents struggle with those kinds of skills?
Yes, they do. I mean, some more than others. In this case, I would say that given his ADHD brain, which is more impulsive, hyperactive, and given how he was raised and more of that trauma and symptoms of PTSD, emotional reactivity, he would have potentially more difficulties with that in times of stress. And he's more, I'd say, at risk to even misperceived threat due to his history of trauma.
Now, and just for the sake of a hypothetical, taking away those additional factors, a quote unquote normal 16-year-old boy would have difficulty modulating their anger in relationship to, say, a 40-year-old man?
You know, everyone is so uniquely different. In you know, when we're looking at brain development, that issue, yeah, they may have more difficulties. But again, some folks are more resilient than others, and But if it's I mean, we would say based on the research, especially in those areas of the brain that are developing, we could agree that that's an accurate statement.
And when I say modulating your anger or putting the brakes on, as you talked about, when there aren't brakes or the brakes aren't applied or you can't modulate an emotion like that, what happens with that emotion? How does it run its course?
Well, if you have difficulties, let's say your prefrontal cortex is not fully developed, one could have compromise or be more at risk to have difficulties with controlling emotions, let's say. So, their person's more likely to, I would say, react more in a dysfunctional way. They may act out, they may have difficulties emotionally regulating and problem solving in that moment. And so there's a lot of factors involved, if I may. Fight, flight reactions based on your trauma history, your brain development. It's very complicated.
Is it fair to say that when one particular emotion is sort of running away in your mind, other emotional responses are subdued and less likely to, interject?
Objection, leading, Your Honor.
Sustained.
How does a intense emotional response register in respect to the other types of thoughts and ideas a person might have in their head?
In part, that depends on their experience. Okay, in a case like this, I have more concerns that due to this abuse, neglect, especially physical abuse by father, Mr. McIntyre's, I think brain wiring and the emotional circuits connecting to the cognitive brakes circuits are going to be perhaps more compromised, in their development at that time. And so, I think a lot of it has to do with the past history of when he's been frustrated, in fear, in terror, angry. Okay. So that's how I look at how has he handled these situations in the past. I'm just saying that the risk factors that he has related to ADHD, brain development, and trauma, place him in jeopardy to handle his anger in stressful experiences, perhaps more than the typical 16-year-old.
Thank you, Doctor. Pass the witness.
State. Yes, you may proceed.
Thank you. Dr. Fabian, thank you for being here today.
Sure.
Let me ask you a few questions here, sir. With the review of the material in this case, can you just tell the jury what additional materials did you view? I mean, you said you reviewed police reports, is that correct?
Yes.
And then also some reports by other psychiatrists, is that correct?
Yes.
And then did you also review criminal history?
Yes.
And then also just some other maybe non-traditional factors. Did you also review, say, news articles?
Yes, I actually have.
And I'm assuming you mentioned that his music talent was impressive, so I'm assuming you reviewed some of his music.
Yeah. For a lot of people, I mean, I've heard a lot about it. It's not my genre of music, but
And speaking of that genre of music,
may we approach your honor?
Yes.
Damn, they keep on going on mute. What's going on over here? What kind of UPN operation courtroom are they running over here? Who remembers UPN? The UPN network, if you will. This is the trial for K. He's a rapper, or he was a rapper, or he had a one-hit wonder, if you will, from what the 808 Island Queen remembers. Hey, thank you. Highly appreciate that. Rhodes 24 for those 18 flowers. Damn, you hooked me up. Gracias. Highly appreciate it. I remember that network. The UPN network, channel 13 if you were in LA. What is the song? Nick, that is a very good question. I have no idea what song it is. Let me see. What he do? He took 3 different individuals' lives, I think in three separate incidences, if you will. Now he had a he a candy rapper. Let me see. He'll be rapping. Let me see. The Race. That song is The Race. Okay, thank you guys. Let me see. Is he the one who was at the hotel? Yeah, next to the Chick-fil-A. Yup, that was him. He took 3 people out. Crazy. Let me see. Hawaii doesn't play. I am blessed. Been here for almost 30 years. Let me see. 25 alive. 3. Wow. Anyhow, hey. So you know how I had mentioned that I was gonna have to get off in about 30 minutes. So it's about that time. If you guys do want to continue watching, I am streaming it on my other platform at CollectCallFrom, which is the same name as this channel. You go to my profile, you could find the links and whatnot. I am running. I'm gonna be running 2 different feeds for the TK trial. One from Judge Boyd, and then another one from another news organization, if you will. But I'll be back later on. When I'll have some free time later on, we'll be doing Pima County and Maricopa County, if you will. I do appreciate you guys. Let me see. He was on the run, and he made the song The Race because of the run. Okay. Interesting. Jill, we'll be seeing each other later on. You're always welcome. Leaving us. You're always leaving us. It be like that. I know a lot of us have abandonment issues and whatnot. But don't trip. I'll be like the other people that abandoned you and come back into your life. I'll leave it and come back. I'll leave it and come back, if you will. Gene Gators. Damn, James, you're a cold piece, James. You're a cold piece. Anyhow, hey, it's okay. Catch you later. Aloha. Of course, you're a man.
The witness testified
What is the other one?
that he listened to some of your client's music.
Hey, bud. Oh, she's going to listen to it?
The state is allowed to question the witness about anything that he reviewed for his testimony. That's the first point.
Cold meals for
the second layer to this whole question.
Hey, but like I say, I appreciate you guys.
So I need to make a determination
I'll see you guys later, right?
on specifically what music that the state is intending to offer through this witness that he said he listened to, and I'll make a decision on whether or not I'm finding that it's more prejudicial than probative. I don't know what the music is, haven't heard any music, so let me just see what the music is.
Your Honor, would you like me to, one, the City Exhibit P5, which is, we'll mark. We have loaded the disc into the disc player. And would you like to play it now, or would you like any other questions to be asked?
Well, let me ask this first. I know you're saying it's loaded in the disc player, but does anyone have just the transcription in Word so I can see it?
It's in the motion in limine, Your Honor.
It's in the motion in limine that defense presented to you, Judge, but I also have a copy.
Oh, if you could bring me a copy, because files are...
Yeah, okay, so, I mean, hold on, where is it?
They might object to the transcription.
I don't know the answer to this. Some versions of the song, these first 4 verses are in it, and other verses of the song, other versions of the song, it's not.
I know it's repeated though at some point.
Is it?
Yeah, it is for the right here.
Yeah, you're right. Okay. Right. But Your Honor, before we get to the substance of it. I do think that we have to establish whether or not the state's question adequately puts this at issue. What we're doing here is.
Just one moment. Let me review this and then I'll hear everybody's arguments. All right, state who you are. All right, so state if you want to ask the witness questions and let me see.
Okay, Judge. And Dr. Fabian, we were just previously, we were speaking about Tamar McIntyre's music. Is that correct, sir?
Yeah, I agree.
And you stated that you reviewed it, obviously, and that some of the material that you reviewed was obviously very well known by individuals out in public. Is that correct?
Correct.
And assuming you've listened to one of his more, I guess, highly listened to songs was The Race. Is that correct?
Correct.
And also there's an associated video with that song. Is that correct?
Yes.
And you've listened to it, and then also you've also seen the video. Is that correct, sir?
Yeah, I didn't watch the whole thing, but I got a good glimpse of an idea of it.
And you saw on the video that Tamar McIntyre this is back in 2016 when he was making this, right?
Right.
And he's walking around in that video with guns.
Yes.
And his rap song, and I'll just ask you some questions if you can remember. You listened to the full song, but do you remember some of the actual words of the song?
Yeah, I think it was about, I think, being in a race and beating his case or something like that.
So referring to a case that he's in a race away from, is that correct?
Your Honor, I'm going to object to the way we're proceeding here. We're running these leading questions through the witness. We should just ask the witness, what is it? Well, this isn't cross. This is a hearing outside the presence of the jury.
You can remain seated, counsel.
I think that the appropriate thing to do would be to have him disclose the underlying facts and data supporting his opinion under Rule 705. That's what we're here for, so that we can determine what the witness actually knows, not what Mr. Garahan knows, and then ask him point blank.
This witness has stated that he has viewed all of this documentation. This witness has been presented as an expert by the defense. The state is allowed to question this witness about items that he's reviewed, similarly to if the state were to offer an expert witness, the defense would be able to ask them questions about things that they've reviewed to form whatever opinion. What I'm telling both, and I want everyone to internalize what I'm saying. One, I am trying to see through this questioning, and you'll have a chance to question them as well. We're outside the presence of the jury to make a determination on one, whether or not, which I'm assuming it appears that the state is seeking to enter either a video or lyrics of this specific rap song. I'm trying to make a determination on whether or not, one, I should allow that. And the way I'll be able to determine that is by listening to these questions. Now, if people do not want to follow what I'm telling them, then what can also happen, which would not be appropriate, is the jury can come out here, the jury can listen to all of your questions, you can do your objections in front of the jury, and I will make my ruling. But I'm telling you all, this is the way it's going to be done, and this is the appropriate way to do it. So state, ask your questions. After they ask their questions, if there are some questions you want to ask, you're more than welcome to ask them. We're outside the presence of the jury.
Yeah.
I don't know anything about your case. I don't know anything about this case. I know people assume that the judges know about these cases. I do not. So,
Your Honor,
the
all I'm
information that you all are presenting, I'm hearing it for the first time. Don't know your client's music. Never heard this song before. Just now am I seeing what the state has presented in the form of a transcript that I'm assuming is a transcript of this song. Don't know anything about the race. Don't know what the race is about. So state will ask their questions. We're outside the presence of the jury. You will get a chance to ask your questions. Everybody will lay the foundation they think they will have laid, and then I'll make a decision on whether it's admissible or not. So let's continue.
Your Honor, all I want to say is that I understand what the court is saying, and I understand that that's how this will proceed. And all I want to do is make sure that my objection has been articulated, because I've been trying to say it now.
A chance to articulate their objection. I don't know what your objection is going to be because I don't know what the state is offering. So if we will just, everyone, just proceed this way so I can figure out what the state is seeking from this witness. We're outside the presence of the jury. They don't know anything about this. So then after the state asks their questions, you will get allowed to ask your questions, and then everybody will get allowed to make their objections. I will give both parties plenty of time to make their objections. Now, the way it seems that you want to proceed is you want them to make ask a question, you want to make an objection, ask a question, make an objection, telling them they don't have the foundation. Fine, we can do that in front of the jury.
That is not how I'm asking to proceed. I just want to explain why I am objecting to the initial decision to conduct the hearing.
All right,
well, I can do that at the end.
We're conducting
I just want
the
it
hearing.
noted that why we're having the hearing is something I also want to object to.
Proceed.
Thank you, Jay. Dr. Fabian, sorry, I sort of lost my train of thought here. But speaking about this song and also the video, you said you viewed the video portions of it, and then you also listened to the entirety of the song. And I was going to ask you, I did ask you about generally what the song was about, and what you stated was that he was in a race to beat a case. Is that correct?
Yeah.
And then there's the lyrics in this song speak of different things, like Smith & Wesson made my nine with some compassion. Do you remember that phrase?
Vaguely.
Okay. And then also things like another phrase, rob a nigga shoes, rob a nigga lace. Do you remember that?
No, I know the subject matter of this song, meaning like the idea behind it. Okay. Like where he was absconding, violating pretrial, cut his ankle bracelet, and was on the run. I mean, I know more about that than the lyrics.
And during this song, you realize it was released right before he was caught.
Yes.
And so it would have been after the murder here in San Antonio and after the murder that happened in Tarrant County.
Correct.
So this song could be speaking of these cases that he's racing away from. Is that correct?
Calls for speculation.
All right. The court will note that this is an expert witness. All right, you can proceed. That's overruled.
I would agree with that comment.
And in lieu of, since we don't have this on digital form, Your Honor, the state's position is well, I'll pass the witness at this time.
All right.
For this hearing.
So, yes.
Thank you, Your Honor. Dr. Fabian, did we send you either the music, the lyrics, or a video about the song, The Race, the defense?
There's a connection issue. Can you repeat?
What did the defense provide you with anything related to the video, the music, or the lyrics of The Race?
No.
You're familiar with this case outside of what we've consulted with you because it's a high-profile case. Is that fair?
Yeah, I heard The Race a number of times and I checked it out.
So it's something you're aware of independent of the scope of what we've asked you to look into in this case. Is that right?
That is correct. And I didn't really talk to your client much about it, actually.
In terms of your opinion, I know on direct we discussed creativity as maybe a crutch for lack of proper attachment. You recall that testimony?
Yeah, sure. It's a skill set that he has.
But apart from the general fact that he's a creative person, did you do anything with the information that he had produced this song?
No, I did not.
Does it inform your opinion in any way, shape, or form? Let me ask it a different way. You understand that you're here to testify about delinquent and violent behavior at a punishment hearing in a criminal trial, right?
Correct.
And that for the purposes of this punishment hearing, a jury has already found Mr. McIntyre guilty of killing Mark Saldivar, right?
Yes.
So is anything about this music, does anything about the music one way or the other inform the opinion you've given today about brain development, about generational trauma, about these dysfunctional forms of attachment?
No, not those factors, no.
Does it inform anything about your opinion regarding drug consumption? Or the substance use in this case?
Probably not at this point, no.
Does it inform anything about your opinion regarding adequate cause or sudden passion as those subjects were discussed in your direct testimony?
No, I would say no.
So this is something you're aware of, again, because it's a famous case, right?
Yeah, in part.
Well, I mean, we didn't provide it to you, correct?
No, but in the course of my evaluation, I heard about it and I read about it. So,
and the prosecutor asked you about the fact that there's wide media coverage about this incident, correct?
Correct.
And so those are the sources that led you to discover this song.
Correct.
If you were unaware of this song, do you think your opinion would be any different?
No, from a mitigating standpoint, I mean, the factors we talked about, his psychiatric diagnoses would be the same.
Ask the witness.
Yes.
Yes, Your Honor. I believe you stated in the course of your evaluation, you became aware of the song and this song in particular and other songs and music of Mr. Tamor McIntyre. Is that correct?
Correct.
And so you're in the course of your evaluation, you listen to the song, you look up other, for that matter, you stated it earlier in testimony, you looked up other news reports and other avenues that maybe defense counsel didn't offer to you, but you, doing a thorough investigation, did that on your own.
Yeah, I would agree. I mean, if you Google this defendant, a lot of information comes up, and I typically do that.
So, well, yeah, I mean, I'm not saying it's wrong. I mean, actually, it's right. You're a doctor and you're trying to get a full scope of the individual that you're evaluating. Is that correct?
Correct.
And so getting the full scope of this individual and watching some of his talented music that he is the artist of, I mean, one, you can see in the video, it's in a sense acceptance of his peers. There's other individuals in that video that are gathered around him. Is that right?
I think there's some other people in the video. Yeah.
And so it'd be fair to say, and what you testified earlier, that one of the factors and some of the factors that you used, maybe not supplied by the defense, but you did an evaluation, and part of that evaluation had some of his music and his occupation, that he was a rapper. Is that correct?
Yeah, I mean, that's certainly what I learned.
All right. I'll pass the witness, Your Honor.
Briefly, Your Honor. Did anything about the song, its lyrics, or the video inform your opinion that you have given today in this case?
No, he would have the same diagnoses, you know, that whether I listened to the song or not.
If we played the video for you and gave you the lyrics and went line by line through it, do you have any concern that it would alter your opinion in this case?
I mean, well, I haven't really been asked about his offenses.
And in terms of what you were asked to evaluate, did you conduct much of did you conduct much of an inquiry into his offenses other than the reports and the basic information about the case that we provided you?
No, I was aware of his charges and I was aware of some of the evidence against him. We did not talk much in detail about, you know, his offense history. That some of that was just, I think, attorney instructions. And so I just didn't focused on that. I investigated more mitigating type circumstances.
Whether this crime was committed as a matter of a robbery, or this crime was committed as a matter of a rush to anger, or this crime was committed because it was a Tuesday, the circumstances of why the crime was committed in any way change or alter your conclusions about Mr. McIntyre, his brain development, and his psychological issues?
I would say no.
Pass the witness.
All right, so the only issue here is whether or not the song that the state wants to question this witness about is whether or not it's more prejudicial than probative. Otherwise, the state is allowed to question the witness about the song. So does anyone wish to argue whether or not it's more prejudicial than probative? And if you want to argue that it's probative, what is it probative for? If you want to argue that it's more prejudicial than probative, you can make your arguments to the court.
Your Honor, our motion limine cites to a recent Court of Criminal Appeals decision in Hart versus State. That's 688 Southwest 3rd, 883, Texas Court of Criminal Appeals. In that case, the court was highly critical of the idea of the prosecution using song lyrics or music that glorifies criminal behavior as evidence. Now, obviously, perhaps a distinction can be made between its use in a guilt-innocence phase and its guilt and a punishment phase, but I don't think so, because the problem is that the state may have a different use for it in punishment than they would in guilt-innocence, but the implications that its use has are the exact same. They want to demonstrate that the defendant is someone who has glorified criminal behavior, who has himself implied that he is engaged in serious criminal acts.
So are you saying it's probative of nothing?
It's probative of nothing.
All right, state, what are you saying is probative of?
It's probative and indicative that even the doctor just stated that it talks about running away from a case. And it even depicted on there that the cases were just previous in 2016. And this is just months after he committed the murder here in San Antonio, Judge. So he released it after that. Doctor testified to that. And so it's the words of the defendant himself stating he's racing away from a case that he can't beat, and also shooting the person in the face.
All right, so here's the court's next question. It appears that from case law that flight is probative and flight is relevant. So the next question for the court is whether or not what the state is seeking to offer it for, whether or not it's more prejudicial than probative. The court is going to find it's probative. Does anyone want to address the issue about the prejudiceness of it all?
Yes, Your Honor. It is vastly more prejudicial than it is probative. We, in opening statement for the punishment phase of this trial, told the jury that Mr. McIntyre cut off his ankle monitor while on bond for the crime in Tarrant County and came down here. We are not disputing that issue.
But opening statements are statements, they're not evidence.
Well, yes, I understand, but the state has introduced the judgment from the Tarrant County conviction, which was the case he's referring to in the song. There's evidence from the guilt-innocence phase of the trial that Mr. McIntyre was arrested in New Jersey.
So are you going to stipulate in signed form that he cut off his monitor and stipulate that he was in flight?
Your Honor, I think that question puts us in an inappropriate position.
No, I'm just asking, that's all.
Well, the problem is...
And let me explain for the record, the reason why I ask is because defense, you stated that you had already given that information to the jury by way of your opening statement for punishment. And the court stated that opening statements are not evidence. And it appears that you're asking that the court block the state for many reasons from going into this line of questioning him, but one of them being that you've already told them this in your opening statements.
Well, Your Honor, I guess here's my problem. I understand what the court's saying, but a concession by counsel at the opening statement, and certainly a declaration as an officer of the court, there will be no argument in closing to the contrary of that or to rebut that question, combined with the fact that this is a subject matter that we do not believe is sufficiently probative to overcome the severe prejudicial effect that it has. Are all reasons why the landscape should just be left as it presently sits, which is that it's not in dispute. There has been no attempt to hide from it. There has been an open acknowledgement by counsel to the jury that this occurred. The state has provided evidence in the form of a verified, certified judgment that the crime that I referenced in my opening statement did occur and that Mr. McIntyre was convicted of it. But then to ask that we have to make a decision about whether to tender a stipulation to that fact, which requires Mr. McIntyre's express consent in order to avoid the admission of something that we believe could not be
and let me just tell you, I'm not asking y'all to do anything to avoid anything. The only reason why I brought up the stipulation is because counsel, you stated that in opening statements, you had already informed this jury that your client removed his leg monitor. And my response was, and I think correctly, opening statements are not evidence. It's just what people expect the evidence to show. So for this part of the hearing, for this punishment part, there's been no evidence submitted that he cut off his monitor.
I expected the state to put on evidence from people with firsthand personal knowledge of it to establish that fact. That's why I made that remark in my opening statement. I certainly did not expect that we would make an attempt to backdoor the information through Dr. Fabian and through a popular music song instead of the state calling a live witness that would be subject to confrontation and so forth, because there are a lot of circumstances that surround this question. So I think that that's the problem we're in, is that we're doing something with Rule 705 that it was never designed to do for a purpose that is already not in dispute by the parties, and that the state had ample opportunity to produce that evidence of, and we would have had no right to object to that direct evidence. It is, of course, the subject matter is relevant, but we do have a right to object to the song in lieu of that. It is a artistic work. There will be no evidence, and the state cannot produce anything other than a naked insinuation that what Mr. McIntyre wrote in this song is the truth. The fact that there are references to things that the state will claim are relevant is beside the point. There are plenty of songs that people think are about them that are not about them, no matter how much they think that the lyrics match their own factual circumstances. And people oftentimes fictionalize what they write in their music from some kernel of true experience. There's no way for us to gauge that one way or the other, except if Mr. McIntyre wishes to take the stand and explain his lyrics to the jury, which he shouldn't have to do because of his Fifth Amendment privilege. So overarchingly, there is a lot to be lost by admitting this song in terms of a fair trial for Mr. McIntyre, in terms of the prejudicial effect it will cause on the jury's imagination. There's nothing to be meaningfully gained. It's not a matter in contested dispute. There is no danger that the state will have to deal with me saying the opposite in closing statement. And this witness is not the right witness to get this information from. It's not part of the underlying facts and data that form his opinion. It's not something that could ever be reasonably asked to inform his opinion. I mean, the fact that this is just something that is a part of this person's musical body of artistic work doesn't say anything about his mental condition, about his life prior to the events that gave rise to this case, nothing.
All right, okay, all right, thank you. So the court is going to find that it's more probative than prejudicial. The only question now is what form you're allowed to ask the doctor questions about the lyrics.
Well, I would also just object, before we get into that, to the predicate of this being the sponsoring witness for it.
All right, so you're allowed to ask this witness question about the lyrics. I don't think it would be appropriate at this time to play a video. So you are allowed to ask the witness questions about the lyrics. And the court is finding that it's more probative than prejudicial. And the court is finding that the witness stated that he did review that song and his music. All right, anything else before I bring the jury back in? Does anyone need a quick break? If you need it, now is the time, because otherwise I'm going to bring the jurors back in.
I think we're ready to proceed, Your Honor.
All right, let's bring the jurors in. You ready?
All right, for the jury.
All right, everyone, please be seated. State you may proceed.
Thank you. Dr. Fabian, previously I was asking you about Taylor McIntyre's music. Do you recall that?
Yes.
And in particular, you evaluated this individual. By defense, asked you to evaluate him. Is that correct?
Yes.
And when you evaluated him, you reviewed some of his music, particularly a song called "The Race."
Yeah, I listened to, I would say, and watched some of the video. I've an understanding of the premise of the song.
Well, can you tell the jury what the premise of the song is?
Objection 705, 801, 802, 803.
That'll be overruled.
That he was on bond for a murder charge, and he was on house arrest, and I think cut his ankle bracelet and went on the run, absconded, and then getting traveled around the country.
And that's what the song "The Race" is speaking of. Is that correct?
Yeah, that's my understanding of it, yes.
And
objection speculation.
Overruled.
And you also saw a video associated with that song, is that correct?
Objection 705, 801, 802, 803.
Overruled.
I watched part of it.
Okay.
I had listened to it in more detail, just, but I saw just a blurb of the video. I didn't watch the whole video.
Okay. But in that video, it's Tamar McIntyre, is that right?
Objection, Your Honor. That's facts not in evidence 705, 801.
Overruled.
It's my understanding that was him, yeah.
And particular lyrics from that song, do you recall hearing, "But I ain't beat that case"?
Objection
bitch,
705,
I did the race."
705 and 802.
Overruled.
I'll repeat that. Sorry, over speaking. Some of the lyrics say, do you remember, "But I ain't beat that case, bitch, I did the race"? Do you recall that?
I do recall that line.
And what about the line, "Shoot a fuckboy in his motherfucking face"?
I don't recall that.
What about, "I'm little TK, I don't think you want no action. You want action, you get turned into past tense"? Do you recall that?
Your Honor, and as to the reading of all the lyrics into the record, I want my objections for all of these questions, if it can be a running objection, 705, 801, 802, 803.
All right, those objections are overruled.
And Dr. Fabian, I'll repeat that. It says, and again, I'm not going to read all the lyrics that are associated with the song. I'm just going to read portions of it. It says, "I'm little TK, I don't think you want no action. You want action, you get turned into past tense." Do you recall that?
And I'm sorry, Your Honor, I wasn't clear. Is the court granting me a running objection?
Yeah, your objections, you're making them. I have overruled it.
As I go?
Yes.
Okay.
I believe I recall that line.
And what about Smith & Wesson made my 9 with some compassion?
Objection 705, 801, 802, 803.
Overruled.
I remember the Smith & Wesson reference.
And then what about this line, "Fuck a beat, I was trying to beat a case, but I ain't beat that case, bitch, I did the race"?
Objection 705, 801, 802, 803.
Overruled.
I recall that line.
And then the line, "I'm gonna shoot, bitch, without a debate. I'm gonna shoot, you can see it in my face."
Objection 705, 801, 802, 803.
I don't recall that line.
But if I ask you again, you said that this particular song was about pretty much the defendant cutting off his ankle monitor because he was on bond for murder.
Objection asked and answered.
Overruled.
And running around, I guess, running about throughout the United States. Is that correct?
I would agree.
And you also have knowledge that this song was written and released very soon after the murder here in San Antonio, Texas.
Objection, speculation.
Overruled.
Correct.
And so this song was written and released after the murder of Mark Salvador, the individual here in San Antonio, Texas.
Object to speculation.
Overruled.
And I don't know if you know.
That's my understanding.
Okay. I guess maybe you don't know the victim's name, Mark Salvador, but that's the name of the victim. Okay.
No, I know. I'm aware of his name.
Okay, thank you. Now, you reviewed, as you stated earlier, several different things in this case. Well, let me ask you, you did review some of the materials associated with police reports that defense counsel gave you. Is that correct?
Correct.
And did they give, you know, if they gave you everything associated with Tamor McIntyre?
I don't know that.
So I guess to say this is that just they gave you everything that they gave you, but you don't know if there's other things out there associated with news reports or other songs or other criminal history or anything like that. Is that correct?
This is inviting the witness to comment on things that are not evidence. Here's total hearsay.
Not a basis for his.
This isn't and it isn't something that was disclosed in the 702, 705 hearing.
Overruled. You can ask the question.
You can answer the question.
Yeah, sure. I mean, I have his criminal history. They gave me, they provided police reports and then of defendant and family members, and I think some school records, the prior psychological evaluation, current indictment. Most of it was, I think, Arlington Police Department reports.
Okay. Thank you. Now, you stated that one thing I wanted to touch on is the pre-diagnostic study prepared for the Honorable Timothy E. Manicos. Did you review that from Tarrant County?
Yes, I did. Mm-hmm.
And in that report, I believe you stated in your testimony just previously that Mr. Tamor McIntyre had witnessed abuse between his mother and his father, like physical abuse.
Yes, I think he denied that in that report.
He denied that. So where'd you get that information from then?
Well, he expressed that to me. I learned it from his sister that they witnessed it, and I believe a Arlington police officer had interviewed him about it.
Yeah, in this report, I mean, just to be fair, because you stated that he witnessed it, but that didn't come from him. That came from other individuals that he states he did not witness any abuse between his mother and father, at least physical abuse.
Objection, hearsay, and asked and answered.
Overruled.
With the hearsay.
You can answer the question.
You can answer the question, Doctor.
Correct. Yeah, I mean, he had expressed that he had seen some domestic violence between his parents when we talked. And it's my recollection in an Arlington Police Department domestic violence report that he was present during one of the incidents.
Sorry, I'm sorry, I don't know if I heard you correctly, but you stated that when he talked to you during your interview, he stated that he had actually seen physical abuse then?
Yes. Yeah, at one point in his childhood, yes.
But yet he answered that in the negative when he was being evaluated for this pre-diagnostic study. You're aware of that, right?
Objection, asked and answered.
Overruled.
Yeah, I said I was aware of it, yeah.
Okay, so he changed his mind, or was he lying?
Objection, Your Honor. Argumentative.
That will be sustained.
Motion to instruct the jury to disregard.
Ladies and gentlemen, you disregard that last question.
Motion for mistrial.
Denied.
Well, I mean, the Arlington,
Just one second. The objection has been sustained.
oh, thank you.
And I just want to be sure that sexual abuse was brought up, but I didn't know if you answered that. The sexual abuse was just brought up, and I'm not saying that there was anything there, but was there any sexual abuse that you're aware of?
No.
Okay, thank you, sir. Now, the psychological evaluation of Mr. Tamar McIntyre, I believe you were talking about that. Do you remember that?
Yeah.
And do you recall, one, if somebody witnesses a murder or anything, that could be a factor in them psychologically, I guess. Could that affect somebody?
Yes.
Okay. And so do you recall from that report that Tamar apparently has been questioned but released by the Denton Police Department about a murder of a college student in
Objection, Your
early
Honor.
2016?
Hearsay, relevance, 403 and 705.
All right, if I could have parties approach.
And I guess 707.
All right, you may proceed.
Thank you, Your Honor. You're aware that he was questioned by Denton Police Department and released about a murder of a college student in early 2016?
Yes.
And
parties approach, just 1 second.
And just want to clarify this, that Tamar McIntyre was questioned as a witness on the murder of that college student.
That's my understanding.
And do you know any other information on that case?
I had read about it briefly, but I can't verbatim describe the facts.
Okay, we'll move on from that. Then as you stated that you did review some police reports from Arlington Police Department.
Yes.
And in particular, the police report that speaks about a robbery, aggravated robbery on May.
I'm going to object 705, hearsay, confrontation, and relevance 403.
All right, with regards to that question, that objection will be sustained.
Motion to instruct the jury to disregard the question.
All right, ladies and gentlemen, you're to disregard that question.
Motion for mistrial.
Denied.
Now, did you see anything about Mr. Tamor McIntyre's gang affiliation?
Did I see anything about it?
Right, in the packet that defense gave you, indicating that if Mr. McIntyre was a member or associated member or self-admitted to gang affiliation.
Is that just what I reviewed or my evaluation with him?
It was just what you reviewed. Because I
No,
don't have your evaluation in front of me.
sure. No, I did not see, I don't recall seeing gang affiliation references in collateral information.
So if this packet that defense counsel supplied to me has information in there about this individual self-admitting to be part of the Crips, that's just something that you may have overlooked.
Objection, Your Honor. That's an improper question. It assumes facts not in evidence.
Overrule.
No, he and I already talked about his gang involvement, so I knew that separately.
Speaking of the gang involvement, so what did the individual say about his gang involvement?
Well, he acknowledged that his family was heavily involved in the Crips in Long Beach, that faction, and that he was also involved. He had a bunch of family members, his mother, uncles that were involved in the Crips Long Beach gang faction. So I think that was a big part of his involvement.
Okay. Now I was wondering, do you take into factor, what factors do you take into consideration of whether this person, Tamor McIntyre, has one, at this age, a fully developed brain? How do you determine that?
Good question. I mean, when we're looking at studies, functional and structural MRI studies of the brain with adolescents, we know based on the research that their brains are still developing. So that's based on group data. Now, we don't have brain scans of him at age 16 or currently. At his age now, his brain would be, I would say, right at that edge of development, age 24.
So you would say that right now he has a fully developed,
For the most part, yeah. I mean, that's kind of my number. 23, 24 is when really that last area, the prefrontal cortex is developed. I would say that's correct. Some people disagree, but that's kind of where my number is.
I think you said it throughout your testimony. Sometimes you say individuals are unique. Is that right?
Correct, in every different way. So no case is the same.
Right. So like in any given case, since you really don't have MRIs of Mr. McIntyre when he was 16, being unique people, I mean, some people could be developed at that age, some people cannot be developed. I mean, you're talking about a very stereotypical development. Is that right?
Yeah, sure. Some people may have depression at that time, have been suicidal. Some people may be more mature. Some people may have, ADHD. So everyone's really, really different.
So it's sort of difficult to say whether Mr. McIntyre at that time had not had a developed brain in the sense of like knowing, well, let me ask you this. Let me retract that question. At that age, right and wrong, does he know the difference?
Yeah, at age 16, I mean, yeah, he would know the difference between right and wrong.
So, for instance, you reviewed his history up in Tarrant County. You're aware of it, correct?
Correct.
That on July 26, 2016, there was a home invasion and associated with the murder,
Yes.
and that he was part of that group of people that did this.
He was, yeah, involved. He was there, yes.
And that we already spoke about when he was on bond and he cut off his ankle monitor. And you're aware that he came to San Antonio then. Is that right?
Yeah, it's my understanding.
And that he was in San Antonio for a bit of time. I'm assuming you don't know exactly the time he was here. Is that correct?
I'm not exactly sure.
Okay. And then he committed the murder of Mark Salvador in April of 2017. You recall
Yes.
that, right?
Yeah, he was. I think he was in the area, obviously, around then.
And then he took off and was found in New Jersey, that's where he was apprehended in June of 2017.
Yes.
And so then he was transferred to Tarrant County to face those charges of the murder up there.
Correct.
And subsequently, in 2019, he was convicted of that murder up there.
Your Honor, we're getting kind of far afield, and I'm going to object to relevance to this witness.
Relevance.
Your Honor, I'm just going over a timeline because he said he reviewed this. I just want to make sure he reviewed it because, one, I believe in testimony earlier, some of the material that I have was not supplied to him. And I just want to make sure.
I'm going to object to the speaking objection, Your Honor.
All right, the objection to the question is overruled. You can ask your question.
Okay. So you're aware then in 2019 he was convicted of that murder up there. And then also was convicted of an aggravated robbery up there. Do you recall that?
Yes.
And then that's when he was transferred down to San Antonio, Bexar County to face the issues here. Is that right?
Correct.
And then you stated that you interviewed him, I believe, April, I want to say April of 2025. Is that right?
Yes.
So this month you interviewed him?
Yes.
And everything that you just testified to is based on that interview that happened this month.
Yeah, whatever yeah, my evaluation was based on an interview and information you provided to me this month.
We'll pass the witness, Your Honor.
Defense.
Doctor, you were asked about the differences and the uniqueness of each individual person. Do you recall the prosecutor asking you about that?
Yes.
And he was asking about the possibility about brain development being more advanced than what you've testified to as sort of the norm for a 16-year-old. Do you recall that question?
Yes.
Do you know of any studies that have found 16-year-olds that have fully developed brains like a 24, 25-year-old person?
Not offhand. I can't reference one. I'm familiar with the imaging studies on adolescent brains and more involved with the prefrontal cortex area.
It is not something, would you feel unable to properly assess forensically the questions we've talked about today without an MRI to determine whether someone's brain was more advanced?
Well, no, but obviously if we did a brain MRI this week, it would not be when he was age 16. So I think things would be quite a bit different in his development, in the developmental years, neurodevelopmental years.
What I'm asking is, is it outside of the practice norms for someone in your fields to base your conclusions upon the generalized data of how most 16-year-old brains develop?
No.
You were asked about these song lyrics. Did that play any role in your evaluation of Mr. McIntyre or about the situation that he faces?
No, I'm when I've been evaluating this case, again, from a mitigating standpoint, the information that I've reviewed in my evaluation with Mr. McIntyre has revealed the same, neurodevelopmental risk factors, but also the issues related to trauma and just really the way he was raised. That's really what I'm interested, concerned about. And I think the offenses and the song all come with all of that.
Okay. So it doesn't change your opinion one way or the other?
No. I mean, no, it doesn't. I'm not basing my evaluation on a song he wrote.
And to be fair, do you even know if he wrote it?
No, I assume he did. I can't really prove that.
Pass witness.
Judge Ruby, your first.
Yes. All right, is this witness excused?
By the defense, yes, Your Honor.
Excused?
By the state, yes, Your
All
Honor.
right, the rule has been invoked. I know you know what that means. Thank you so much for zooming in.
Thank you, Judge. Have a good day.
Thank you. All right, call your next witness.
Defense calls Kayla Beverly.
Does anyone need a break before this witness? If you take a seat here, please. You can have a seat. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. If you'll make sure you speak in the microphone so members of the jury can hear. And then there's a clip on for the court reporter. Oh, if you'll state your name for the record and spell your last name, please.
Kayla Beverly. My last name is Beverly.
All right, defense, you may proceed.
Thank you, Your Honor. Good afternoon, Miss Beverly. How are you?
Good, and you?
I'm well, thank you. How old are you?
27.
And do you know Tamor McIntyre?
Yes, sir.
How do you know him?
That's my brother.
Is he your older brother, younger brother?
Younger.
How many years separate you two?
1.5 to 2 years. It depends on when our birthday falls.
Okay. I want to ask you a little bit about your childhood and Tamor's. Could you tell us a little bit about your early childhood?
We were taken from our mom by CPS, and we had to live in foster homes and bounced around a lot.
How old were you when you were taken from your mother?
I believe I was 5.
5. So Tamor would have been how old?
Well, I believe that Tamar was 5 and I was about 7.
Okay, gotcha. Before that, did both your parents live in the house?
Yes, sir.
Okay. Did that stop at some point? You said just you were taken from your mom.
Yes, my dad was incarcerated for domestic violence against my mom.
Okay. Do you know anything about that incident? Do you remember it?
I remember seeing my mom after, like, injured.
Tell us about that.
I just remember seeing our mom afterwards. She was injured really bad after she was hospitalized. Stuff like that.
Was Tamor around for that?
Yes, sir.
And you said your father was incarcerated. Do you know if he went to prison for it?
Yes.
Okay. And so after he went to prison, did you all stay with your mother for some period of time, or did CPS get involved immediately?
For some time, maybe a couple of years, 1 or 2 years or something like that.
Just living with your mama?
Yes, sir.
What was that like?
We moved around a lot, kind of. I think she was trying to find stability, but didn't have a lot of help.
Okay. So you mentioned that eventually Child Protective Services got involved?
Yes, sir.
Can you tell us more about that? What happened there?
One day they came and they took us from our mom, and we fought with them and cried. And then they put us in a orphanage.
Okay. And you said that this was a couple years after your dad was locked up?
You can proceed.
If you need a moment, that's okay.
Thank you.
So how old do you think you were when you went to the orphanage?
I think Tamar was 5 and I was about 7. That's when they took us from our mom.
When they took you from your mom? Okay. And was that orphanage in Texas or was that someplace else?
It was in Las Vegas, Nevada.
Do you remember the name of the orphanage?
Child Haven.
Child Haven?
Yes, sir.
And describe to the jury what Child Haven was like.
It was like it was buildings, like different buildings in a property that was gated, and like the different buildings hold different kids of different ages. So me and Tamar were separated at that place for some time, and we were allowed to get visitation with each other, but we couldn't leave there. We went to school there, we ate there, bathed there, and sleep there. And sometimes we get visits. I think we got a visit one time.
Kind of sounds like a jail. Is that fair or is it not like that at all?
Yeah, it was. It's like a jail.
How long were you there?
As a kid, I didn't understand time, so it felt like a year, but it might have been like 6 months or something like that, close to a year.
You're not really sure, but
no, I'm not sure.
Felt like, I guess.
Yeah, it felt like a year.
What happened to get you out of the orphanage?
They placed us in a foster home. They found a foster home for us.
Where was that?
In Las Vegas, Nevada, in a neighborhood, low income neighborhood.
And you and Tamor were placed together in the same home?
Yes, sir.
Can you tell us a little bit about what it was like living in the foster home?
we weren't happy. So it was sad. We just wanted to go home.
Did you have any contact with your parents?
No,
Did you know what had happened to your parents?
no, it was times we didn't even know if our mom was still living.
How long were you living with that foster? Was it a family or was it a single person? Do you know?
It was I believe she was married and eventually her husband passed away, but it was a married woman.
And what was daily life like with her?
If it was during the year, then we go to school and we come back after school. If no extracurricular activities, and if it wasn't during the year, then we have to be in her home at all times, not allowed to ever leave.
You couldn't leave her property?
No.
Tamor too, or just you?
Neither one of us, Tamor either.
What happened if you tried to argue with her about that?
She didn't allow it, and we were young, so we just did.
Do you feel like you were provided for there?
Provided for because we ate every day and had a place to stay, so yeah.
What about your emotional needs?
No, not at all.
How long were you with this woman and her husband before he died?
I believe that we were with her for up to 2 years at the most at one point, and then we got transferred somewhere else and sent back to her again. So over the years, we were with her 2 times at the length of time that we were in foster care.
So you were transferred from her care to another foster home or transferred back to the orphanage, or how'd that happen?
We were transferred to our grandfather family.
Okay, tell me about your grandfather.
He's a retired veteran. I don't know his age, but he took good care of us, and he's a good man.
What's his name?
Russell Hardy.
And where does he live?
In Waco, Texas.
Okay, and that's where you all went to stay after you left Las Vegas?
Yes, sir.
And Tamor came with you, I guess?
Yes, sir.
Tell us a little bit about what life was like living in Waco.
We were allowed to be kids, and we were happy for the time span that we were out there. We were happier than we ever been as a kid in foster care or any of that stuff.
How did Tamor take it living with your grandfather?
He took it better. He started to get better grades and things like that. My grandpa was more involved in his school with his teachers and stuff like that. So eventually he did start to be better, do better and be happier, like a happier kid, more do extracurricular activities and just be a kid.
And about how long did this period of time last where you lived in Waco?
Maybe a year or so.
What happened after that?
They took us from our grandfather's care and sent us back to Las Vegas to Child Haven.
When you say they, who was they?
CPS.
Child Protective Services?
Yes.
So you went back to Child Haven?
Yes.
Do you know why they sent you back to Child Haven from your grandpa's house?
They never really explained it to us as kids. They just said that we would be coming back, so that it was just temporary.
Did you come back?
No.
When you got to Child Haven, the second time, how long were you there for?
Just one day.
Okay, just one day. What happened after that?
They sent us to the same foster home that we lived in before.
The woman that you mentioned?
Yes.
Okay. What was it like when you went back to live with her?
It was the same, but I feel like this time we were older and we knew it was wrong. Like
what was
we learned,
wrong?
like how she would treat us.
Help me understand that more when you say how she would treat you.
Maybe like physically abuse us and mentally abuse us and accuse us of things we didn't do and couldn't have done, or like 24-hour surveillance for us. Like it doesn't matter. We couldn't watch TV, have a phone, or nothing like that.
So are you saying that she hit you all?
She did.
Did she hit Tamor?
She did.
When you talk about mentally abusing you, you talked about not being able to leave. Is that what you mean, or do you mean something else?
I mean, just overall, because we were young and we were kids, so it was like a weird feeling with her because we wanted her to love us, but she was always disappointed at us, and we would get accused for things that we didn't even do. So it was just like, I feel like that was like mental abuse, because it was like we just wanted to earn her love, like be really respectful to her and not do anything wrong, but we would still end up in trouble.
What kind of things did she accuse you of doing, or accuse Tamor of doing?
Maybe, well, it was every kid in the house, but maybe like picking at carpet, like if normal wear and tear on the carpet, if it's older, like maybe we did it, we picked it out the ground, or maybe like we scratched a scratch on a wooden furniture that's older and wear and tear. It was things like that.
You made it sound like it wasn't just you and the woman who took you in. Were there other people living in that house?
It was other kids. They were all siblings. So 3 other kids that were all siblings.
Okay, were they her children, or were they also adopted?
They were not her children. They were in foster care. She ended up adopting them.
Okay, and I'm sorry, I used that word adopted a little carelessly. Y'all weren't adopted, I take it?
No.
Okay, but she had adopted other children from the foster system?
We met them the first time we lived with her. The second time that we came back, she had adopted them and changed their names and everything like that.
I see. Okay. So how long did this last where you were back with the lady in Las Vegas?
Not I don't want to say it was a year.
Okay.
I don't want to say it was a year.
During that time period, did you have contact with any of your biological family?
This time we were allowed to occasionally talk to maybe our grandfather or our uncle visited us before one time. And so, yeah, this time we were able to talk to family sometimes, yeah.
Were you able to talk to your mom and dad?
Not my mom, but my dad. Well, not even my dad. Maybe if I received a letter, but I don't think so ever.
Okay.
Not in her care.
So you said that you were there with this woman again for about a year? Is that
The second time, I feel like it was less than a year.
Less than a year. Okay. What happened after that?
We ended up telling a social worker about her treatment the last time we lived with her and how it was still going on this time, because this time they let us have different type of workers that come and talk to us or take us somewhere to a park or anything. So this time we got closer with our workers, and we let them know like everything that had been going on. So they switched us foster homes.
Okay. So the second time around, there were some social workers to oversee what was going on?
Right.
Okay. And based upon what you told to the social worker, what happened?
They removed us from her home.
Where'd y'all go?
A different foster home.
Okay. Tell me about that foster home.
It was better. We lived there until we were not in foster care anymore.
Where was that other foster home?
In Las Vegas, Nevada.
Okay. And do you all have any connection to Las Vegas, Nevada, besides that they took you to Child Haven and that's where you got put into the foster system?
No.
Okay. No relatives, no distant relatives?
No.
Okay. So you said that you lived with the second foster family until you were taken out of the foster system. What happened there to get you out of the foster system?
Our dad got out of prison and we were released into his care.
And where was your dad living when he was released from prison?
In Arlington, Texas.
Okay. So that's where y'all went?
Yes, sir.
Tell me about what it was like to go to be with your father at that time.
At first it was supposed to be happy, but it was a lot of abuse and things going on.
Okay. Abuse towards you, abuse towards Tamor?
Abuse towards both of us.
Tell us about it.
About what he would do.
Yes.
Well, what do you call it? Maybe like his punishments were too big for like the thing. Like if we got bad grades, then we would be punished. Like he would. It started off by maybe the whoopings got worse and worser, and then now it's not a belt. Now it's a 2x4, and we get a certain number of hits, and we get hit with it, and we have to lay there, and we can't get up. And it was times when Tamar was younger than me, so Tamar was younger than me, and he would cry, and just maybe they would think he was over dramatic, so they would tie him down to an ironing board, strap him down, like stuff like that.
And you said that these were examples of over disciplining you both for things in the house?
Maybe bad grades, maybe like, yeah, just bad grades and stuff like that. We weren't bad kids to be doing any, like going and doing anything we didn't have any business. We were too young, and we moved around a lot to know what's going on in our outside world. We were just learning. So it would be stuff like bad grades and stuff like.
Were there ever any signs that you were being hurt this way or things that other people would notice?
Yes.
Give me some examples.
Bruises, busted lips, noses. People have witnessed before.
Did any of these things ever come to the attention of your teachers or other adults outside your house?
Tamar's teacher noticed.
Okay. What happened when she noticed?
I wasn't there the exact moment. A certain teacher took a maybe noticed Tamar and built a relationship with him. And one day he had some type of bruising or something on his face. I don't know what it was. I don't know if it was a black eye or what, but the teacher ended up asking him, and he ended up being honest with her, and the school intervened, and they called our dad and our stepmom. Our stepmom came to the school, and they ended up talking to us, saying that we can't have any contact with our dad, and they just released us to her the same day.
Okay. But she was living in the same house as your dad or no?
Yes.
Yes, she was?
Yes.
Okay. So what happened after that?
After that, then we went home with her, and they told Tamar we got in trouble, and they told Tamar that he had to say that he was lying.
Okay. Your dad and your stepmother pressured him to say he was making it up?
Yes.
Okay. So did CPS ever get back involved as a result of that, to your knowledge? How long did all this go on, living with your dad?
Until I was about 16, 17. By the time I was like 16 years old, then me and Tamar started to think about we didn't want to live with him anymore, and we wanted our mom to live with our mom.
Who was your mom at this time?
I don't know where she was. We just were upset that everybody took us away from her. And then we just thought that we knew that she wasn't perfect, but just to have wake up one day and your kids be ripped from you, or your kid or us being ripped from our mom, I felt like that wasn't helping her or us. Well, we felt like that.
So what did y'all do?
We started to think about living with our mom, or just living somewhere else around the time I was 16. And then by the time I turned 17, then we decided to leave.
So Tamar would have been how old around this time? 15, 16?
15.
Okay. You said you decided to leave?
Yes.
Did you leave?
Yes.
Where'd you go?
We went to Corpus Christi with our mom after some time. Initially, we first left and we stayed here and there. And then we left Arlington to go to Corpus Christi after maybe like a month.
And that's where your mother was living?
Yes.
How long did you stay with your mom?
I stayed not even one night. I came and I brought Tamar and then I left.
Okay. So when you took Tamar down there, did you tell your dad you were taking him?
No.
All right. You were trying to get him out of the house?
I felt like if I did not take Tamar and leave, then my dad would keep hitting us and he would get in trouble eventually. Somebody would notice, there would be nothing we could do about it, or he would hurt Tamar, or law enforcement would have to get involved and they would have no choice.
And last time that happened to your dad, what happened to you all?
We went to foster care.
So do you know how long Tamar was in Corpus Christi with his mom?
I want to say a month, maybe. Or a month, or it couldn't have been longer than 2 months.
Where did he go from there?
Back to Arlington. He stayed with a friend and their grandmother.
Okay. How long was he staying with them?
I'm not sure.
Did you ever get to meet the grandmother?
I don't think I never met her. I think I've been there, but she was elderly. I think I never met her.
Okay. How was Tamar behaving around that time?
I mean, he was all right. How he was behaving, he liked to make music and stuff like that. So he wasn't having behavioral problems.
Okay. Now, eventually, did something happen to that older lady that you mentioned that he was living with?
She passed away.
Okay. And what happened after that for Tamar?
Then he went with other friends, or like had to figure it out on his own after that. He bounced around a lot, didn't have a place to stay.
What was your opinion of the kind of company he was keeping after he left that older lady's house?
I knew that if the circumstances were different, he probably wouldn't be around the same people.
Okay, but as far as those people are concerned, I mean, you know that some of them were drug dealers, right?
Right.
Some of them were violent.
Sustained.
What sorts of things were the people he was hanging around with like? Or what were they doing?
I didn't hang around them. I didn't like them. They didn't like me. So I didn't, I knew that I didn't like the way they treated him sometimes, or like whatever was going on.
How'd they treat him?
Just not, those aren't your friends. I could just boil down to, you can just tell some people aren't really your friends or want better for you.
Well, are you saying they took advantage of him, or are you saying that they were a bad influence, or how do you mean?
I feel like so, because he was only 15 years old, and it's a bunch of grown people who are just,
So were these people older than Tamar?
Yes.
Was it fair to say he was the youngest of that group of people?
Yes.
And were these the types of people he was hanging around when he got arrested in Fort Worth?
Yes.
Now, as far as the case in Fort Worth is concerned, are you a witness to any of the facts of that case? I mean, were you there for the case?
I was in trial.
You watched the trial?
Yes.
Okay. Do you know what they're accusing him of doing specifically was?
I know that he did not even have a weapon of any sorts, and he didn't harm anybody. And I know that he was 15 years old, and pretty much.
And you got to watch the trial unfold?
Yes.
Okay. Pass the witness.
State.
Miss Beverly, I want to start off by saying I am sorry for the abuse that you had to witness, and I don't think that any child should have to witness that. But there are some things that I have to talk to you about. Okay.
Yes, ma'am.
All right. So your brother, to your knowledge, he was born in Long Beach, California. Is that right?
He was born in McCollum, Mississippi.
In Mississippi. Did you guys ever live in California?
Yes.
Is that with your mother?
Yes.
Okay. And then is your mother from California?
Yes.
All right. Now, as far as how you guys ended up in Las Vegas, is that because you moved there with your mother?
Yes.
Okay, and as a result of that, you guys ended up in the foster system in Las Vegas, correct?
Yes.
Okay. Now, I know you stated that your brother's about 2 years younger than you, is that correct?
Yes, ma'am.
And growing up, I mean, you guys were very close, is that correct?
Yes, ma'am.
As a matter of fact, I mean, I think you would describe it as you two were kind of the only thing that each other had growing up, is that right?
Yes, ma'am.
All right. And so, I mean, you love your brother, that's correct, right?
Yes, ma'am.
And you don't want to see anything bad happen to him?
No, ma'am.
Now regarding your father, I guess you stated when you guys went back, or when you took Timur down to Corpus Christi, you loved your dad, is that fair to say?
Yes, ma'am.
And you didn't want him to get in any trouble for the abuse that you guys were undergoing at his hands, is that correct?
Yes, ma'am.
Okay. And you guys have kind of reconciled with your dad since then, is that correct?
Yes, ma'am.
Okay, in fact, he was here watching the trial last week, right?
Yes, ma'am.
Okay. Now regarding you, I guess when you were about 17 or 18, did you get your own apartment?
When I was 18 years old.
Okay. And that was located in Arlington, Texas, right?
Yes, ma'am.
Okay. And I guess the address to that apartment, it was 2216 Plum Lane. Is that right? Complex was?
Sutter Creek.
Sutter Creek, okay. And regarding, I guess I'm gonna show you something that, well, I guess, and when you were living at that apartment complex, that's when Timur picked up his case in Fort Worth, is that correct?
No.
No. At some point, when Timur picked up his case in Fort Worth, he was released from the juvenile detention center, correct?
Can you say that again?
Yeah, so when Timur was arrested up in Tarrant County, do you recall that?
Yes.
Okay, and he was in juvenile detention.
Yes.
Okay, and he got an ankle monitor, is that correct?
Yes.
And when he was released on ankle monitor, didn't he go to live with you?
Yes, ma'am.
And that was at your apartment that you had?
Yes, ma'am.
Okay. Now I want to show you. Is that your brother as depicted on the screen?
Yes, ma'am.
And was that photo taken at your apartment or the Sutter apartment?
Yes, ma'am.
Okay. And so at the age of, I guess, 18, your brother, he went to go live with you and you were kind of taking care of him. Is that how you would describe it?
Yes, ma'am.
And I mean, you've done your best to be there for him, correct?
Yes, ma'am.
And to provide for him, correct?
Yes, ma'am.
And you allowed him to live with you, right?
Yes.
Okay. And I guess you describe the environment that you provided for him at that time when he was on ankle monitor as stable, right?
I described it as that.
Would you describe it as stable?
No.
But you were doing your best to provide for him as best as an 18-year-old could, right? Okay. And so at that time when he's living with you, I guess he decides to put his ankle monitor, is that correct?
Yes, ma'am.
Okay. And so he's no longer living with you, cuts his ankle monitor, and he flees Arlington, Texas, right? Like,
Yes,
or
ma'am.
no? Okay. And so I guess previously you would describe your brother's stature at that time as small, right? He was a smaller individual.
Yes, ma'am.
Okay. And I guess at the time that you guys were living together, you previously stated that you guys were sharing an iPhone at that time. Is that correct?
That we were sharing an iPhone.
Or did you ever share a cell phone with him?
I don't even think we had phones.
Oh, okay. Do you recall an interview that you gave to Say Cheese, the social media outlet?
Do I recall it? Yes, ma'am.
Do you recall in that interview you said that you and your brother shared a phone at the time that he was living with you?
No, I don't recall.
Okay, and I'm gonna show you some photos. Okay, so who is that depicted on the screen?
Me and Tamar.
Okay, and what is that in your hand?
A phone.
Okay, and was that taken at your apartment?
Yes, ma'am.
And what about there? Is that the same thing depicted?
Yes, ma'am.
Now, regarding the Fort Worth case, you said that you watched the trial up there. Is that right?
Yes, ma'am.
Okay. And I guess you stated that your brother didn't have a weapon. Is that correct?
Yes, ma'am.
And he didn't harm anyone. Is that correct?
Yes, ma'am.
Okay. But somebody died up there as a result of the actions of your brother and his co-defendants. Isn't that fair to say?
As a result of my brother's co-defendants?
Your brother and the co-defendants.
Yes, ma'am.
Okay. And I guess you've previously spoken out because your brother's co-defendants up in Fort Worth involved 2 female co-defendants. Is that right?
Yes, ma'am.
Okay, and one of them, her name was Megan. Is that correct?
I guess so. I'm not sure.
You're not sure? That's fine. But you know that there were 2 females involved, correct?
Yes, ma'am.
Okay. And I guess you've previously spoken out because you don't agree with the way that the court systems have handled your brother. Is that correct?
No, ma'am.
You don't agree with that?
I don't.
Okay. Now regarding the Fort Worth case, I mean, based on the evidence that you saw, isn't it true that your brother, you know, enlisted these 2 females and there was an agreement for the females to enter into a drug house, unlock the door, and then allow your brother and the other co-defendants to go in there. Is that correct?
Objection calls for speculation.
She testified she witnessed the trial.
That doesn't mean that
All
she
right.
agrees with
Could
your
you all
recitation.
approach? Right, you may proceed.
Thanks, Judge. So up in Fort Worth, your brother was acting with multiple co-defendants. Is that correct?
Can you repeat that?
In the Fort Worth case, your brother had multiple co-defendants. Is that correct?
Yes, ma'am.
All right. And the evidence in that case was that your brother and his co-defendants, the 2 females, entered into a drug house. They texted your brother and the other co-defendants that were not yet in the house and told them to come in, and the females unlocked the door. And at that time, your brother and his other male co-defendants entered the house to commit a robbery. Is that fair to say?
I'm not sure.
Okay. And isn't it true that your brother in that case searched the house for drugs to take?
Wrong.
No.
He didn't search a house.
He was in the home, isn't that correct?
He entered the home. Yeah.
Okay, and he admitted to the Tarrant County Police Department that he was searching for drugs during the robbery. Isn't that correct?
Oh, I don't know.
Now, regarding the murder that we're here for today, you were not in San Antonio, Texas when that murder occurred, correct?
No, ma'am.
You were up in Arlington, is that correct?
Yes, ma'am.
All right. So you weren't in the car, right?
No.
You have no personal knowledge as to the facts of the murder that we're here for today, right?
No.
Okay. Now, I guess earlier you kind of said something that your brother liked to make music. I guess you would describe him as like a talented musician, is that correct?
He's artistic in a lot of different ways, drawing, music.
Regarding music?
Yes, music too.
Okay. And I guess, are you familiar with the song that he wrote called The Race?
Yes, ma'am.
Okay. And that song was released after the murder that we're here for today, correct?
Objection to 403, Your Honor.
All right, that objection will be overruled.
You can answer the question.
I don't remember the question.
The song The Race, it was released once your brother was apprehended in New Jersey, correct?
It was released after he was apprehended in New Jersey.
Yes.
Yes, ma'am.
Okay. And the song was released after the murder that occurred in San Antonio, Texas happened. Is that right?
If he was in New Jersey, then yes, ma'am.
Okay. And I guess regarding that song specifically, I mean, the lyrics of the song is that your brother was evading police. Isn't that correct?
Is that the lyrics of the song?
Yes.
I'm not sure.
You've never heard the song before?
I have, but I mean, I can't tell you what a person meant unless it was me.
Well, I want to know what is your take on the lyrics? So.
Objection, speculation.
All right, that objection will be sustained.
Motion to instruct the jury to disregard.
Ladies, a question has not been asked for them to disregard.
Understood, Your Honor.
And I guess at the time when your brother was in New Jersey, you're aware that he was posing in front of his wanted poster and taking pictures in front of his wanted poster, right?
I don't even think it was a wanted a poster, so I'm not sure about that.
As well, Your Honor.
All right, that will be overruled.
And I guess while your brother was on the run, isn't it true that SWAT went to your place looking for him multiple times?
Yes, they did.
Have you met with the defense team in preparation for your testimony today?
No, ma'am.
You've never talked with them on the phone?
About my testimony, no, ma'am. Or sorry, I have, but I thought you were saying like about my testimony or anything like that. I've answered questions.
Okay, so you guys have met?
Talked on the phone.
Okay, thank you for the clarification. And I guess regarding your brother, I mean, you've seen photos of him. Do you have knowledge of his affiliation with the Crips gang?
No, ma'am.
But you've seen photos of him throwing gang signs, is that correct?
Have I seen photos of him throwing gang signs?
Yeah, or videos?
We were foster kids. I don't really know a lot of gang signs myself, so I couldn't tell you what it is or.
So if there's been testimony that multiple of your family members are gang members?
They didn't raise us.
Okay. So your testimony is you're just not familiar with gang signs?
I'm not.
I want to call your attention to the interview that you gave to Say Cheese. Isn't it true in that video that you said your brother be hitting them things regarding gang signs?
I said he be hitting them things?
Yeah.
I don't even recall my Say Cheese interview because I just answered questions, but I don't recall saying that. Okay. I'm not saying that I didn't.
And regarding that interview, I mean, were you paid for that interview or was it free?
No, ma'am.
Okay, you were not paid for that?
No.
All right. So I want to talk to you about some of the people that you said your brother was hanging out with back in the Tarrant County case. Is one of those people Jalen Bell?
Can you ask that again?
Yeah, so earlier, when Mr. Hunter was asking you questions, you kind of talked about some of the people that Tim was hanging out with that were a bad influence on him. Do you recall that?
Yes, ma'am.
Okay. One of the people that he was hanging out with at that time was one of the people Jalen Bill.
Not sure, but
But you're aware that Jalen Bell and your brother were pretty close friends, correct?
yes, ma'am.
And you have personally, I mean, you've communicated with Jalen Bell before, correct?
Have I ever communicated with him before?
Through him or his girlfriend, Dara Sanders?
Yes, ma'am.
Okay. And sometimes they ask you for money, is that correct?
No, ma'am. I haven't talked to them in over 10 years.
So if there's a jail call saying that they've talked to you and asked you for money from your brother, that's just not accurate.
You said it's a jail call of them asking me for money or saying that they did?
Saying that they did.
Well, they didn't.
Okay.
So I can't know what they said.
Now, regarding Jalen Bell, I mean, you're aware that he pled to ag robbery for his role in the aggravated robbery of Mark Saldivar, right?
Yes, ma'am.
And your social media profile or on Instagram, your social media name is @RealSpecialK, is that correct?
Yes, ma'am.
Okay. And isn't it true that on your bio you still have free pimpies?
I'm not sure. I've been having the same Instagram for over 15 years.
Do you recognize what that is?
Yes, ma'am.
Is that a photo of your Instagram profile?
Yes, ma'am.
Okay, and just regarding the bio, can you read for me what it says here and here?
Free TK, free pimp, long live 2 Live.
I'm tendering to defense for inspection, but I'm offering State's Exhibit P5.
Objection, improper impeachment. I mean, it
All right,
wasn't.
if I could see the exhibit P5. Parties want to approach? State, you may proceed.
So regarding your social media profile, I mean, on your bio, you have free TK and free pimp, is that correct?
Yes, ma'am.
All right, and so you have no real interest in the family of Mark Saldivar getting justice for his death.
Objection, Your Honor, argumentative.
Sustained.
Motion to
I've been
instruct
having the
jury to
same
disregard.
Excuse me.
Oh, sorry.
So, when either party makes an objection, just stop speaking and I'll make a ruling on it. If you don't understand my ruling and whether or not you're supposed to continue to speak or not, just ask me.
Okay.
All right, the objection is sustained.
Motion to disregard.
All right, ladies and gentlemen, you're to disregard the last question.
Motion for mistrial.
Denied. State, you may proceed.
Thank you. At this time, we pass the witness, Your Honor.
All right, defense.
Fair to say you love your brother?
Yes, sir.
No one's suggesting that you're not hoping for something positive to happen to your brother, right?
Right.
Pass the witness.
No further questions.
Is this witness excused?
Yes, Your Honor.
Excused from the state?
Yes, Judge.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone during the pendency of the trial. All right, thank you. You may step down. Defense, call your next witness.
May we approach, Your Honor?
Yes. So, defense, what item did you want admitted into evidence?
Yes, Your Honor. The defense intends to offer defendants P1, which is the judgment of conviction of Joanna Reyes. The offense date listed on the judgment is April 1st, 2019, which is after Ms. Reyes is pleaded guilty in this case to the tampering charge. Sentence was imposed on April 22nd of 2020. Your offer.
All right, and state what's your objection?
Your Honor, the objection is one, this predicate has on the way, I mean, we don't know who's actual. States Joanna Reyes, but we don't have fingerprint evidence, but we don't have any about that.
Their TCIC will absolutely confirm that that is the same Joanna Reyes is what they entered to be at the beginning of the trial. I had to get back. No concern there. It's self-authenticating document certified by the Harris County.
All right, here's what the court knows. The court knows, one, that it's self-authenticating. I understand the state's objection, because you really do have to tie the fingerprint to whomever the judgment belongs to. Otherwise, it could be any Joanna Reyes. Just because you have this doesn't necessarily mean that the party who's listed on the document is somehow attached to this case. So, is that your only?
We're also objecting to relevance at this stage of the trial. Joanna Reyes did not testify in the punishment phase. The jury has already chosen that they believe her testimony, and so I think it's proper and untimely.
And we can get to that, and I understand that objection, but I really want to address the question. Is the state meaningfully arguing that the judgment and conviction on that cause number in Harris County, which will match their TCIC records, is not an authentic representation of Ms. Reyes' prior criminal history? Because this was our concern as well in the closing argument, when the state told the court, and this is its relevance, so it's sort of a twofer. The state told the jury that Ms. Reyes had abided by the conditions of her bond while she'd been on bond in this case. And this is direct evidence that that is not correct. We maintain that the state has its own independent obligation to set the record straight as to that. That was our objection at the guilt innocence phase. But additionally, the document that would corroborate that the judgment in the court's hands is reflective of the same person that was called, would be the TCIC and CIC record, which the defense is not able to make use of as an exhibit for the reasons that we had a hearing about at the very beginning of the trial. So I don't know that fingerprint authentication is the sole means of admissibility, but irrespective of that, I don't think that the state should be taking the position that that is a predicate that we are required to lay when there is a, I guess, statutory, we obviously dispute this, but just a physical reason we cannot admit the records in their file to corroborate. You don't have to prove up the judgment by a fingerprint. That would also go to its weight, not its admissibility. And as to relevance, again, Your Honor, Ms. Reyes' credibility is still an issue at the guilt innocence phase, because one of the questions in the case is whether or not there was sudden passion and why this homicide occurred and the surrounding circumstances of it are relevant to punishment. And those are things that
Oh, I'm sorry, Deputy Laura. Deputy Laura? Yeah, tell her now, because we have to go over the charge. All right.
A testimony about, and that testimony will have to be discussed in the closing argument here. So,
all right. All right.
We think it's relevant.
All right. The objection is sustained.
Receive that into evidence, and what I just proffered to the court, I would like to make a bill of exception.
Yes, and if you would then label it so that the record is clear, you can label it as P1R or P1B.
I can mark an R on it, Your Honor.
All right, thank you. That way it won't be confusing for the record.
I'll label it as Defendant's Exhibit P1R.
All right. And are there any other witnesses from either side?
No, Your Honor.
All right, so what I'm going to give to you all, and we can go off the record. I'm going to print off, I'm just going to do two copies. And then if it's the one that you all want, because Barbara just sent me one.
John, are you resting? Because Kayla wants to come back in and Ben wants to come in too. So.
Kayla, Beverly?
Yeah.
Okay, yeah. I would.
We have an issue with our next 10 coming back and.
No, yeah, we're resting and they make sure anybody didn't hear close.
All right, so defense, I'm assuming you're going to want sudden passion.
We're requesting sudden passion, Your Honor. I reviewed the charge that was left on our desk this morning. It looks good to me. The only thing I saw missing, and maybe it's there somewhere else, is that the jury is instructed that they have to be unanimous as to sudden passion. But I didn't see a separate paragraph that told the jury that they have to be unanimous about whatever punishment they give, whether they find sudden passion or not.
Okay.
So we'd request that there be a general unanimous instruction as well. But other than that, I have no problem with.
All right, so this is what Barbara has just sent me. And if you both can look over it and state what I will tell you is I'm inclined to give the defense the sudden passion argument.
Yeah, Judge.
Okay. All right, let me. I need to print out a copy for you. Here, Cindy, you can take this one. And I just Xed out my name on it.
And it's a guy that usually worked for the in Chicago. He's got really fish. He goes on. It's one master of the species of plants and do things about their history and so forth. Oh, sir. Behavior. First thing, it was Jody Mitchell. Of course, here's Jody Mitchell. Okay. Paved Paradise and put up.
You ready?
All right, for the jury.
Mm-hmm.
Let me go out. She went to the vending machine. I don't know if she knows how to get back.
Okay. All right. Well, we'll bring the.
So come on.
Okay. All right, everyone, please be seated.
Yeah, there you go. That's like seeing like it's not full food. That's right. That's right. Oh my God, Steve. Yeah, that's right. Yeah. Yes, you do.
Everybody's here now.
All right.
For the jury.
Everyone, please be seated. Defense, call your next witness.
Defense rests.
State.
They close it, Your Honor.
Close.
All right, ladies and gentlemen, you've heard all the evidence that you're going to hear at this phase of the trial. I'm going to read to you the charge of the court on punishment. You do not have to memorize it. You'll be given the original when you begin your deliberation. Members of the jury, by your verdict in this case, you have found the defendant, Tamar McIntyre, guilty of the lesser included offense of murder. It is necessary that the jury assess the punishment for this offense. When a defendant is convicted of murder, the defendant may raise and prove by preponderance of the evidence that he caused the death under the immediate influence of sudden passion arising from an adequate cause. Adequate cause means cause that would commonly produce a degree of anger, rage, resentment, or terror in a person of ordinary temper, sufficient to render the mind incapable of cool reflection. Sudden passion means passion directly caused by an arising out of provocation by the individual killed or another acting with the person killed, which passion arises at the time of the offense and is not solely the result of former provocation. The term preponderance of the evidence means the greater weight and degree of credible testimony or evidence introduced before you and admitted in evidence in this case. If you unanimously find that the defendant has proven by preponderance of the evidence that he caused the death of Mark Anthony Saldivar under the immediate influence of sudden passion arising from an adequate cause, the special issue is to be answered by you in the affirmative. If you unanimously find that the defendant has not proven by preponderance of the evidence that he caused the death of Mark Anthony Salvador under the immediate influence of sudden passion arising from an adequate cause, you will answer the special issue in the negative. Now, bearing in mind the foregoing instructions, if you all agree that the defendant proved by preponderance of the evidence that the defendant, having committed the offense of murder, caused the death of Mark Anthony Saldivar under the immediate influence of sudden passion arising from an adequate cause, you must make an affirmative finding as to the special issue, and the punishment you must assess is by confinement in the Texas Department of Criminal Justice Institutional Division for any term of not more than 20 years or less than 2 years. If you all agree that the defendant did not prove by preponderance of the evidence that the defendant, having committed the offense of murder, caused the death of Mark Anthony Salvador under the immediate influence of sudden passion arising from an adequate cause, you must make a negative finding as to the special issue, and the punishment you must assess is by confinement in the Texas Department of Criminal Justice Institutional Division for life or for any term of not more than 99 years or less than 5 years. You are instructed that your finding on the issue of sudden passion must be unanimous. That is, you must unanimously agree that the defendant either did or did not act under the immediate influence of sudden passion arising from an adequate cause. In addition to imprisonment, an individual found guilty of the offense of murder may be punished by a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in your verdict. If you assess a fine, it is not paid to the victim or victims, if any, but it is paid into the registry of the court. If there is any evidence before you that the defendant may have committed an offense or act of misconduct other than the offense of which you have convicted him, you are instructed that you may use that evidence, if any, in assessing punishment in this case, but only if you find from the evidence beyond a reasonable doubt that the defendant committed such other offense or act of misconduct, if any. In the event you have a reasonable doubt as to whether any other such acts, if in the event you have a reasonable doubt as to whether any other such offense or act of misconduct was committed, or as to whether the defendant was involved in such other offense or act of misconduct, then you will wholly disregard the evidence, if any, which may relate to any such matter. When there is a possibility for a defendant to incur multiple punishments on separate offenses, whether those sentences run concurrently or consecutively, that is, at the same time or one after another, is a decision to be made by the court. You are instructed that the defendant may testify on his own behalf if he chooses to do so. But if he elects not to do so, that fact cannot be taken by you as a circumstance against him, nor prejudice him in any way. The defendant has elected not to testify in this punishment phase of trial, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. Under the instructions herein given, it will not be proper for you in determining the penalty to be assessed to fix the same by lot, chance, any system of averages, or any other method than by a full, fair, and free exercise of the opinion of the individual jurors on the evidence admitted before you. The length of time for which a defendant is in prison may be reduced by the award of parole. Under the law eligible in this case, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed, or 30 years, whichever is less. If the defendant is sentenced to a term of less than 4 years, the defendant must serve at least 2 years before the defendant is eligible for parole. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. Suitable forms are attached hereto for your verdict if you should care to use the same. However, such forms are not intended to influence you in any way in arriving at your verdict. In any event, your verdict must be unanimous, in writing, and signed by your presiding juror. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. Are parties ready to proceed with closing?
State's ready, Your Honor.
Yes, Your Honor.
All right, State, you may proceed.
Not all murders are created equal. That's probably the only thing that me and Mr. Hunter can agree about throughout this whole trial. Ladies and gentlemen, Mr. Hunter is going to get up here in a couple of minutes and ask you to give the defendant 2 bodies for the price of 1. That is not justice. And you need to consider that in your deliberation. The defendant is charged with murder. His punishment range is 5 years to 99 years or life in the prison, and up to a $10,000 fine. The evidence in this case does not support a sentence of less than life. The defendant has taken an active role in the death of 2 individuals, not only in this county, but in Tarrant County. And you all need to send a message to our community and to all other criminal defendants out there that they can't just come into Bexar County and
Objection,
do
Your
whatever
Honor.
they want.
Appeal to the community.
It's a plea for law enforcement.
Overruled.
Mr. Hunter's going to get up here and he's going to tell you the defendant is counting on you. But ladies and gentlemen, our community is counting on you. The family of Mark Anthony
Objection,
Saldivar
appeal
is
to
counting
community.
on you.
Overruled.
The evidence in this case does not support a finding for sudden passion at all. There's been no evidence that the defendant was acting under sudden passion. And when you are considering that, you need to look at the person or a person of ordinary temper. And what does that mean? Well, you need to look at the defendant and how he holds himself out in our community. And how is that? As a Long Beach insane crip that goes under the moniker of KK-47, that writes rap songs about evading police after committing 2 murders, that doesn't surrender himself to law enforcement, has to be apprehended in New Jersey. Ladies and gentlemen, that throws gang signs repping the folks and the insane Long Beach Crips. That's not a person that has an ordinary temperament. Even you heard from Dr. Fabian, he said that the defendant struggles with having an aggressive personality and he's more at risk than other individuals in our community. Now, regarding the role of parole, you may consider the existence of the parole law. The defendant's length of the sentence may be reduced by parole. And so that's something that you can consider. We don't know if he will get it. He will be eligible at halftime, and that's something that you need to consider during your deliberations.
I object to that last statement, Your Honor. That's
You may
not appropriate.
consider during your deliberations.
Overruled.
Ladies and gentlemen, your verdict changes this community, and I want you to think about the evidence that you've seen in this case. What we know is that the defendant has played a role, 1 as a party and 2 as the active shooter and 2 murders. And he's taken no accountability for it. He comes up here and he's asking you all to take sympathy on him because he had a rough upbringing. And I do sympathize with that, but that's a slap in the face to every other child of abuse that chooses to be a law-abiding citizen in our community. And it's not just 1 mistake, it's 2 intentional choices that he made. And you all need to consider that seriously. Ladies and gentlemen, the only appropriate punishment verdict in this case is life.
Right, defense.
Thank you, Your Honor. Opposing counsel, may it please the court. Ladies and gentlemen, the concept of community, I think, is an important place for us to start because it tells a certain story. The state wants you to come in here and send a message to the community, and a harsh message. But how do we send a message to the community to address the sorts of systemic problems that result in someone being the victim of child abuse, being snatched up and taken away to what is essentially a carceral institution, an orphanage where they can't leave, away from their parents, that locks these people up, that puts them in foster homes where they're mistreated, that confuses them about who are their caregivers, who are their providers, that bounces them around from disaster situation to disaster situation. You can blame parents, you can blame the overarching structure, but at the end of the day, we also, I think, have to look at ourselves. We have to look at what this society does. And we can all recognize, I hope, that what Kayla Beverly testified to, that she and her brother Tamor went through as children, is not doing what we expect of the foster system, of child protective services, of moms and dads. The societal problems that we have to recognize these children are growing up in is all of our responsibility just as much as it is our responsibility here today to make a decision about how to punish Mr. McIntyre. And it's an easy fix for us to all just say, of course, man died, life for a life, life in prison, goodbye. But that doesn't answer those questions. And this isn't just a situation where we can accept that a tragedy has occurred and forget about all the things that led before. I'm not suggesting to you that what Dr. Fabian testified about in punishment in this trial is an excuse for what Mr. McIntyre did. It isn't. And of course, there are ample examples of people who have had terrible childhood backgrounds, like Tamor's, worse than Tamor's, who don't go out and commit murder. But it would be silly not to acknowledge that there is a cause and effect relationship. And to completely ignore that is all you'd be doing by giving a verdict of life in prison. You'd be abdicating any other bit of responsibility for how this tragedy played out. How it played out when he was a small child. How it played out when he was 10 years old. How it played out when he was 14 and 15. How it played out when a 16-year-old boy was expected to provide for himself and make his way in the world as though he was an adult. And it wouldn't account for the travesty that it is that we are sitting here in an adult court prosecuting a man for a felony as though he were 38 years old, 40 years old. That he should have known better, that he should have understood all of these things. And again, I'm not saying that there isn't an appreciation of right and wrong, but you understand that we have here a perfect storm of factors that ask for these kinds of things to transpire. And we need to make sure that the verdict that we deliver in this case is measured to that it acknowledges that this is a tragedy for a lot of different reasons. And only one of them was decided when that light changed from green to red on the access road of 410. That's the timing we're talking about. A decision that was made in that little span of time, impacting the rest of Mr. McIntyre's life and ending Mark Saldivar's life. And that tragedy, as I said to you in opening statement, cannot be undone. But we can avoid turning one tragedy into two. I'm asking for your mercy. I'm asking for your measured consideration of the evidence. And I'm asking you to think about some of the things that we talked about in the guilt innocence phase of this trial as well, because those are still relevant factors. Irrespective of the fact that those things didn't lead you to the conclusion that he was not guilty, let's just understand what we're talking about here. We have a 16-year-old boy in a car with a bunch of people who are 2, 3, 4 years older than him. And out of that scenario, we have this entangled romantic situation. You hear evidence that goes uncontroverted. In fact, it's after 2 or 3 attempts at trying to conceal it that we tease out of Joanna Reyes the fact that she was flirting with this man on Instagram, that she was discussing with him a very provocative photo shoot, that this was something where they have had a history together, that they know each other from back in high school, that she's blocked him for making advances on her and soliciting her for photographs in the past. And the man gets into the car and all of a sudden this photo shoot is called off or it's rescheduled. Okay, now that's the evidence. And the state doesn't provide you with a competing narrative of that. So even if you accept that Joanna Reyes is telling the truth, that Mr. McIntyre killed this man, and you accept that he did it for whatever reason, the bottom line is that Joanna Reyes got that man into the car, and that man had one thing and one thing only on his mind. And his decision to abort the photo shoot, to not go through with it, to act weird about it, provoked this issue. And again, I'm not trying to blame Mark for that. I just think we need to understand that Joanna Reyes shaved the tinder into the campsite. She poured the lighter fluid on the tinder, and she throws the match onto it. And now is trying to pretend that that didn't happen. And I think that that evidence is important for you all to consider for two reasons. The first is, it's the only evidence that you know about the true accounting of what happened in that car. Throughout both phases of the trial, that's the information you're possessed with. Well, in my mind, that evidence points us to sudden passion. It's the only evidence that we have about the transpirings of that car. So I would submit to you that's the great weight and preponderance of the evidence that's before you. And it suggests that there was a provocation for Mr. McIntyre's behavior. It's not a justified reason to kill somebody. It's inexcusable, losing your temper like that. But we have to couch it in terms of the whole context of what we're here to talk about. We're talking about a 16-year-old boy. We're talking about someone who doesn't have a fully formed brain. We're talking about someone whose decision-making skills and whose understanding of reality is tempered not just by post-traumatic stress from having an abusive childhood, but by the fact that he was intoxicated, or at least partially intoxicated, by the fact that he's had systemic problems with drug abuse as a child. We have to understand things as they relate to that. And we have to ask ourselves whether or not any of that should be considered at all as a matter of mitigation. This isn't some grown man who lost himself in the bottle and did something in a blackout rage. This is a child whose entire world was shaped by circumstances that were mostly out of his control. And now, at a moment where we freely acknowledge he exercised his own control and made a decision that was terrible, we're going to bring the hammer down and send him away for the rest of his life. Folks, let's try to be a more reasonable society. Let's try to make this courthouse, the juvenile justice system, child protective services, something other than a killing floor. We know that these problems are plaguing our society. We know that these problems are creating the risks and the jeopardy that these kinds of events will take place. But this is where we sit. I think it's very important that we understand that when we talk about a message to the community, it really is that. At the bottom line, what the state wants us to do is to be able to say that this is a classic example that they did their job. We put a man away for life in prison because of a brutal murder. And it's not just one, it's two. This guy's been to prison before. And he's a bad guy, and he's written rap songs, and he's a member of the Long Island or the Long Beach Insane Crips. Whatever they want to say about it, there's a propagandist function to the request that they're putting to you. Don't do it. Don't be a shill for the state's own apologetics. They're asking you to whitewash over their own failures, our failures as a society. We're all in this together. And participating in it only at the end of the story, participating in it only when we get to come down and pass final judgment, is a cop-out. A message can go both ways. And I would submit to you, if we're going to send a message, that's a better one to send. Because it's very core. It's a message that communicates mercy, forgiveness, moving forward, recognizing that this person, Mr. McIntyre, is also a human being, that his dignity is just as important as the deceased, as Mark Saldivar's. That's just the reality of it. We can couch it in terms of right and wrong. We can point the finger. We can blame. But every human being has that same level of dignity. The Bill of Rights doesn't have an asterisk that says except for convicted criminal. Our founders recognized the inherent dignity of every single person. That's why we have these procedures. That's why we have these laws. And that is also why you all have such a wide range of punishment. It's a lot for you to consider. I want you to also just consider again, to go back to it, that while you have rejected self-defense, and I understand that what we are critically talking about here is a bad decision in the face of a pretty significant circumstance. Defense exhibit number 5 is still in evidence. That's still something I want you to go back and look at. And you're going to see that shattered windshield. And you're going to understand that this is what is being experienced by this boy in this moment. Are we right to say it's not good enough? That's not an acceptable reason to pull a gun on someone? Sure, I think that we can say that that's unacceptable. But we also have to understand that that's something that goes towards his decision making, and that this is a decision that happens in the blink of an eye. Milliseconds. Now we're here sitting here talking about years. Many, 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 many years. You've heard about Mr. McIntyre cutting his ankle monitor while on bond for a murder. You've also heard some testimony that Mr. McIntyre is not the trigger man in that case. Mr. McIntyre didn't act alone. Mr. McIntyre was in the company of older people who were bad company, who were creating problems for him. There seems to be a theme here, falling in with the wrong crowd, falling in with older people, and trying to take their direction. Before we can say that that doesn't merit any consideration and what punishment to give him, we need to be asking ourselves, where were all of us? Where were we as a society? How did we end up here? Why are we letting these types of people have to depend upon the guidance, the counsel, and the decision-making of older criminals for their only source of support, for their only guidance, for how they're brought up, for their introduction to how to intoxicate themselves, what to do with their lives, how to behave, how to create, how to express? It's not acceptable. This is a weighty choice because I fully understand everything the state's going to get up here and tell you and everything the state said. Mark is a human being. Mark was entitled to that dignity. Tamor took it from him. That's worth something. I'm not suggesting it isn't. I'm just asking you to balance that against everything else that needs to be considered. Lastly, I want to talk to you about something that's a little bit more technical. You have here a judgment from Tarrant County.
Right, 2 minutes.
Where Mr. McIntyre received a sentence for 55 years, and then several concurrent sentences for accompanying offenses in the same transaction, which ran concurrent with that. So you understand, he's serving a 55-year sentence in prison as we sit here today, okay? I want to be clear about this. This isn't a situation where if you all express leniency and give him a low sentence, he's going to be out in a couple of years. I mean, to the extent that we can recognize that there's a valid purpose in carceral punishment for people who commit these kinds of crimes, understand that work's already been done. The issue that has to be considered is that whatever you all decide to do, the court has in its discretion the power to either run that concurrently with Tarrant County or to stack it on top of it, so that whatever you give won't begin to be served until all of that time has been satisfied, however it gets satisfied. So understand that. There's a lot of temptation in these sorts of things. It's almost like when you're negotiating for the purchase of a house and you're talking about 20,000 here and 40,000 here, and these are big numbers and they're being casually thrown around. When we're talking about something as significant as this, and where the options are 5 to 99 or 2 to 20, it's easy to start talking about numbers like 40, 30, 20, 15, 10, as if it was just no big thing. How do you mathematically quantify in your head the time that's spent in those places? And you heard testimony about what a jail's like. Try to understand. It's incumbent on you to just focus on this. Focus on this and know that there is a possibility in the court's discretion that it will be stacked. This gang stuff, don't fall for it. There's nothing to it. It's just trying to smear him in your eyes. There's no evidence that this particular group is in any way a criminal organization. Just a thing on paper. And it betrays a very important fact about jail, about prison, about any kind of lockup like that, which is that it is survival of the fittest. It's a brutal place. There are no good people there to provide counsel. There is no way to get better. You have to live. You have to survive. And so, as a natural consequence of that, sometimes people join up with other groups of people. A lot of it's on racial lines. You heard that. That isn't a reason to think that Mr. McIntyre is any worse of a criminal, that he's a criminal at all, other than the things he's been convicted of. It's just a fact of life about these situations. But it gives you a glimpse into what you're sending him to. This isn't a resort. This isn't a country club. Prison is hard and it is cruel. And there are plenty of people in this world who say, well, that's how it should be. That's how it should be. But I'm sorry. The 8th Amendment of the United States Constitution demands more. It expects that people don't get raped in prison. It expects that people don't have to trade in contraband in order to not be hurt, beaten up. It expects that people won't be shivved in the shower. But we know that those things happen. That's what we're sending. So appreciate that as well. You all have given us so much of your time, so much of your patience over the course of this. And I hope that we haven't been wasting it. This is a very worthwhile thing for Mr. McIntyre. I know that when you deliberate, you will come to a fair and just sentence, one that is tempered by your compassion, by your love of your fellow man, and by your understanding that we are all in this together for good or ill. Thank you all.
State. Thank you, Your Honor. Ladies and gentlemen, I'll be the last to speak with you. I'm going to try to make it as brief as possible. I know it's been a long 2.5 weeks for you all, but we're here for a very important matter. State of Texas versus Tamar McIntyre. I want to tell you, just start off with the charge of the court. This is what you'll receive, very similar to what you received during the guilt innocence phase. But this is what you'll receive back there, and the judge has already gone over it in the verdict forms. I've circled the part where the state believes that this is not said in passion. I've also circled a portion on the next where we're asking for life with a $10,000 fine. Very few times that you're able to come up here and argue that the individual not only has the murder that you convicted him of, but also another murder that he was convicted of. It's not very often. So when you're looking at that range of punishment of 5 to 99 years of life, let's think about that. What the lower end, 5 years. Somebody that committed 2 murders deserve that? Plus ag robberies, gang affiliation, shoot a fuckboy in his motherfucking face. Fuckboy, condoms, lube. Who's he speaking of? Is Mark that fuckboy that he shot in his motherfucking face? That family over there wonders that same thing. And he glorifies it in a song. And when he's on the run to beat the case, and then he posts it out there, glorifies this lifestyle. 5 years, that's somebody that goes in and unplugs it. A plug from the medical device supporting their wife or husband that's dying of cancer and is pain. That's murder. You intentionally and knowingly did it. That's what that is. What's in between? 5 years and 99 years of life. 20 to 40 years? Maybe. Got 55 years on his last murder. And supposedly he wasn't even the shooter. 60 plus years? If you're the shooter, yeah. That seems appropriate. 60 plus. However, that's if you're just a shooter, not a repeater, meaning that you did 2 murders. He's done 2 murders, affiliate with 2 murders and aggravated robbery. If this doesn't call for life, then what does? Sudden passion. Remember where Mark was shot? He was flying off that car. He was shot in the shoulder. It went across his body. He was on his hands and knees. On his hands and his knees. When he was shot by that man. In that parking lot. Mark had to jump on that hood to get back his stuff. And I understand you couldn't agree on robbery. But there's no doubt that Mark's things were in that car. No doubt. His wallet ended up to that Mexican food restaurant, thrown about by these individuals, by Mr. Tamor McIntyre, TK47. Person of ordinary temper, TK47. Ordinary temper, anger, rage, resentment, or terror. An example of that is walking in on your spouse and they're with somebody else in your bed. You grab the gun and you shoot them. Sudden passion. You feel that. That's what sudden passion is. This is not sudden passion. Tamor's timeline of death here. July 26, 2016. Home invasion. Murder. He's on bond for murder then. He's given a chance to show that he can get on bond, be out in our community with an ankle monitor and abide by the rules. But what does he choose to do? Cut it off and let's go down to San Antonio, Texas and murder somebody. Let's go on. He doesn't get caught here in San Antonio. He runs off to New Jersey to hide away, to release his song, The Race, because he had to beat it. He had to beat this case. That's what he chose to do. He was caught there and dragged back to Tarrant County and convicted of murder and 3 different ag robberies and received 55 years for the murder, 30 years for one of the ag robberies, and pled to 2 ag robberies and got 13 years on those. To run all concurrent. They're not stacked on top of each other. They're all run concurrent. They're all running at the same time. And now you convicted him of murder for the 2nd time. 3 ag robberies. He's affiliated with the Crip Street Gang and continuing behavior of a gangster rapper style. That's what it is. You heard the lyrics. Who really treated somebody like trash? Look at that picture. Left in a parking lot with an orange and tangerine or bottle of water and marijuana and shell casing and the grime on his hands and the grime on his pants, the dirt. Who really treated somebody like trash that day? Who didn't treat somebody like a human being? This is human. This is humane. This is what we're doing. This is humane. We're not asking for you to go out there and shoot Tamor McIntyre. We're asking you to hold him accountable. 2 murders, 3 ag robs, 5 first-degree felonies. 5. The punishment phase is to deter this kind of action from happening again. It is for punishment. He took somebody's life. He took Mark Salvador's life. We're not asking for an eye for an eye. Again, we're asking you to deter this type of behavior from other individuals wanting to be that type of individual. Big man with the gun. Walking around with a gun. If you want to talk about somebody, about the sexual innuendos that Joanne was having flirting, and then you want to talk about Tamor knowing about that's his girlfriend, and he goes into a rage because he was going to rape her because he brought the condoms and he supposedly brought lube. Well, we don't know. Why did Tamor want to set this up then? Why do you want to meet the guy that wanted to have sex with her before and she blocked him? Why? Never understood that. Why would Tamar want to meet this guy? Ask yourself that. Remember this, Tamar will one day speak, well, he'll speak to his loved ones.
Your Honor, I object. This is an insinuation about parole in some kind of way. It's improper.
All right, that'll be overruled.
We'll also walk among us one day. He will have his freedom. He will have his life. Maybe he's going to a bad place like defense counsel said, which that's what prison is. He has all those options ahead of him. He can choose to make himself better there. He can choose.
2 minutes.
Thank you, Judge. He can choose. Mark will not be able to choose any of that. He will not be able to choose to go to college. He will not be able to choose to get a degree. He will not be able to choose to use photography as a career. He will never, ever see his family ever again. They will never see him. It's a simple ask here. Is please assess a just verdict. A just verdict in this case, considering all the evidence that's been presented in front of you over the course of 2.5 weeks, is nothing less than life. Nothing less than that. Thank you very much, ladies and gentlemen.
All right, ladies and gentlemen, you've heard all of the testimony that you're going to hear in this case. Deputy Laura will take you back to the jury room, and of course, the alternates will be placed in a separate room. All right, everyone, please rise for the jurors.